Good morning, everyone, and welcome to the hearing for the Urban Growth chapter of the Selwyn District Plan. This morning we have 4 panel members in physical attendance in Selwyn and the other remaining panel members on Zoom. Sorry, I was trying to sort out a technical glitch. Is that working now? All right, so there may be a few technical glitches, including the one we just had, but we'll try and work through those as we progress. So just before we hear from our first submitter from the 42A reporting team, anything for us this morning? No? All right. Okay, well, we're first submitted this morning is Fulton Hogan. Mr. Ensel, good morning and welcome.
Good morning.
And so you know the drill. You've been before us before. You don't need to read out the pre-circulated material, but you're very welcome to highlight key points, and then we'll see if we have questions for you.
Thank you very much. Just a couple of very brief points to highlight here. Really, the first point can just be summed up that, and I'm sure the panel is sort of well aware that when looking at future rezoning through this plan change and the policies that are supporting it, we have the NPS for urban development sitting behind things, and also policy within the proposed plan, which is driving a sort of a coherent and strategic approach. And one of the further submission points that Fulton Hogan made on golf properties is really just trying to stress that departures from having a coherent strategic approach, I guess in my view, isn't consistent with what's sitting behind this plan in terms of national direction, and that it could also raise issues in the future. And one of those, which is the other main point that I'd like to make, is reverse sensitivity, which is a significant challenge for primary production activities, of which quarrying is a part. And so in my evidence, I've sort of pointed out that an avoidance approach to reverse sensitivity is much easier to, or I guess clearer for everyone to deal with, given that mitigation can come in lots of different forms with a lot of potential uncertainty around it. And so in most cases, the way to mitigate reverse sensitivity is simply to have a separation and avoid the clash in the first place. So that's all I really had in terms of the summary, and happy to take questions.
All right, thank you very much for that. And we do have a predetermined order of questioning for the panel members. So Andrew. Thank you, Mr. Ensel. I appreciate your evidence and the clear, concise. Thank you, Andrew. Lindsay?
No, I don't have anything in particular, but I just wondered, Mr. Ensel, whether you'd had the opportunity to look through some of the other legal submissions in terms of the conflict or the disparity there is in between the NPSUD and the Canterbury Regional Policy Statement in terms of direction. Did you have any comment to make on that?
I haven't read the legal submissions as you suggest in any detail, but I'm sort of aware of potential conflicts. I think probably from my perspective at this point, I probably don't have much to add. You've probably got a reasonable amount in front of you there. I guess really from a relatively limited perspective of what I've looked at these documents from in terms of Fulton Hogan's interests, it's just a matter of as best possible coming up with some resolution that the RPS obviously will need some work at some point in the future, taking into account the NPSUD. And in the meantime, sort of avoidance of ad hoc urban growth is probably what I'd suggest would be an appropriate approach to avoid tripping over any future RPS form and in the direction of the NPSUD.
Okay, thank you. Just a technical matter. I couldn't hear Commissioner Willis at all when he was speaking before, so that could be looked at or thought about.
Thanks, Lindsay. Can you hear me?
I can hear you. Yes, fine. I just couldn't hear Commissioner Willis.
Okay, we'll just maybe Andrew, just check your microphone's turned on next time. All right, Malcolm, any questions?
No questions on my part. Lindsay has covered the area that I was interested in.
Thank you. Nicole?
I'm the same, but just with Andrew with his mic, might want to speak directly into it because it wasn't very loud when he just tested it as well. Sorry, otherwise we don't know what's going on. So thanks, Lindsay, for bringing it up.
No need to apologise. I said at the start we might have a few glitches to work through. Deborah, any questions?
No, I'm fine, thank you.
Thank you. Mark?
Thank you. No further questions that have been asked.
Raymond?
No, thank you.
And Yvette? Your microphone's muted. You need to unmute your microphone. Okay, we'll assume no questions. Gary?
Yes. Can you hear me okay? Everybody hear me okay? All right.
Yep.
I just had one question. It was just to do with the policy UGP 15. The submitter requested the words be added is in accordance with and will give effect to the National Policy Statement UD. And your main concern is that that would lead to ad hoc implementation of the NPS. I just wanted to explore that a little more with you. Do you mean for any individual proposal, even if it does give effect to the NPUS, because that's what the words would say, would still be ad hoc? Just explain that a little bit more.
Yes, so in relation to an individual proposal as opposed to looking at it as a district whole. And I guess my concern is that that would become relied upon as a I guess a backdoor approach to strategic planning for urban growth.
So you believe it needs a more strategic direction rather than a reliance on another document?
I see. Yes, okay. Down at an application level, as it were.
Understand that. Thank you.
Thank you, Mr. Ensor. No further questions from me, but thanks for coming in this morning.
No problem. Thank you.
So our next submitter is Woolworths. Our next submitter is Woolworths. And just while Mr. Lecky's getting himself organised, for anyone who's watching the live stream, if information is to be tabled today, could a digital copy please be emailed to hearings@selwyn.government.nz. Thanks.
Thank you, Commissioner and panel. And apologies, I hadn't appreciated there were panel members joining remotely as my team. So I'll get that summary statement emailed round.
Great, thank you.
Just by way of introduction, my name's Josh Leckie. Obviously appeared before you already in relation to the strategic directions. And today I've got Mr. Granger from Woolworths remotely dialing in, and Ms. Panther Knight, consultant planner, also remotely joining in. My legal submissions have been pre-circulated, so I won't read them out. Paragraph 2 I've summarised what for Woolworths are the key challenges with the chapter as it currently stands. And just to orientate the panel, Ms. Panther Knight has tracked changes into the relevant provisions in her evidence, and that's attached at Appendix 1. These changes are to enable sufficient land supply for business growth through the Selwyn district. That's the how much land question. The second is where it goes, enabling sufficient flexibility for supermarket development within appropriate locations. And the third point, which is less significant for Woolworths, but I appreciate is getting a lot of focus, is the point of the MPS and regional policy statement tension. So I've noted at paragraph 3, I'm calling 2 witnesses today, Mr. Granger for Woolworths, and he'll outline and can take questions just on those functional operational needs of supermarkets and what makes them special, if you like, compared to more general retail, in particular where they need to go. And also Ms. Panther Knight, who provides the planning framework to support that. There's just expanding on those 3 themes. The first being the need to provide the land for business growth, and I've detailed that a bit further at paragraph 11 of my submissions. Woolworths, and Mr. Granger can speak to this, Woolworths have struggled to find appropriate land in Selwyn through the ODP and are concerned that restriction or that restrictive framework is flowing through to the PDP, and Ms. Panther Knight has suggested some amendments to address that. Secondly is the concern from Woolworths around the direct and control approach of the PDP. There's the approach Woolworths are seeking is what's commonly referred to as a centres plus approach. We've appeared for Woolworths around the country in relation to that, and it's now within the Auckland Unitary Plan, the Christchurch Replacement Plan, and most recently the Dunedin 2GP, where the provisions have been settled by way of consent order. So that's the second theme being where did these supermarkets go? And the third is the NPS regional policy statement tension. For Woolworths, the perspective is slightly different to the residential land developers in that the regional policy statement does provide for out of centre commercial activity. So in my submission, that reconciliation is easier in relation to the amendments that Woolworths are seeking to the district plan. And I can happy to take questions on that. But to me, it's simpler to align the MPS, the RPS, and the district plan in relation to where supermarkets go. So I've just provided a bit more detail on that in my legal submissions. So I'm conscious to not take too much time, and I'm happy to take questions now or after the witnesses. I'd propose to call Mr. Granger first and then Ms. Panther Knight.
Yeah, thank you very much for that. Just I'll see if we do have questions for you, but I've got one question first, which I'd like to put to you. The changes in Appendix 1 of the planner's evidence, I can't see them detailed in the original submission at all. So that raises in my mind an issue of scope. As you know, we're constrained to the scope of the original submission, and a deficient submission can't be backfilled by evidence at a hearing.
Yeah.
So I'd invite you to respond to that matter.
Yeah, sure. So and it's a completely reasonable question. So originally Woolworths weren't allocated to this topic, but it became clear to us when we reviewed the allocation that the concerns raised in the Woolworths submission relate directly to this urban growth framework. And in that sense, the relief that Ms. Panther Knight has proposed is just subsequent relief to give effect to the concerns raised in the Woolworths submission regarding both the availability of land for supermarket development and also where supermarket development within Selwyn can go. So to answer your question, in my view, there's clear scope. This is just consequential relief that Ms. Panther Knight has proposed to put some mechanics and some teeth to addressing those concerns.
All right, well, if you can maybe set out in writing just a brief memorandum or something, just detailing aspects of the original submission that you think give scope for us to consider the detailed amendments that are attached to the plan as evidence?
Yes.
If you could do that, and then that can be considered by our 42A team in reply, and we'll get their opinion on that as well. All right, I'll see if we have any other questions for you. Andrew.
Hopefully working this time. Paragraph 16, thank you for your legal submission. So paragraph 16, just want to confirm, in there you said Woolworths is not seeking to drive supermarket enablement outside of existing or proposed urban areas. Okay.
Yes, I can. In that sense, what Woolworths aren't seeking is to be able to put a supermarket in what's currently or proposed to be a rural zone, or somewhere outside either the urban form as it stands now or the urban form as it may become through future plan changes. What Woolworths is seeking is that as that urban growth takes place, there's sufficient flexibility for the supermarket activity to then infill as needed to respond to that residential growth. So that paragraph 16 there, I'm just attempting to emphasise that it's not that Woolworths are seeking to go out on their own with a supermarket out of sequence. It's just that the district plan and my submission needs to be agile enough that as that growth happens, there's the provision for the provision of a supermarket. Yeah.
Certainly, thank you. No, I do understand that. It's just that some in places the evidence of one of your witnesses seems to suggest tweaks to the urban growth approach and allowing zoning outside of an urban growth overlay as well, as opposed to simply facilitating and enabling Woolworths activities within an area identified for urban growth. So it's just there looks like a little bit of conflict creeping in places.
Yes, yeah, and it's something that could be refined, I think, through the provisions, because there are aspects of the it's a blunt way to describe it, but the direct and control approach of the RPS that are around where commercial and business activity can go. That Ms. Panther Knight is attempting to sort of reconcile that tension with the fact that provided the appropriate evidence and reverse sensitivity effects and all those other aspects can be dealt to, a supermarket outside a centre could still be appropriate. So that's where Ms. Panther Knight's amendments are seeking to just enable that to happen through the district plan. But I appreciate what you're saying, that the amendments have a broader implication beyond just what Woolworths are seeking.
Yeah, that's right.
Yeah.
I mean, she's proposing to delete UGP3, which is around avoid zoning outside of urban growth overlay. And so I'm just that seems to go beyond what you were saying around simply Woolworths enabling activity within the urban growth area.
Yes, yeah. For what Woolworths are seeking, I'd agree.
Okay.
Yeah.
All right, thank you.
Lindsay.
Sorry, no, I don't have any further questions. My questions are for the witnesses. Thank you.
Thank you. Malcolm?
No further questions, thank you.
Cole?
No, thanks.
Deborah?
Yes, I have one question, and it's just teasing out further on that paragraph 16. Could I have an answer to whether establishing a supermarket, which is the best zoning? Is it business zone, commercial zoning, or neighbourhood centres?
Yeah, thanks for that question, and I'll partially pass it to both of my witnesses in a sense to provide their perspective. But as a general response, the key perspective for Woolworths is to ensure that supermarkets sit within the catchments that they serve, and often that means they do need to sit outside those identified centres that you've read out. As it currently stands, in my submission, none of apart from the town centre, none of those zones particularly enable supermarkets, and there's some subsequent relief for early next year, hearings early next year, that Woolworths is seeking to remedy that. So at the moment, to answer your question, none of them from Woolworths' perspective other than the town centre does enable that. But ideally, supermarkets from Woolworths' perspective, the consenting pathway should be open to consider supermarkets in any of those zones.
Great, thank you. Mark?
Yeah, I have
I have a question. I guess it's good to ask it now because your planner may be able to ask it. You appear to be seeking a permission or a permissive plan that allows supermarkets to develop where you want, but isn't that to the detriment of a cohesive development as a whole? If supermarkets, and they really are standalone, they typically drag in a block of shops with them, can pop up where you want, as opposed to a more comprehensive development as townships grow, wouldn't that lead to commercial fragmentation with essentially unexpected larger neighbourhood centres popping up randomly through the district? And instead of having cohesive commercial zones, we just end up with a lot of little ones all through the area, which are actually less struggling for a word, less good, if you understand what I'm trying to say, than a comprehensive, larger commercial centre where people can go and stop once and do a whole lot of shopping rather than have to travel to the supermarket, then to somewhere else, to somewhere else, to somewhere else, which actually is detrimental.
There's a balance there in my submission, and unfettered, I agree that the concern you've raised could happen. But we've seen elsewhere in the country, there's ways that can be managed through district plan controls. So, for example, the ability for a supermarket to develop either through a resource consent or a plan change at the time of that plan change or that consenting should consider effects on identified centres. So the supermarket and their expert witnesses, in particular economists, it happens regularly, need to provide evidence that the establishment of a supermarket won't have an effect in a retail distribution sense on an identified centre. I think the other control that I've seen elsewhere that helps identify that issue is ensuring that the plan and potentially enabling a supermarket through a consenting process doesn't enable a de facto centre to be established, and that would involve the sort of activities that go with the supermarket. So for projects I've worked on for Woolworths, there's regularly been conditions put in place limiting the ancillary retail that goes with a supermarket, just to control that centre by stealth that you raised.
Thank you. So, in your view, does our current proposed district plan contain enough rules to restrain that development, or if we were to grant your relief, are we opening up a further can of worms because there aren't subsequent rules to restrict this?
At the moment, there aren't subsequent rules because at the moment in my submission there's just not the provision for supermarkets as the district plan stands. So if you're minded to accept the relief in the Woolworths submission, there will be a need to backfill further provisions in the particular zones that we're talking about as those provisions are finalised through the PDP process. So it's certainly not something that we should open the door on through this chapter, which is an objective and policy regime, and then leave. It's going to need some backfilling in the event that the panel is minded to accept the relief of Woolworths.
Thank you.
Thank you. Raymond?
No questions from me, thank you.
Yvette?
Kia ora. Yes, I do have one. I'd just like to check in a point of clarification, please, that the recommendation from the 32A report is to adopt and to build on the provisions that we have in this current plan. And I just wonder, do you know of these rules being tested at all in terms of what you are proposing that gives you confidence to say that they will not provide? Has there been any testing in the operative plan of these rules?
Yeah, so the Woolworths has done a lot of work with the operative plan and found the rules very restrictive in relation to the ability for supermarkets to develop out of centre. Ms. Panther Knight has considered the 32 report and also the 42A and supports the momentum of travel on the amendments proposed by the reporting officer, but doesn't consider they go far enough. So to answer your question, Woolworths has tested the operative plan on the ground and have found it very difficult to apply in relation to establishing a supermarket or an additional supermarket in Selwyn.
Okay, kia ora. So what you're confirming is that you have tested, which is confirming for you for this review that they are not working, the provisions are not working well enough for you.
Yes, that's right. And Mr. Granger has some comments on that in his evidence and can take questions as well. And just on the perspective on the ground of implementing those rules.
Kia ora, thank you.
Thank you. Gary?
No, I understand.
Yep, no legal questions for me. Thank you very much. We can proceed with the witnesses.
Thank you. So as I mentioned, my first witness is Mr. Granger, who's the Director of Format Network Development and Property at Woolworths. Mr. Granger's evidence is relatively succinct, so we haven't prepared a summary statement, but he'll present a short summary and take questions.
Yep, thank you very much. Good morning and welcome.
Thank you. Can you hear me okay?
Yep, we sure can.
Yep.
Great. Yes, my evidence is reasonably brief. I won't summarise my qualifications, and I'm assuming you're aware of Woolworths. We operate the Countdown brand of supermarkets in New Zealand, and we also are the franchisor for Fresh Choice and Super Value brands. And I think that's important also to remember that a supermarket doesn't necessarily mean a Countdown size supermarket. There are other smaller supermarkets which may wish to establish throughout the district as well. If I could perhaps turn to paragraph 10, Woolworths is currently considering several development proposals and options in the Selwyn district. However, we have been frustrated by the inability to find suitably zoned sites, and the framework of the district plan has proved challenging to establishing new supermarkets. Obviously, there's a lot of growth planned within Selwyn, and with that residential growth comes increased demand for a range of services, including obviously supermarkets. And we endeavour to try and provide supermarkets in locations that are convenient for customers. And while we often do locate in centres, often there's not adequate provision or suitably available sites within town centres, and also within growth areas there's often not the zoning of a centre there to enable a supermarket to be established, which often means in practice that supermarkets are located either adjacent to existing centres or within residential areas on major roading routes. And this is really all about providing convenience for customers. And I guess the other point there is the transport efficiency of having supermarkets located closer to customers rather than having customers from urban growth areas on the fringe of towns having to travel by car to get their groceries. I think that's probably the main points in relation to the background. Obviously, our submission is that the district plan needs to provide a more enabling framework to enable supermarkets to be established to accommodate the growth within the district.
Excellent. See if we have questions for you, Andrew.
Not a question, just thank you for setting out, I guess, some of the constraints and issues that you've identified in relation to your facilities in the district. So I appreciate that background thinking.
Thank you. Lindsay?
Thank you, Mr. Granger. You obviously work nationally and look at a number of district plans and a number of different scenarios. the Selwyn District Plan has come out of the involvement of a number of strategic documents before. It's not been done in a vacuum. There has been a reasonable amount of work in terms of where growth should go, and obviously in terms of the the higher level policy direction in place at the time. Was Woolworths actively involved in the development of the plan at all? You obviously have identified a need in Selwyn for greater supermarket offerings, and you've said that the operative plan is not enabling. You're finding it frustrating. It's just, this is what I'm hearing from you. It's there are not the development offerings to be able to available. Were you involved? Was this a voice that you had? Did you explain this to the council that you've got rapidly growing areas in Selwyn? People do expect supermarkets to be provided, which are in close proximity to demand. Is that something you've been actively involved in?
I think that's why we're here today. I think the other point is within Selwyn there's the future urban zone, and there's a number of plan changes occurring, private plan changes, and so that I guess doesn't enable the kind of coordinated approach to planning for town centres within those future urban areas. We have had experience with resource consent application, which was unsuccessful in Lincoln a year or so ago.
Okay.
I think perhaps if I could just expand on the first part of your question about experience with other, nationally around the country. Another example which we have come across is in Auckland, where we've in a centre or a new subdivision area, the south of Auckland, which didn't provide for a commercial area within it, but within the unitary plan there's some policy provisions which set out a framework for a private plan change application and certain things that would be tested against for establishing a new centre. So that framework, I think, was quite a helpful way of enabling applications to be assessed and measured against the framework set out in the plan.
And briefly, what sort of things did the Auckland plan have in it which were more enabling? Surely it was, presumably the scenario you're talking about was a large block of land, a significant number of new residential properties which needed some commercial activity associated with it, or was it on a much smaller scale where there had been an already identified need?
This was a growth area of about 800 to 1,000 houses, but the provisions that I was talking about are in the policy section of the plan, and it's essentially says here's the framework of the plan with the different centres, local, neighbourhood, etc. If you wish to apply for a plan change to establish a new centre, these are the criteria that you'd have to meet. So that was what I was referring to.
Yeah, that's helpful. No, I don't have any further questions. Thank you.
Thank you. Malcolm?
Yes, I'm interested in the expansion you're seeking. It would appear that you're looking to do your development in more greenfield areas rather than redeveloping existing brownfields. Is Woolworths interested in redeveloping existing commercially zoned brownfield, or do they see it more financially accessible for them to do it in greenfield areas?
I think there's two parts to that. One is about being located in a location that's convenient to where the people are living. So that's one driver, and I guess the other factor is whether there's actually availability of brownfield land. And sometimes it can be fragmented into very small parcels, which makes it difficult to acquire enough land to establish a supermarket.
Thank you.
Nicole?
No, I'm fine, thank you.
Deborah?
Yes, I actually have two questions leading on from the questions that have already been asked. Just with regards to the fact that we have in the outline development plans that are put in for large-scale urban development, we have the opportunity to actually put in a commercial or a business zoning, but they can always be at risk under the RMA process with regards to private plan change requests to change that zoning. Would it be ideal in our district plan to have some protection around being able to retain those zonings specifically for what you are asking for with regards to the establishment of supermarkets? That's question one.
Yes, I don't think that would hurt.
Okay. Now my next question centres around the establishment of a supermarket, but often with the request of the establishment of a supermarket, we have also having other services close by, like coffee shops, and then we have shops. So by default, where you establish a supermarket, it can actually turn into a neighbourhood centre. And it could also basically, you know, have a petrol station as well. And I'm just wondering, is that how you see the growth of the establishment of a supermarket in a particular location? And if so, would it need a specified zoning?
I think there's plenty of examples around the country where we've had standalone supermarkets consented in the residential zone without any associated other retail around them. And examples I can think of are Mosgiel, Alexandra, and Rangiora, where that has just been a standalone supermarket on its own without any other ancillary retail. And those were all consented within residential zones.
Thank you.
Thank you. Mark?
No question, thank you.
Thank you, Raymond?
No questions, thank you.
Thanks, Yvette.
No questions, thank you.
Gary?
Thank you, Mr. Granger. Just one question. In your statement, you've made it clear that supermarkets are unique or quite different from general commercial, if you like, and they have I won't go through it, but you've made the point that they're unique. Yet in the relief that's being sought, the word supermarket is not mentioned in the actual policy level. It's more to do with commercial activities. So that did you consider there might be a need for supermarkets to be somehow identified separately to general commercial? And I suppose this leads back to the other questions panel members have asked about if further flexibility is provided or more provision is made, it could be taken up by other commercial activities that don't have the same characteristics as supermarkets.
Yes, I think that could be a good solution.
Okay, thank you.
Thank you. No further questions from me.
Thanks, Matt. Thank you, Commissioners. I'll now turn to call Ms. Panther Knight. Ms. Panther Knight's prepared a summary statement, which she'll just walk at a high level through because it's relatively lengthy, and then happy to take questions.
Great, thank you very much. Well, good morning, Ms. Panther Knight. My preference is where an expert witness has gone to the trouble to prepare an additional written summary that you just read it out verbatim. Otherwise, we get confused what is the evidence and what is not the evidence. So if you're happy to do that. I don't think we've seen this information before.
Thank you very much. It is indeed a summary of my primary evidence, so there's nothing new, but I am very happy to read through it. It certainly assisted me in preparing for today, so I'll do that. But if you are comfortable, occasionally I may divert from the text just to respond to some of the questions that have already been raised today relative to the statement that I've prepared just to assist you. Yep. So, excuse me. Starting from the beginning, paragraph 1, Woolworth's submission identified that the PDP does not currently enable business activity to flexibly adapt to the anticipated growth of the district. Further, Woolworths' submission sought consideration of more aspirational provisions for growth in the PDP, utilising the strategic process of a plan review to comprehensively and sustainably plan for, enable and respond to growth. Woolworths' submission did not outline specific amendments to the urban growth chapter, as you've clarified today, sir, but the preceding summary identifies the concerns Woolworths has presented with the way in which the PDP, as notified, does not adequately respond to the district's recognised fast pace of growth. Woolworths also sought that the overly restrictive and centres-only approach to new business activity in the PDP be amended to include more enabling provisions. This is specifically in relation to supermarkets within the submission, for which Woolworths considers there is no feasibly zoned land for supermarket development to support the PDP's growth agenda for its centres. This relief is relevant to this chapter of the PDP insofar as how new business growth is enabled and accommodated. This relief, in my view, is also consistent with the approach taken through the Centres Plus approach in recent plan review processes in Christchurch, Dunedin and Auckland, and as Mr. Leckie outlined relative to business activity as has been signalled as appropriate in the Canterbury RPS. I support the relief sought by Woolworths. Further, I consider there are very limited existing opportunities where new business growth is anticipated or provided for in the urban growth overlay within this chapter of the PDP. For example, and as elaborated upon in my primary evidence, as drafted, policy UG-P15, in my interpretation, requires that new business growth can only occur on sites within the urban growth overlay and consolidated with an existing key activity centre or already live zoned. With the exception of Leaston, I don't consider there is any such opportunity presented in the PDP. So I understand the urban growth chapter is intended by Council to provide a framework for managing future urban business and residential growth opportunities in the district. I also understand the intent of the chapter is to identify the work Council has already completed in certain areas through previous planning processes, as referred to by Commissioner Dayton, specifically in respect of the Canterbury RPS as it's developed, that identify where growth can occur. In this instance, within future development areas, greenfield priority areas or sites that are or will shortly be the subject of outlined development plans. I consider this approach as useful in establishing what I would determine as the starting point for growth. In other words, these identified areas have been the subject of robust analysis to date, which has confirmed their suitability for growth and where growth is anticipated from a district-wide level. This then enables the Council to appropriately plan for servicing that growth through integration with infrastructure provision and other considerations. Following on from that starting point, in my view, the urban growth chapter should then be used as the framework against which alternative and additional future urban development opportunities are able to be assessed. And this, I think, is the crux of the questions that have arisen to date, specifically with respect to the perceived tension between the Canterbury RPS and the NPSUD. And I think, as Mr. Leckie pointed out, relative to business activity, the benefit we have in respect of the CRPS is that it does anticipate, to some extent, out of centre business activity, so long as that clear and robust analysis is implemented either at the plan change or consenting stage, depending on the zoning. However, it is my assessment that instead of presenting an enabling framework to provide guidance on suitable urban growth, the urban growth chapter, as notified, presents a narrow, direct and controlled prescription for urban growth to occur, and ostensibly only in those locations already identified by the urban growth overlay, specifically relative to the Greater Christchurch area and in respect of implementing the CRPS. In that regard, it would appear that the PDP prioritises consistency with the CRPS over the NPSUD in respect of enabling future growth. I note that the PDP must give effect to both the CRPS and the NPSUD, the latter being more recent in providing national level direction on urban development and growth matters. And I think what's important to point out relative to both Mr. Leckie's submissions and my primary evidence is that the amendments that I've proposed, I'm attempting to walk that fine line, the balance between trying to proceed with this process in respect of an RPS that, in my view, does not sufficiently implement the NPSUD for obvious reasons, given the recentness of the NPSUD. And I think specifically in respect of the way in which the NPSUD is looking for flexible and responsive consideration of urban growth, and in terms of out of sequence or unanticipated development. Those are the key amendments the NPSUD would need to have implemented in the RPS in order for it to comply. In other respects, I consider the RPS delivers a robust growth strategy for the region and obviously has been carefully considered. So I just wanted to make that point in respect of the questions raised to date. I consider the urban growth chapter as notified is in conflict with the NPSUD, and that flexible and enabling provisions must be prioritised in the PDP as a result of the introduction of the NPSUD. Therefore, I agree with Woolworth's submission that, as notified, the PDP does not yet flexibly and appropriately provide for future urban growth. Drawing on Woolworth's submission in relation to the overly restrictive planning framework established by the PDP for new supermarket developments, noting that such activity is only permitted in the town centre zone, and even then still requires resource consent for the building under Rule TCZR1. And I think this is a matter that will obviously be very relevant when we get to the commercial and mixed use zones hearings next year, but I would be happy to discuss some of the questions that have been raised already in respect of what might an appropriate zone for a supermarket be, and I'm happy to discuss that in questions. I consider amendments are required to specific provisions in the urban growth chapter to enable new business growth in and around key activity centres. This approach will ensure such development complements and does not have an inappropriate or undermining effect on the centre's hierarchy, and is an alternative to the current direct and control approach that does not enable any flexibility to consider business growth elsewhere. This is particularly the case for supermarkets that have a functional need to locate in the catchment they serve, and you heard from that point from Mr. Granger. I set out amendments in my primary evidence with respect to the urban growth chapter, and again I reiterate that I consider those amendments will give effect to policy 6364 of the CRPS, which enables new commercial activities to be located out of centre where they will not give rise to significant adverse distributional or urban form effects. Further, the amendments, in my view, are necessary to ensure the PDP is consistent with and delivers on the objective of the NPSUD. Absent those changes, I consider the urban growth chapter is not the most appropriate method to achieve the purpose of the Act, and specifically does not align with the NPSUD as the overarching policy direction for establishing well-functioning urban environments in the Selwyn district. I'm happy to take questions.
Thank you very much for that. And to the rest of the panel members, that was read out reasonably quickly, but you don't have it before you, so I thought it was useful to have it read out, but we will make sure that you get emailed copies of the document just as soon as we can. Now, just see if we have any questions. Andrew.
Yes, thank you for your evidence, Ms. Knight. So paragraph 26, and you've covered this in your summary as well, but I just want to seek some clarity because you've challenged the proposed restrictive approach to additional urban zoning, as I understand it, and suggested some amendments. And so just for clarity, is Woolworth proposing supermarkets outside of the urban growth overlay? Because in the legal submission, and Mr. Leakey confirms that you're not seeking to drive supermarket enablement outside of proposed urban areas. So I'm just trying to get clear in my mind, there's a question around the enablement of supermarkets within existing urban areas, but you're also querying here in your evidence, as opposed to the legal submission, around having future urban supermarkets in future urban areas outside of the urban growth boundary as well. Is that correct?
So thank you for the question. The evidence, and another question was raised in respect of whether or not we could have further refined the relief specifically to supermarkets in the urban growth chapter. And in my view, that wasn't appropriate because the urban growth chapter is part of your overarching policy directive, and it is talking about the way in which residential and business growth together are working relative to that urban growth and urban form. So no, my evidence is not supportive of supermarkets outside the urban growth overlay. What I'm seeking to amend is the way in which urban growth can occur, the way in which additional urban growth opportunities can be identified and incorporated into the plan via plan changes or similar, and to address that relative to achieving consistency with the NPS.
Okay. So and again in that same paragraph, you've referenced you've referenced some CRPS policies in your assessment and your evidence.
Mm-hmm.
And I'm just wondering if you've looked at the different approaches in the RPS in Chapter 6 versus Chapter 5, which I think has driven, I guess, the difference in approach between PG3 and PG4. And if you have a comment on that.
Yes, thank you. Yes, I have looked at the difference, and yes, I understand the reason for the differentiation between within Greater Christchurch and without in respect to the Selwyn district. That's, I think, where the tension arises with respect to the NPSUD, and Selwyn needs to be looking at its growth as a district-wide matter. The urban growth overlay and the way in which it's consistent with the RPS, as I say, is that primary starting point for saying this is the urban growth, this is this is where we expect it will occur. But beyond that, there needs to be that flexible, responsive approach to considering other opportunities in the future. And in my view, in respect of the changes to P3 and P4 in particular, was to essentially create a level playing field within and beyond the Greater Christchurch area, to say that those are the established urban growth areas. Beyond that, let's consider via what I guess would fall out from subsequent amendments to the RPS relative to policy 3.8 of the NPSUD, an enabling consideration of out of sequence or unanticipated growth opportunities.
Yeah, sure, thank you. And again, just a point of clarification. So paragraph, my favourite paragraph, 26,
Yes.
clause C this time.
Yes. Yes.
You've referenced urban growth policy P15.
Yes.
And you identify there that as drafted, this policy requires new business growth can only occur in sites within urban growth overlay and consolidated within the key activity centre. And with the exception of least, there's no such opportunity. So, I mean, as I read P15, it's an or, not an and. But I mean, it appears to provide an approach for new areas within new for greenfield development or brownfield development. I think that's, as I see it, what the policy is saying. So it's an or, not an and. Can just clarify what you mean by that?
Thank you. Yes. So my interpretation was that those requirements were required to all be satisfied. So if there was an or, then that gives an opportunity for that flexibility. But my reading of it was that you needed to achieve these matters, these components of P15, which obviously is lengthy, and that's where the concern arose in respect of what actual opportunities were available to achieve that policy.
So, I mean, if you've got, I'm not sure if you've got policy 15 up in front of you now.
I do.
Do you see that it says an or between A and B rather than and? And does that change any of your conclusions in around your recommended amendments to the chapter?
Oh, so subclause 5.
No. UGP 15 clause 2A and B.
2. Got it.
Not conjunctive, they're disjunctive, which is the point my colleague is making.
Right. Right. So my interpretation had been that if we deleted subclause 2 altogether, it removed any unnecessary restriction and enabled the remainder of the subclauses to achieve the intent of the chapter consistent with the NPSUD. But if the preference was to retain those and to focus on the disjunctive component, as you say, then that does enable further flexibility than otherwise anticipated.
Okay, thank you. Thank you. So I guess we'll hear this. I guess we'll hear more evidence from. So I'm assuming you're providing evidence in relation to the actual zone provisions as well.
Correct.
Like local centre zone, etc. I think maybe I'll hold that question till then. And I guess just sort of a general question. In your experience, do you think supermarkets give rise to significant adverse distributional effects?
No, in my experience, they don't. And this is a matter that I've considered over a number of years. The first in respect of a plan review was the Hamilton City Plan. It's now operative, but in its process, in its review process, this was of critical concern given the vitality of Hamilton City Centre at the time, and there was robust analysis at that point and a lot of critical thinking in respect of the way in which retail distributional effects could be considered on a case-by-case basis. And some of those criteria are still relevant and have been successful in respect of additional out-of-centre supermarket development in that district without adverse effects on the city centre there. And that example has been through to many others, including Auckland and the other districts that I mentioned in evidence in respect of enabling supermarket development has quite a different character relative to other centre activities.
Okay, so that's in relation to a standalone supermarket. What if the supermarket was bundled with a number of other retail activities? Do you have a different view then around presenting or creating distribution effects on centres?
Yes, I think as soon as there's consideration given to what could essentially be called a quasi-centre, or in fact a centre of its own right, there needs to be consideration given to the way in which that proposal either supports or undermines any other centre's hierarchy. And so it does become a different beast in my view.
Okay, hence the question earlier and the response around potentially tailoring it or limiting this to supermarkets or something else might be a more prudent approach or acceptable approach.
So my view is that amendments to the urban growth chapter need to remain necessarily broad to cover analysis of business and residential growth in a not generic but in a higher level sense. Where I think it's appropriate to separate and provide distinctive provisions is in the centres and mixed use zones and the other zone chapters, but it needs to hang off something. And I think it's probably worthwhile stating that my view is the strategic directions chapter didn't require amendment in respect of achieving either of these urban growth amendments or in fact the amendments that I propose for the centres and mixed use zones down the track. I think they are actually quite consistent and are obviously hanging one off the other.
Okay, all right, thank you.
Lindsay.
Thank you for your evidence. Obviously, this is a topic which is, I guess, drawn quite a bit of attention to the NPSUD and whether that is a game changer in terms of the way in which urban development generally is to be considered. Just going back to some of my questions to Mr. Granger about the extent of work that's been done in Selwyn before, in terms of identifying urban growth overlays and also looking at things like the activity centre network. So if you're looking at a supermarket, but in particular, you would probably have an easier ride in terms of doing it if it is actually recognised and provided for by the district plan. Would the NPSUD mean that, and the provisions of that mean that things would be easier, that there is a more friendly policy framework for providing for urban development generally outside of those areas which are identified in the plans?
So my view is that the Centres Plus approach is consistent with the NPSUD and it would more flexibly enable supermarket development. I do not consider that the Selwyn PDP currently sets up that framework.
And can you just clearly outline what would need to be done to it as opposed to tinkering with various policies? Does it need to be much more directive, saying we welcome these things happening in general terms, subject to various other matters, obviously?
So no, my consideration is that it comes down to the activity status and the associated assessment criteria where consent is required in the various zones. And so a question was put to Mr. Granger earlier about what might an appropriate zone be for a supermarket. Obviously, I think centres are your first port of call and the centres hierarchy is relevant in that respect. But what Mr. Granger has pointed out as well is that in addition to being able to locate within the centres, there needs to be flexibility where they might also be able to locate close to the catchments they serve. And that's particularly relevant in Selwyn, where we do have a number of urban development areas or growth areas to come forward that at the moment are solely or largely residential in nature, and with the expectation that those new catchments are going to only be serviced by, say, the town centre or otherwise. And so the intent is to work within the framework, but to enable supermarkets as largely permitted activities within the centre zones, leaving aside the fact that you might require resource consent for buildings in a lot of centres. A lot of district plans are doing that. That addresses the matter of urban design and the way in which a supermarket, which is often large format, can work within the urban form and character that's anticipated for the centre. So it doesn't separate from that. But one of the other questions you put to Mr. Granger previously was how are supermarkets enabled in other locations? And the way in which Hamilton and the unitary plan in Auckland, for example, do deliver on that is by recognising the operational and functional requirements of supermarkets, even when you're considering urban design criteria. So it would be those components, activity status in the centres, actually enable them. At the moment, they're not. They're permitted in the town centre zone, but you need a resource consent for anything over quite a limited gross floor area, as well as consent for the buildings, as well as any consents that are required for standard infringements. And then the recommendation that I've made to all this is that you'd be seeking, relative to the Centres Plus focus, you'd be looking for slightly more enabling activity statuses for, say, large format, potentially even general industrial or light industrial. So in those zones, you would be restricted discretionary, and you would be considering those criteria relative to retail distribution effects on centres in particular. Beyond that, the recommendation I've made is that while Rangiora East and other examples have occurred in residential zones, they should be subject to a resource consent process that is robust and obviously considers those effects on a case-by-case basis.
Okay, so town centres, okay, it's all, I think that's pretty much understood. It's appropriate. Outside of town centres, it may be appropriate if it's in the urban growth overlay, subject to the usual sorts of things that you look at in terms of traffic generation and vitality of existing town centres and those sorts of things. But then you're also looking for an opportunity to actually say, well, if you can't meet the first two, then you need to be able to make your case that a supermarket is appropriate. Do you think that in terms of making that particular case that there needs to be strengthening of provisions relating to analysis of alternatives, whether alternatives have been exhausted, are inappropriate for whatever reason, such as existing land supply, land fragmentation, those sorts of things that you consider in an alternatives assessment, to say, well, you can't locate in A, you can't locate in B, we have to go to C, and therefore C it may be an appropriate location for commercial activities or a supermarket in particular.
So I would say relative to perhaps the industrial zone where you're looking to where a supermarket might be looking to locate, it would be worthwhile considering alternatives and I think maybe more importantly considering the land supply argument relative to industrial use, because in many districts, and Selwyn included, there needs to be consideration given to supply and demand of that activity. Elsewhere, in terms of alternatives, I think it's important to consider the effects of those proposals in each circumstance. And what I would say relative to this chapter is that we have the opportunity to enable additional urban growth to get the zoning right, so that there is greater availability of appropriately zoned land within an appropriate framework for the district in terms of its strategic directions, so as to avoid an argument about inappropriate development or out of zone development.
Okay, I'm not too sure whether I completely understood your argument. So you'll be looking at these potential activities outside of town centres or outside of the urban growth area. Would you consider that a restricted discretionary activity, or would you be looking at full discretionary activity? I know we're potentially looking at something which is going to be looked at in later chapters as well, but in terms of being able to look at the whole big picture.
So to clarify, I don't think Woolworths is looking for, and I'm not supporting, supermarkets outside the urban growth overlay or outside urban growth areas. What Woolworths is looking for is the Centres Plus approach, so that it would I'd say almost invariably be an urban zone rather than a rural zone, because that is where they will locate relative to the catchment that they serve. But then in terms of activity status, what I'd set out previously, well, perhaps not in this evidence. So what was set out in the submission was a suggestion that supermarkets would be permitted in the centre zones. There might be a need for consideration of a gross floor area cap for a permitted activity status in, say, the neighbourhood centre zone, because it is of a smaller scale. And that's where Mr. Granger identified you might not have a countdown, you might have a fresh choice, you might have a super value. Then I think the suggestion in the submission, and we'll be giving further consideration to this as we work through into the next hearing topic, the suggestion was restricted discretionary in the large format zone and likewise in the industrial zone, and then or potentially discretionary in the industrial zone depending if it's light or general, and then non-complying would be largely acceptable in the residential zone, recognising the intent of that zone and being able to make a case as has been appropriate elsewhere.
Okay. You're suggesting the removal of UGP3. Obviously, UGP3 and UGP4 are set up to provide the distinction between those areas within Greater Christchurch and those areas which are outside of Greater Christchurch. Do you not think there needs to be a distinction between the two in terms of areas which have been identified as being the higher growth areas and with those which are of lesser growth going forward, in terms of the way that you would consider urban growth generally, considering it's a general policy relating to urban growth?
My view is that the distinction is not consistent with the NPSUD. It's clearly a well-established growth strategy that's been set up in the RPS. And I think, as stated in my evidence, that obviously is a clear starting point and there's clear, robust analysis for that. And I'm not suggesting that that's undermined in any way. But my consideration is that now that the NPSUD is established a more responsive and flexible approach to growth, that ought to be adopted across the district, or we end up in a perverse situation where growth may in fact be easily enabled as an unanticipated or out of sequence opportunity outside Greater Christchurch than within.
Yeah, okay. I sort of understand what you're saying there. However, the NPSUD is set up a framework for providing for unanticipated development, but surely there needs to be a lot more finer grained detail about where that should go in terms of the appropriateness test of whether an unanticipated or development might occur. And doesn't the RPS, particularly the relevant recency of Plan Change 1, if you look, and thinking about what Plan Change 1 chooses to do, doesn't that put a chock under the wheel at that particular point in time, as that is the preferred area for urban growth?
I understand.
Sure, you make your case on something which is outside.
I understand, and yes, I think that you're absolutely right. There is a cascade. It's not that you can overlook the RPS to jump up to the NPS, irrespective of the way in which these have been altered. I think one of my key concerns with respect to P3 in particular was the very stringent wording and the use of the word avoid. Correct. And so if that was altered and there was a retention of the difference between growth in Greater Christchurch and outside, but the consideration with respect to the way in which you consider out of sequence development via the NPS and indeed through the RPS when it's amended to introduce those criteria as required, then P3, P4 as a distinct separation, given the recency, as you say, of Plan Change 1, remains supportable. But the key concern is the avoid, the manage. There needs to be consideration given to that, in my view.
Yeah, but also there would need to be greater level of direction about avoiding those perverse outcomes which you talked about before.
Agreed. Yes.
In terms of potentially ad hoc development, those which aren't well connected, those sorts of things. And I'm not suggesting Woolworths wouldn't be looking at those things anyway, or potentially needing to justify those through a consent process, but I guess the key point, and it's clear all the way through this hearing, is the inherent tension between what the NPSUD, what that says, what it actually means in the real context, and what existing strategic planning processes actually, whether they need to be changed or amended as a result.
I agree.
Okay. Thank you, Chair. No further questions.
Thank you. There was a very wide-ranging discussion of issues. We'll see if we have any further questions. Malcolm.
Yeah, thank you, previous questioners on your lines. Very interesting. I just want to investigate a little bit further your comments on adverse effects caused by supermarkets. Did I hear you right in saying that you didn't think that you had evidence to support that supermarkets backed up to residential areas caused adverse effects? Is that what I heard you say, or was that not quite correct?
What we were discussing previously was specific to retail distribution effects. So my view was that supermarkets on their own can comfortably assess retail distribution in terms of effects on centres or elsewhere. The discussion around effects on residential amenity and boundary interface issues are absolutely prevalent and required to be assessed in nearly every supermarket consenting process that I've been involved in and elsewhere. So no, I do consider those adverse effects need to be assessed. They can comfortably be addressed, but it's certainly not something to be overlooked.
Thank you very much. Thank you. That's all I have. Thank you, Chair.
Thank you very much. Nicole?
No questions, thanks.
Thanks. Deborah?
Thank you. Yes, I do have a question. And I guess it's around the issue where a developer will put a covenants on the sale of a property in a specific location, which actually may negate the opportunity for amenity values to actually be assessed in the planning process. How would you actually deal with the covenants issue where there are no complaints covenants is actually put on those that purchase land for development in greenfield or brownfield, given the pressure with growth and so on?
Thank you. So my experience with no complaints covenants and the RMA process in respect of adverse effects on potentially adversely affected parties are quite distinct. For example, a recent project had a significant height boundary infringement on a neighbouring property that was subject to a no complaints covenant. And my advice to the applicant at the time was that that doesn't negate the requirement to assess the effects. Council is still able to engage with those parties, consider them adversely affected, and carry through the process of either limited or public notification. The extent to which those parties are then able to engage in the process relative to that no complaints covenant is a separate matter. And so thinking about that in respect of provision or covenants or similar on supermarket properties, the same would apply. The RMA process would require robust analysis of effects. And so my assessment of environmental effects on any such project wouldn't be able to overlook those and would need to assess them appropriately. But as I say, the process beyond that becomes a civil matter.
Chair, is it okay if I jump in there as well? And there's a legal overlay to that question, and that in my experience, the panel can take a lot of comfort from quite a lot settled Environment Court authority around the fact that no complaints covenants can't be used to essentially mean effects are disregarded on neighbours. There's been litigation in Jack's Point down in Queenstown around this, and they're essentially decision makers still would need to consider those effects, and they're not a magic bullet to solving problems. That would be my legal response to that question. The effects are still need to be mitigated.
Yep, thank you for that. Mark?
Thank you. I just need in my mind to tease out the change you've asked for policy 17 to in terms of what means in and around a key activity centre. The regional policy statement defines Ralston and Lincoln as key activity centres. The proposed district plan gets a bit more specific and says the existing and proposed commercial centres. and you're wanting in and around rather than just in, how far does around go? Yeah, different from near, neighbouring. You know, if I heard correctly, you're essentially saying around means any within the urban overlay for that township. So it's a very permissive around rather than a near the existing township. It can be anywhere within the urban overlay for that town. Is that what you mean by in and around? It just seems very permissive.
Yes, I agree. It seems permissive. And so bearing in mind that my interpretation of policy 17 is with respect to urban intensification redevelopment, in that regard, and thinking about the flexibility for which we're trying to enable growth, so long as we're talking about the urban area, and that extends beyond the centre zones, as we've discussed, because the proposal we're looking at is a centres plus approach to business activity. It would be exactly as you say, the urban area around the centre where intensification or redevelopment might occur. Leaving aside, of course, that would be subject to a resource consent process if it was in fact not a centres zone. Even then, there would be a resource consent process more than likely.
Thank you. I'm still sort of struggling with sort of the approach, because while Woolworths failed in its resource consent for Lincoln, there have been other resource consents and successful for the establishment of supermarkets within Selwyn. And I'm just wondering whether, if the proposed district plan was not changed as per your amendments, whether you thought that a supermarket provider would still be able to raise a resource consent or a plan change to enable a new centre for their operation within the urban growth overlay.
Yes, it's still feasible, but I think the current objectives and policies will make that process very difficult, as has been borne out by Lincoln, albeit accepting that was under the operative provisions.
Thank you.
Raymond?
No, thanks.
Yvette?
No, thank you.
Thank you. Yeah, just in relation to the Centres Plus approach, I think we were asked to place some weight possibly on some considerable uptake by other councils as to that approach. I was interested to hear about Dunedin because I was a member of the district plan review panel there. So I'm just wondering, just very, very quickly for my own edification, how far did the council go in that consent order in adopting what you call the Centres Plus approach? Is there an easy answer? Were you involved in that?
I wasn't. I'd like to defer to Mr. Leckie, who was in fact very involved in the consent order.
Yeah, I don't want a lot of detail. I just was interested to know whether the actual Centres Plus approach was adopted by council.
You know, I was hoping I might get a chance to respond to that, listening to the questions. So the where the consent order got to in Dunedin was a two-step plan change, then resource consent process for the sorts of activities we're talking about here. We presented a similar argument to Dunedin, where the 2GP is one of the most direct plans in New Zealand, in my experiences, about activities going where they're meant to go and not elsewhere. So where the parties, and there were a mixture of retailers and council, got to was a future plan change policy. And what it did a few things. It didn't define supermarkets. We attempted to, but it gets very difficult. Sometimes no one wants to be a supermarket, and then another scenario, everyone wants to be a supermarket. So instead, we define the activity by an activity that serves the immediate catchment in which it's located. That was a way to differentiate supermarkets from big box retail. I'm not sure who's at the back of the room, so I shouldn't give examples, but perhaps Rebel Sport or Bunnings. So that was how that was dealt with. And then it was a policy regime that said, if you can come to council with a plan change that demonstrates there's a new market that is in need of a supermarket, and establishing the supermarket or the activity of a supermarket won't affect the centre's hierarchy, then that will be a positive enablement to granting of the plan change.
I think the key thing I took from that is it sets up a framework for future plan changes.
That's right. It's a future plan change policy.
Right.
So it adds another step rather than just a resource consenting process. Yeah.
Thank you. Anything else, Gary? No. I just got one question for you, Ms. Pant, tonight. Your recommended amendments, and other commissioners have touched on this, is to delete policy UGP3, which I might colloquially call a nuclear option. Have you and would potentially make us therefore inconsistent with the statutory obligation to give effect to the RPS, which we can't duck. Have you considered the option of, instead of deleting UGP3, adding a rider to it along the lines of, and these are just words off the top of my head, they would just have words tacked on the end of it that would say something like, unless it is consistent with criteria in the Canterbury RPS for determining when plan changes will be treated as adding significantly to development capacity. So it's rolling into there the words that are actually in the NPSUD, albeit the RPS hasn't developed those criteria yet, but it's providing a gateway to be open to potentially in the future, should those criteria be developed and are able to be met by a proposal.
So policy preparation on the fly is always exciting, and relative to my nuclear option, yes, there's definitely merit in that approach. I think where I'm still uncomfortable with P3 is the use of the word avoid, and it comes down to many another circumstance where terminology like that, post King Salmon and beyond, has caused considerable difficulty in respect of consenting hanging off that down the line. So that would certainly be an improvement on P3. And if there was consideration given to the discussion I had with Commissioner Daish earlier in respect of the way in which P3 and P4 differ between avoid and manage, then it would go a very long way to further balancing the tension between the RPS and the NPSUD in that respect.
Yes, I'm not sure if you've been watching any of the earlier hearings, but I have a personal aversion to the word manage because it doesn't really mean anything, doesn't give any direction to a decision maker. But
I appreciate that, and I think something other than manage could be established.
Sorry, I haven't finished the question yet. So that's why I had suggested, instead of deleting the word avoid as you had recommended, just putting an unless at the end, of course, which then needs to be taken into account by the decision maker. It's avoid unless certain things happen.
And that is an approach taken in Kapiti, which we're testing at the moment. So I'm waiting to see the council's approach to that there. The economic experts have been comfortable with that approach, but consideration of how in which how the council will interpret the framework in that respect will be borne out shortly, I guess.
All right, thank you. No further questions from me. Mr. Lecky, anything else?
Thank you, Chair. No, no further points from me, so thank you for your time.
Thank you very much for that. Right, our next submitter is Transpower. Morning, welcome. You've appeared before us before, so you know the drill, so over to you.
Hi, my name's Trudy Burney. I'm a senior environmental planner for Transpower. I'm sitting in here to observe and to support our expert witness. So I'll now pass you over to Ainsley.
Thank you.
Good morning. I'm Ainsley McLeod. You have seen me here twice before, I believe. I have a relatively brief statement of evidence that I understand you will have read.
Yes.
And I also have just provided you with a few pages of notes. Apologies to those on the end of the Zoom meeting. I'll email those as soon as we're finished today.
Yep. Thank you.
My evidence is confined to two matters, and one is policy UGP 11, and the other is the location of the urban growth overlay at Hoskins Road, where it intersects with the national grid. I'm happy to take questions on both those matters, and only really want to comment briefly on policy UGP 11 on the basis that the hearings panel had questions in respect of that policy to the Section 42A officer, and the officer agreed that to the addition of the word significant in that policy. Now, I don't agree with that, and the material I've provided you today is a list of the policies that relate both to the national grid, important infrastructure and significant infrastructure that have guided me in supporting the 42A's initial recommendation on that policy, as opposed to the revised recommendation with the inclusion of the word significant. Now, the last page of that material provided you today, I've presented 3 options that can resolve that. The first is option 1, which is reverting to the initial 42A recommendation. The second is also something that was picked up by Mr. Phillips in his planning evidence, where there are 2 approaches to the 2 subclauses in respect of adverse effects. One's and avoid significant adverse effects, and the others avoid all adverse effects, where that relates to important infrastructure, land transport infrastructure, and the strategic transport network. And the third retains the significant in relation to clauses 1 and 2, but then adds a national grid specific clause 3. And that option 3 is more similar to, I think, Mr. Bonis and some other planning witnesses that have sought to expand clause 2 to also relate to maintenance and upgrade activities of important and significant infrastructure.
Thank you. So just for the benefit of the other panel members who don't have this material in front of them, so is it your key concern then that you've brought before us today is recommended changes to policy UGP 11 by the reporting officer, which is to add the word significant into the chapeau of that rule? Is that correct?
That's right. I supported the initial recommendation, but I don't support the inclusion of the word significant, because I believe that the higher order policy direction, the guiding direction, including other provisions in the proposed district plan, don't have that qualifier of only significant effects.
Okay. All right, let's see if we have questions for you. Andrew.
Thank you for your evidence. I guess I have only got one question really, and it comes up in relation to paragraphs of 30, 31, where you talk about the Hoskins Road area that's which has the transport facilities on it, a network on it. And you talk about how you think it's, I guess, inefficient to wait for the plan change to confirm that there's a corridor there and therefore to exclude that, than simply doing it now. And I'm just interested in your views. If you follow that line of reasoning, then should we also exclude something with natural hazards, or something which has got high natural character, or somewhere that's contaminated? I mean, where is the sort of the level of, or burden of proof, or level of evidence that required for councils to consider up front versus something that they do later? Just interested in your thoughts on that.
Yes, and I've given it some thought, and to some extent I was guided by the rationale that the 42A report says, oh, it wasn't in the structure plan, and so therefore obviously the national grid either wasn't there or doesn't need to be thought about. Perhaps the solution I've proposed, which is quite a blunt planning tool, just don't show it in the overlay. There are other options that could present an indicative, the national grid's here, you need to think about this. It's a qualifying matter under the NPSUD, and will have an impact on the extent to which urban growth can be achieved in that area. My view, it's more efficient and effective to do that up front and not establish unreasonable expectations of growth that might be able to be achieved.
Yeah, and you make the point, at least I'm interested in where you draw the line. There are other considerations that do for other matters that are also relevant.
Yes, and I do take your point on that. In this case, the national grid is there. There's no need to gather any further information to know that it's there, to know there are development constraints, whereas perhaps if there was a need to contemplate or undertake further studies as part of a plan change to determine the extent of natural character, the extent of risk of natural hazards, that might differ and might distinguish the two or three matters.
Yep, thank you. Thank you. No further questions.
Thank you, Lindsay.
Yeah, didn't hear the first question from Commissioner Willis, but we'll proceed. I heard the answer, so I think I got that. Just one pretty smallish question. You talk in your paragraph 33 about potentially some of the activities in the yard being non-compliant. Transpower's got access to designations. Is this site not designated? I had a look on the plan. It appears it's not.
No, it's not. And the majority of existing transmission lines are not designated.
But the yards are often designated. Is that true?
No, they're typically not designated.
Okay. All right. Thank you.
Thank you. Malcolm?
No questions. Thank you, Mr. Chair.
Thank you. Nicole?
No questions, thanks.
Thank you. Deborah?
No questions.
Excellent. Mark?
Thank you. Yeah, I do have some questions, and it is around the Hoskin Road portion of the urban growth overlay. Because it just seemed to me to be odd to be trying to remove a piece of that urban growth overlay, which in the context you'd reasonably expect in the future to be a business zone, and there's already business zones there. It could be used for warehousing, retail warehousing type operations, given its Hoskins Road frontage, and that it would end up, if it's removed, with a perverse piece of rural potentially left in amongst what is otherwise a business zoning. So is it good practice to have this exclusion at this time? And similarly, well, I guess with that, is the National Yard, that corridor, insufficient? You seem to be arguing that you have the National Yard is the corridor along which the transmission lines are laid out, and that you seem to be arguing that that's insufficient. You've got to exclude this other area. It's about 5 hectares in area, if I'm measuring it correctly on the map, that your National Yard is insufficient for that protection, so you've got to exclude this other area, which could have activities that are compatible with your transmission lines. And then my final question is, would you want a similar treatment for any other area within Selwyn where the transmission lines transect a zone so that you could exclude just a small piece of it? It just seemed to be very odd that you've picked on this one specific piece of future zoning to exclude it. And I, like the other commissioners, would probably agree that at the future plan change, when this is to be implemented, would be the time to test this rather than a broad brush approach now.
Yes, perhaps shall I start with this first part is at paragraph 38 of my evidence, I suggest that the only area that ought to be excluded from an indication of future urban growth is the National Grid Yard, which is an area measured from the central line of the National Grid, no further than that. So only that area within which you could expect things like warehousing and that kind of activity that you refer to not being undertaken and not being anticipated. And that's the scheme of the rules in the proposed district plan. It's also consistent with NZECP 34, which is the restriction for building near or close approaches to transmission lines. So my suggestion is that the overlay should include some indication that urban growth ought not be anticipated in that narrow corridor area.
Thank you. But then you go on to say that whole triangle, it seemed to be that the whole triangle to that northern corner be excluded. Am I reading it wrong?
Yeah, Transpower's submission suggested take everything out of that triangle. And my evidence says perhaps that's more than needs to be taken out. That is just the area that is the National Grid yard.
Okay. Thank you. That's the clarification I was thinking.
Good.
Raymond?
No, thank you.
Yvette?
No, thank you.
And Gary?
Yes, paragraph 39, policy UGP 11. You've suggested some changes there around changing the focus from reverse sensitivity effects to broaden it to include all adverse effects, including reverse sensitivity. And in your paragraph 41, you say that the officer has supported that because it broadens the effects. I can understand what you're saying there in relation to Transpower, the National Grid. There's a need to give effect to the MPSET. But I'm just interested in your comment on the first clause, 39.1. So it's to avoid adverse effects on any adjoining rural, industrial, inland port or knowledge zone. In other words, it's not just the National Grid, it's a whole range of rural activities, industrial activities. I just wondered whether you thought that becomes quite onerous, because the word avoid, it would be avoiding adverse effects on all of those things, not just the grid. And that changes it from a sort of resource consent type approach to you cannot have effects on all of those activities. Do you think there's a danger that it's gone a little far there?
Yes, I appreciate what you're saying. And
Yeah.
I also am aware that there's evidence before you that says exactly that. And that's why in this attachment where I've got option 2 and option 3, they perhaps provide that more nuanced approach that picks up those matters that where avoidance is required versus those matters where you might want to manage the effects in a different way.
And did you favour, I might not have picked this up, but did you favour any particular option over another in those 3 options?
I probably would favour option 3 on the basis that it picks up the concept of operation, maintenance and upgrade, which is more consistent and probably better gives effect to the MPSET as it relates to the National Grid.
It's certainly from Trustpower's perspective. Yeah, okay. All right, okay,
Yes.
Thank you. I'll have another look at that. Thank you.
No, thank you very much for that. Just to the 42A, no questions for you. Thank you very much for coming in though. To the 42A team, when you respond to this issue, can you please make sure your advice is consistent with advice that we've received in the Energy and Infrastructure chapter hearing relating to exclusions from the National Grid yard? And just for the other panel members who aren't on that panel, we received a lot of evidence and there was a lot of discussion about that in that hearing. And also to the 42A team, I forgot to ask you something earlier on in relation to another submitter, and it relates to policy UGP 15. And just upon rereading that in response to the submission, the submitter drawing our attention to it, it's unclear in my mind how clause 2A is intended to work. Is the whole clause meant to be subject only to an industrial activity, or is the industrial activity notation at the end of that clause meant to only apply to subsequent urban growth areas or urban catchment boundaries? The clause has a lot of commas in it, and it's not clear to me how it's supposed to work. So if you could address that in reply, and if there's a means of clarifying it, I'd appreciate that. Thank you very much. So now we're going to adjourn. We're running only a little bit late, only 5 minutes late, which is pretty good. So we'll adjourn now for 15 minutes and we'll reconvene the hearing just after 10 minutes to 11. Thank you. Right, good morning. We'll resume the hearing, and at this stage we're hearing from Foodstuffs. Good morning, welcome.
Good morning. Tēnā koutou katoa. Nā te mihi kei te mana whenua. Ko Alex Booker tōku ingoa. So I'm here with Foodstuffs, and we've obviously appeared before you in the Strategic Directions chapter, and we've also heard you cover quite comprehensively matters with Woolworths. So we'll aim to keep it quite short. With me in the back of the room, I've got Miss Rebecca Parrish, who has provided evidence before, and we haven't sought to recall that evidence, but rather you're already aware of it. So in terms of, are you happy, Chair, if I just highlight a few?
Absolutely, yeah, go ahead, highlight key points, thank you.
So the essence of Foodstuffs submissions on the proposed district plan, and I'll just recap very high level, is they see them as being essential services, supermarkets. They've got particular operational and functional needs, as well as locational constraints. They can be dictated by the market, but also where they locate. They're often located within the catchment, the residential catchment. So the proposed district plan, there's been no provision made for additional supermarkets within the town centre zone or the other zones, commercial, mixed use, non-commercial. And in our submission, the lack of identification coupled with restrictive urban growth policies will lead to prohibitions or otherwise very uncertain and difficult consenting pathways for new supermarkets in the future, which may be critical to respond to the population growth and changes which we see occurring in Selwyn already. Now, when we drafted these submissions some time ago, we had quite a broad ranging submission, and Foodstuffs hadn't secured a site for their pack and save. We have now done that, and it is within the township boundaries and within the urban growth overlay. So they don't seek to advance their discussions outside of those overlays. So while these submissions did include changes, to example, was it UGO3? Sorry, UGP3, we're no longer going to advance changes. It's not necessary for what Foodstuffs trying to achieve. So just say there, in terms of the future growth, this chapter, obviously we're, in terms of a future resource consent application, you're going to be required to demonstrate how you can achieve these, and therefore it's appropriate in our submission to make some changes which would ensure that there's some flexibility in approach for consideration of site-specific constraints for supermarkets. In terms of, I'm thinking instead of talking more generally, because I think we've, to use the word, thrashed out the issues on supermarkets, I'd like to just talk to a couple of the provisions in the chapter. So in the appendix to the legal submissions, we have got some tracked changes. If I refer you to the urban growth objective 3, and you'll see that we've sought changes in subparagraph 3. Now, we're seeking flexibility to acknowledge that supermarkets can locate outside centres and co-locate within district residential catchments that they serve without any inappropriate adverse effects on the district activity centre network. And as you've been discussing with my friend, Mr. Leakey, this reality does exist up and down the country and has been acknowledged to add another plan change in the mix recently in the Ashburton District Plan Change 4. And we'll be presenting more information about that in subsequent chapters where we present. So the changes there. In terms of the policy 3, we're no longer advancing a position on that. Moving to the urban growth policy 15. This relates to business growth and new areas to support commercial activities. Such new activities are limited to where development capacity is assessed through council-owned documents and where the land is subject to an urban growth overlay and is either in a greenfield priority area where it's an industrial activity. And Chair, you were just asking that question, but my reading of that was it did appear just to relate to industrial activities. So if that's a different interpretation provided by council, our position may change on that particular aspect. And the second one is in terms of consolidated within a key activity centre or an existing general industrial zone. So as noted in our original submission, there's just no area within the identified urban growth overlay in Rolleston that we would be able to give effect to that for a supermarket. So there's no new areas within those ones identified in that policy. that would support commercial activities. Supermarkets are only provided for in the town centre zone, and any departure from this to accommodate an appropriately located new store will be subject to a very restrictive policy framework. So we've sought some changes in terms of opening the door there to also, if you are a business activity capable of minimising significant adverse effects and managing other adverse effects on business growth. And you'll also see we've sought some changes in relation to taking out that it needs to be identified in a future urban study or a development plan. So it's a more broad policy in that sense, so that you can have that discussion. Similar changes are made in terms of the outside the Greater Christchurch area as well. Again, that policy in my submission provides a really restrictive and outcomes-based planning approach rather than effects-based policy, which will be appropriate at this high level. There's been some discussion around specific supermarket policies, and that's definitely supported by Foodstuffs. It would be in my submission and looking at the way these have been drafted, probably a little bit unusual to put it up in the urban growth chapter. So really what we're trying to do here is just tease the door open a wee bit so that that discussion can be had at the next zone chapter, and we would put forward some more specific policies in that sense. And then other than that, I don't feel like you need me to go through anything else that I've included in my submission. So I am available for questions. And if I can address some comments that were asked of my friend, Mr. Leckie. Supermarkets obviously can be standalone, and with limited retail have been found on numerous occasions in Foodstuffs experience not to adversely impact centres. I think we spoke at a high level in terms of what Foodstuffs proposing to do. It's got a consented pack and save in the town centre, and the advice of its consultants has been that that would be more appropriately not located there in terms of what's been trying to be achieved in the town centre, and it would be more appropriately located just a little bit further out. So it's obviously still within proximity to the town centre. It wouldn't change the retail distribution impacts. But it wouldn't be in a town centre zone or any other zone that's being put in the district plan. So to answer, and I think my friend Mr. Leckie answered this quite well, but no, there's no sort of unfettered ability, and this would be put through controls. But I feel like we're probably advancing these discussions again a little bit high up, and they would be dealt with in the later chapters. In terms of alternative locations and significant adverse effects, I find this is a conversation that we regularly have through either not so much plan change, but if you are doing a resource consent application, because there's a requirement under the RMA Schedule 4 where you must consider alternative locations if you've got significant effects. So quite often a supermarket or a large food warehouse would be in a position where they do need to explain and justify, generally on the basis of catchment and retail distribution, as to why they intend to locate where they are. And the only other thing was that you need to backfill provisions, and we entirely agree and wholeheartedly confer that that will be something that we're looking to do with supporting technical evidence in the later chapters. So, Chair, that's all I've got, unless you've got some questions of myself. And again, Ms. Parrish is available as well if necessary.
Great, thank you very much for that. Just before I hand over or run through the panel members in terms of questions they may have, I have a similar issue regarding scope. Your original submission, as far as I can tell, only sought amendments in any kind of detail to policy UGP 15. So I'm not sure there's scope within your original submission for you to ask for changes to other provisions. So I'd invite you to submit a memorandum or minute to us just explaining why you think you have scope to ask for amendments to the other provisions other than the ones that were identified in your original submission. And attached to that minute would be really helpful, given that you said you now resolved from some of the changes that were attached to the planning evidence. If you could just make it crystal clear which provisions you still are seeking amendments to and what those amendments are, that would be very helpful. Thank you.
Thank you, sir. And I did have a look at the original submission after you questioned my friend, and I'm confident we do have scope, but I will set that out in a memorandum.
Yep, that would be helpful, just so we can consider that matter. Right, we'll see if we have other questions for you. Andrew.
Thank you, Mr. Chairman. Yeah, look, I did have a question around paragraph 19, which is in relation to Urban Growth Policy 15 and how you have interpreted that in relation to clause A being limited to where it's an industrial activity, and I appreciate you've already clarified that and acknowledged the questions from the chair around the application and interpretation of that policy. So, but I note you also said, should that interpretation be widened so that it's not just simply industrial areas, that may well affect the, I guess, what Woolworths is seeking. And I'm just exploring, Mr. Chairman, how if we have that confirmed that it isn't limited to industrial areas, that clause A, as well, whether or not that response, how we might deal with an altered position from the submitters as part of their further response.
Mm-hmm.
Yeah.
Did you follow that?
Well, it was a question of you, Mr. Chairman, as much as anything. Is that a direction you want to provide as well?
I was just asking if
okay, thank you.
You followed that request.
So in terms of clarifying what our change in position would be if it's not industrial, it would have to be just referred quite simply there to urban growth areas, obviously, or being within that overlay to be able to change our position. And I'm not sure that it does when I read that, but if it did, and that was clarified by the council, it may be that well, actually, I'd suggest that the other changes would still need to be there in terms of just opening it up broader again for that minimisation of significant adverse effects and that extra provision in there.
So maybe in the minute that you're going to do for us, if you can maybe address that as well.
Can clarify that as well, absolutely.
Yep, thank you.
One, if it is, the whole clause applies to industrial, then here's what you think, and if it doesn't, then here's what you think instead.
No, absolutely happy to do that.
Yeah, thank you. That'd be helpful. Anything
Yeah,
else?
and no further questions. Thank you.
Right, Lindsay.
Yes, thank you for your legal submissions. I don't have a whole lot more to add. You obviously heard our discussions with Woolworths this morning, and I think there is some similarity in terms of both of your positions. But I'm just interested in a specific paragraph in your legal submissions, paragraph 29, where you discuss the inherent difficulty about defining what adverse amenity effects are. Obviously, with an organisation like Foodstuffs, you're involved in the RMA process a lot. Surely there is an established body of knowledge about what generation of adverse amenity effects might be. You're looking at potentially traffic generation, potentially noise, loading and unloading, and those sorts of things, plus also wider effects on, say, vitality and vibrancy of adjoining town centres. Can you just sort of expand a little bit more about why it is difficult to actually define what adverse amenity effects are in relation to your submission?
So can I just clarify, is that just a general question, which I'm happy to answer, or is it in relation to Foodstuffs seeking to qualify adverse amenity effects by the words either unacceptable?
Well, it's a little bit of both, actually. Okay. I think there is the wider question about how do you define what adverse amenity effects are, but in relation to the policy relief, which we're looking at, how would that work as a decision maker?
Correct. So yours, and I might be putting words in your mouth, but the question, as I understand it, is if you are seeking to locate a supermarket within a residential catchment, which is the customers that it services, there could be amenity effects. And how does that, I guess, correspond with the expectations of the residential amenity of those people living in that zone?
Yes, that's it. Okay.
Yep. And the second aspect of that would be that when you design a supermarket, and we're always quite hot on this because there's a lot of urban design criteria now for supermarkets, and a lot of them actually do not really work for someone who has a business which has functional requirements, obviously large car parking areas, truck servicing and bread. So amenity is something that is particularly important and very much focused on in any application for resource consent. It takes exactly what you said in the form of how do you achieve appropriate and acceptable effects from the traffic generation, which tends to be quite large in terms of visual, because you've got to have a certain size of a building in terms of a floor plate and the supermarket to be able to maintain economic viability. And that really, I think in a lot of respects and in all the decisions I've been involved in for supermarkets can be maintained largely through good architectural design, strategic location. So supermarkets and the site that we've got are on two road facing frontages, for example, so that you're not, you might only have one residential connection side because you've got high traffic generation, and generally a supermarket wouldn't be able to be supported on a road that couldn't withstand that capacity. So on a quiet residential cul-de-sac, for example, you're not going to be able to justify a supermarket on it. So it's largely, amenity largely sorts itself out, I should say, because the supermarket operators are very experienced in picking a site that would meet its requirements, that wouldn't cause unacceptable effects on people who live next to it. Those people who live next to it are their customers. So they generally are wanting to make sure that their customers are happy and there's appropriate setbacks and there's no shading, and you know, the bread delivery comes at a time that people aren't going to hear it, or around the back entrance away from where people are going to see it. Yeah, so I mean, I think that there are always amenity effects that you need to consider, but that there are some very experienced operators now who design quite well around those effects to ensure that they can complement the activities that they're located next to.
And in terms of directing particular activities to go in certain locations, do you feel with the amendments that you've made that there's sufficient direction in them to be able to quantify between, well, not quantify, but to be able to make a distinction between an activity which is appropriate and an activity which isn't appropriate at the high level?
Yeah, so one change, for example, under Urban Growth Policy 15, we talk about a diverse range of services and opportunities, and we've said associated with additional suitable development capacity, the type, scale and function of new commercial does not generate significant adverse effects on the activity and meets the needs of residents in the intended catchment. So I think the changes that we're putting forward are very sensitive to that. It's not something that we've ever tried to shy away from. I think it's a discussion that we always front foot.
Yeah, but how would that actually play in reality in terms of, you know, you're sitting in a decision maker's position with this when you've got things which are potentially need some value judgment, some subjectivity in them? Is there not the necessity to provide a little bit more direction about what's an acceptable outcome?
Yes, absolutely. And I think that direction is and will be provided in the subsequent zones, the zone chapters that we'll submit on. At this stage, it's definitely setting it up so that there is an acknowledgement of needing to be sensitive to the neighbours. And then your next chapter would talk about what values of amenity perhaps are important for residential zones and how they would need to be maintained.
Okay, thank you. No further questions.
Thank you. Malcolm?
No questions, thank you.
Thank you. Nicole?
Me neither, thanks.
Thank you. Deborah?
No questions.
Thank you. Mark?
Yep, just a couple. You mentioned that you identified land for a new Pack and Save in Ralston. Have you received consent for that?
No. So we also, as Woolworths has expressed, see challenges in the framework of both the operative district plan and this proposed plan to be able to succeed on securing a resource consent at the moment.
So, okay, just for my clarification, are you not likely to apply for consent under the operative plan?
I think there will be an intention to apply for consent while making a submission that the proposed district plan has limited weight and doesn't also provide, but that we're seeking to have more permissive framework put into it.
Thank you, because I was just trying to clarify this because I knew of the the land that you purchased and I wasn't sure where you were in the consenting process because
not yet, but would like to be.
Thank you.
Yeah.
As to whether it was possible under the current operative plan to essentially apply outside of a centre within the township, within the residential zone.
Yes, it is, and ironically, it has a better activity status than the proposed plan. So it would be a discretionary activity to apply for a supermarket in a residential zone, and it would be subject to consideration of amenity values and in the residential chapter in terms of what's sought to be achieved.
Okay, thank you.
Raymond?
Yes, I do. I have a couple of questions. First of all, you mentioned pack and save. You were trying to, or if you'd had your time again, you wouldn't have located pack and save in Roddeston where you did. Why is that?
I shouldn't put words in Foodstuff's mouth. They obviously secured on the New World site that I understand, and I'm just going to turn to my, oh, here you go, she's frantically saving me. But I understand the New World is 21 years old, and so Foodstuffs have been looking, because of the demand in Rolleston and the huge amount of growth in Rolleston, to cater for a food warehouse. And I'm going to pass, if it's okay, Chair, if I can pass that to my client to answer that question.
Sure.
Good morning, everybody. My name is Rebecca Parrish. We've been looking for a site in Rolleston for a pack and save for many years, almost a decade now. And we have secured a resource consent for a pack and save in the town centre, but it is very tight. It's very confined, it's very dominant, it's very constrained architecturally, very constrained operationally, and will have quite a significant impact on the flavour of the town centre. It's not the most ideal proposal. If we got desperate, then that was what we were having to continue to develop, but it's certainly not our preference. Ideally, we needed a site that would behave better with our surrounding catchment and our community and create more of a community feel. The town centre site is really constrained.
Okay, thanks for that answer. I've just got one more. I'm not sure if you're the person I'm to ask. I think the submission was by M. Allen back in 11th of December 2020.
Yes, Mr. Allen is the planner for Foodstuff, but he's not here today, so we're happy to attempt to answer the question.
Okay, well, I'm referring to his paragraph or her paragraph 23C. And you talk about, or he talks about, or she talks about other key anchor tenants. Do you know of other key anchor tenants who have been provided for in the objectives and policies and rules in the PSDP, and whose buildings are at a greater scale than 450 square metres in Roddeston?
I'm not sure of the context of that question because I don't have the submission in front of me from Mr. Allen, but
so do you want me to read out C for you, what he says?
Yes, I'm happy to.
As a key anchor tenant, supermarkets should be expressly provided for in the objectives, policies and rules of PSDP for a range of centres. Currently, for example, the PSDP does not enable supermarkets to occur on a scale greater than 450 square metres outside of the TSZ within Roddeston. So my question is, do you know of any other key anchor tenants that are provided for in the policies and rules?
Sorry, thank you, Raymond. No, because the rules for the town centre zone, which is referred to in that paragraph, don't provide for supermarkets specifically. That would be commercial activities, and that would be that they would all be consistently limited to 450 square metres in terms of the triggering the requirement for a resource consent.
Okay. All right, thank you.
Thank you. Yvette? Something's gone wrong there. Gary?
Just one question in relation, similar to Commissioner Dacia's question, but this time in relation to UGP 16, business growth outside Greater Christchurch area. I'm just interested in the amendments you're seeking, and you did make the point that the policy is very outcomes focused and doesn't deal with it deals with outcomes rather than effects. And so the change you've suggested uses the words "or is capable of minimising significant adverse effects." So the direction, do you not think it's a little watered down? It's saying that you take a strategic approach, or you look at the effects and see if they can be minimised. There's no priority between the two. I'm just wondering how
I see. So in terms of a cascading preference.
Yes, well, as it reads there, it gives the decision maker a choice as to
That's
which
right,
way they
to
go.
either look that way or the other.
That's right.
And I would be happy and comfortable, because the intention is simply to have that assessment of effects in situations outside of those areas. So I'd be comfortable with expressing that, so that in the event that it is not consolidated, then you are looking at the other option, as opposed to, you might be in the town centre, but you could justify it on the basis of that other component.
It would give some priority to the initial strategic.
Yeah.
Okay, thank you. That clarifies it. Thank you.
Thank you. No further questions from me, but thanks very much for coming in this morning. We look forward to your further assistance in terms of the little minute I've asked you to prepare.
Thank you, Chair. I'm happy to provide that memorandum.
Thank you.
Thank you.
Next submitter we have is Birches Village Limited.
Tēnā koutou katoa. I'm now putting another hat on and acting for Birches Village, who is a residential property developer with interests in Christchurch as well as Selwyn, and in particular Trebleton. So with me on my left, I've got Mr. Ryan Geddes, who's a director of the company. He didn't provide evidence. He's sitting here in support and to obviously observe.
Thank you.
So to take the same approach, Chair, if you're happy just to quickly summarise some points, and then we can answer questions.
Thank you.
Birches Village are one of, I'd say, many private plan change submitters seeking to do an out-of-zone residential development in Trebleton. And the concern held by Birches Village is that the current framework doesn't provide for sufficient flexibility in order to enable assessments on a case-by-case basis for that suitable additional urban development. Avoidance provisions for the new urban growth areas, and together with an emphasis on the council-owned capacity information, will not achieve the competitive market outcomes and will fail to deliver on affordable and social housing needs. And in our submission, urban growth provisions don't strike an appropriate balance between certainty of planning outcomes and that flexibility and responsiveness that has been indicated or strongly directed in the NPS on urban development. So I've set out some legal submissions, which I don't really plan to go through. What I would like to do is use, and I'm obviously happy to answer the questions on that stuff, but I'd like to use the Birches Village example as to how we can demonstrate that these provisions may not be the best outcome. For example, I know there's talk about ad hoc development across Selwyn, and there's concern that in terms of Birches Village, they are looking to do a plan change, and this will be obviously dealt with in detail in the site-specific zoning requests, as well as through their private plan change. But there's in Trebleton, the council has identified an area along Birch Road for a reserve. It's on the end of the urban area, and it's outside the township boundaries. So naturally, what is now being looked at by developers is filling up, I guess, the space between the township boundaries and then now the urban reserve, which will have all the infrastructure and everything moved down towards the reserve. So Birches Village have a site across the road. It's currently, in our submission, being inefficiently used for lifestyle blocks. And there's a number of residential owners that have all signed up sale and purchase agreements. And there's a real opportunity there to, in our submission, achieve a residential outcome that is entirely consistent with what's trying to be achieved through the NPS on urban development. You're, next to a large area of open space, you've got the ability to do a bit more density on the front. You've got the existing infrastructure that's there. You're along the main strategic bus routes, and you've got a road that can take the capacity of additional traffic. There's cycle routes there. There's a pathway across. So in our submission, putting aside what level of capacity you could produce on that site, I think it is 600 lots that is proposed, and the evidence behind that is that there is currently no land available in Preberton, all the areas that have been identified through this plan change. And you'll be aware from other submitters that the Selwyn District Council haven't elected to do any new areas. So we are almost in my submission enabling the past, whereas there's this bright future ahead with lots of opportunities, particularly in Preberton, which is currently saturated, and there's a huge demand there. So when you take that example and then you look at how you might be able to produce consistency with what's being proposed in these urban growth objectives, the first one that you obviously hit is you've got your strategic direction for providing urban growth, and we've suggested an amendment in subparagraph 9, which essentially brings in the requirements of the MPS on urban development. So it's requiring the local authority under planning decisions to be responsive to proposals that would supply significant development capacity. Development capacity in my submission could take many forms. It could be numbers in terms of volume for demand, but it can also be achieving those higher level outcomes of the MPS on urban development. So what you don't have in Preberton at the moment is obviously competitiveness. You also don't have any supply. You've got a reserve, and you've got these sort of, what do they call them, well-functioning urban environment requirements that in our submission would be met through this type of proposal. It obviously wouldn't be feasible under your urban growth policy 3, because you're to avoid the zoning of land to establish any new urban areas outside the township boundary. So this piece of land is outside, even though it adjoins the existing form, but it is outside the boundary. When you get to further down, again, under your policy 7, we're still talking about township boundaries and maintaining compact and urban form. And actually, when I go through the remainder of those changes here, a lot, I would say, have actually been picked up through the addendum, the Section 42 report, in response to the Commission's questions. There were some questions around the versatile soils, recognising and providing for, having regard to. So the changes suggested now in the officer's report would be fine there. In terms of your urban growth policy 10, have regard to the rural outlook, or preserving, another word could be maintaining. I believe there were some changes as well through that. Getting into the policy change, I mean, if we're being quite frank and open, the rest are just minor tweaks. The fundamental change that would be required to be able to advance that is through your urban growth policy 3, which says you have to avoid outside of the overlay. And in response to the Commission's directions, there was a further legal submission that was circulated by council, and just in support of that, which we generally concur with, our submission is that, or my submission is, given the invalidity and or incompleteness of the regional policy statement, you must have recourse to the urban policy statement in terms of making determinations. This plan change in our submission would respond to those needs, and it's unable to be considered through this framework. The other submission that we would really support is a hard rural urban boundary without the ability to consider change or movement would not, in our submission, meet those requirements of responsiveness. And those higher order urban growth provisions would also need to be set up, which allows that sort of consideration of what might be significant development capacity. Because I know that I've noted that I've inserted those words, but there is no further guidance. as I said earlier, in terms of significant development capacity, it's my submission that this could be more than just numbers or contributions to numbers in terms of meeting bottom lines. It can also be, providing housing choice, for example, which this proposal would provide for Prebbleton as a different type of housing in lot size and location, which is next to the community reserve. It will provide competitive land markets, and development could also make an important contribution to the urban form of the township. So that's obviously all the things that will be raised in future. Chair, in response to your, I can't recall who you put it to, but in terms of mulling over whether you could do, for example, avoid unless, I think that's something that would be entirely we'd be supportive of something like that, because it just provides that opportunity. I know that's kind of kicking the can down the road slightly, and it may be that you also have to think of in your overall framework of how aspects of what significant development capacity might be could be intertwined into how the policies are read. But I think that that may solve the difficult situation where we've got a tension between an RPS which hasn't kept up with an urban policy statement, but the local authorities plan coming through. So something like that, I think, would remain or keep the door open for submitters like my client, Birches Village, and would enable that, I guess, to be involved in another process at the RPS level to really discuss what that significant development capacity would be. I say that with a wee bit of hesitation because I have seen the strong approach being taken by representatives for the Canterbury Regional Council, and they do seem quite set that there wouldn't be any development beyond these infrastructure boundaries. And I guess that makes me a little bit nervous that we might be kicking the can from a local district that knows its needs of the district really well to providing it to another process with someone who's already indicating that they wouldn't allow any development beyond those boundaries. So I would just add that qualifier. So that's kind of the gist of what we're saying without having to read all of these pages of submissions.
Great, thanks very much for that. And I'll just see we have questions for you, but in terms of the detailed amendments that were attached to your legal submissions, you've indicated your key area of interest is policy UGP3, and you just made some comments in relation to that. So which are you able to provide us with, again, a little bit of assistance, maybe by way of a memo or a minute, just saying which of the remaining changes you're still seeking and which you don't seek anymore?
I think we're still seeking the remaining changes because if you have a look through them, they're quite minor tweaks to wording to take off the edge of hard comments. I think the one that's probably most significant, other than PG3, which I talked about, is in terms of residential growth, Greater Christchurch area, P13. So the land is subject to an urban growth overlay, and the area is a greenfield priority area, or is a rural residential strategy, or in our submission, there should be additional words here, is appropriate for residential growth in accordance with the National Policy Statement on Urban Development. So it's just providing this to stretch a wee bit beyond the current regional policy statement. Now, there's no suggestions in my submissions that the other aspects of the regional policy statement wouldn't continue to be applicable. And as I've outlined at a very high level, Birches Village development would easily tick those boxes. What we don't tick is being beyond the township boundary, despite the council's own reserve also not being beyond the township boundary. So it's sort of a difficult. The urban form has extended, but not on paper.
All right, thank you. I'll see if we have questions. Andrew.
Thanks, Mr. Chairman. Thank you for your legal submission. So paragraph 13, and apologies if I have missed it in your evidence, it is submitted that there are already issues with the council's capacity assessments and spatial mapping. So is there any, did you explain what that was in your evidence, or is it somewhere else?
No, so I've referred further on there to the fact that we've provided an application for private plan change.
Yes, okay, you did.
So within that, there's an economic assessment, and the economic assessment says two things. that there's obviously insufficient capacity in Prebbleton, that the business assessments that have been done by council to date don't appropriately provide for it. And the view of the economists acting for my client is that even if you were to take all the development across all the plan changes right now in the district, there would still be a need in terms of the demand for development capacity.
Okay.
Yeah.
Right. Thank you.
So that's our fault, Commissioner, because we don't have that economics evidence in front of you.
Yes. Well, that hence why I couldn't see it.
Yeah. So this would be obviously dealt with in the later chapters.
Sure.
In more detail.
So I'll just skip ahead to another question, just because we've just sort of segued into it. So paragraph 23, and this is around, I guess, how much capacity there actually is. And you've just said in your plan change, you've identified, I guess, a shortfall. I just note in ECAN's legal submission in their statement that they've talked about a significant surplus of 48,000 feasible households across Greater Christchurch under the recent housing capacity assessment. So I mean, does your plan change evidence address?
It does address that. Okay. And also I just note that that is obviously a helicopter view of capacity across the region. And it doesn't provide for the local situations of wanting to perhaps live in the town as your parents do in Prebbleton. So if it's not going to be solved through a plan change one, putting a whole pile of houses in Rolleston if you want to live in Prebbleton, to put quite simply. Yeah. So the specific assessment from the economist looks at the demand, and there's actually an acknowledged shortfall in that business capacity for Prebbleton. It's acknowledged, and we're within that shortfall. But when you look at the overall business capacity assessment for the entire Greater Christchurch, the submission from ECAN is that there is enough housing across that entire region.
Okay.
Yeah.
So just going back a bit before we segued. So paragraph 20, just so I can get clear in my mind, you've stated it's submitted that the PDP should enable considerations of development capacity based on a broad evidential basis than just those held by council. And I'm interested in what that would mean, because I'm just looking at the MPSUD clause 3.21. It does talk about a process for doing the housing and business development capacity assessment and who should be involved in that, and it appears to be pretty broad. So I mean, what in your mind, what are you suggesting the council should be doing in paragraph 20?
So you are correct, it is very broad and they're required to consult the property developers. But in terms of paragraph 20, I'm looking at the provisions which essentially only provide for growth if you are listed in one of those. So it still is at the control of council. So at the time that assessment's undertaken, if you're not considered within that assessment, in our submission, is that appropriate that you're then now cut out of being able to be considered through the district plan process if you were to advance a private plan change?
So it's at that level. Okay.
Yeah.
Thank you. And finally, just looking at the recommended changes to UGP3, is that accurate, the strike through and underlining for PG and for P4 as well, P3 and
So
P4?
in terms of what we're seeking?
Yeah, so if you look at P3, you strike through most of it and then just left P3 as Christchurch area of the district outside the urban growth overlay. Is it a heading, or is it that the policy?
So UGP3 is just essentially absorbed the two changes into the one policy of policy 4.
Right, so it's 3 and 4.
Yeah, and I listened to some discussion earlier on whether there should be some acknowledgement between, I guess, the Greater Christchurch and the other area. The challenges, as was acknowledged by that planner, currently there seems to be a more permissive zone for areas outside of where the growth should reasonably occur within the Greater Christchurch. So, yeah, so if you're in West Mountain or Leaston, you're not subject to these provisions. But if you're in Prebbleton or Lincoln, you are, which seems odd. So I think the intention here is really to take away the restriction that the district plan puts on people being able to submit site-specific plan change a request for something which may not be in MAP A.
Okay, so sure. So for clarity, then UGP3 is deleted in its entirety. Is that what you're
Correct,
saying?
but it's absorbed into
And there's just-
PG4.
Right, and it's
Yeah.
renumbered accordingly.
Yeah.
Okay. And it will be manage the zoning of land to establish any new urban areas extensions to any township boundary, Christchurch area of the district. Within, so I'm just wondering, is that correct as well? Before?
Manage the zoning of land to establish any new areas or extensions to any township boundary outside the urban growth where it maintains a consolidated and compact form or is otherwise consistent with MPS on urban development.
I think there's a font problem with our version.
Oh.
It shows it's underlined, not struck out.
Oh, gotcha.
Yes, it might clarify it. Sorry.
I'm happy to provide this copy if that would assist.
Thank you. Yeah.
There's no need to hand it out now. Just in the minute that you're going to, if you can do a minute for us, just saying what the changes are that you actually still seek, like I asked for earlier.
And would you like me to express, Chair, as well, that, you know, I have acknowledged and I've heard you say about the avoid unless as well would be an alternative wording that would be appropriate.
Yeah, thank you.
Thank you for clarifying that. That's not the version we have.
Okay. Yeah, the crux of the submission is that, you know, in light of the MPS on urban development and the fact that there is this provision for out of sequence or responsiveness, it seems to, the plan still seems to apply, in my view, the backward thinking, not backward, but the retrospective thinking of how the district has operated in that hardline approach, where in actual fact, this is an exciting opportunity for you all to be considering how we could move forward in terms of that flexibility. And that's not to take away any emphasis whatsoever on those other important elements within the RPS, such as infrastructure. And that's obviously quite clear through the RPS as well as the MPS on urban development. You'd need to justify that on each in each application.
Yep, no, understood. Anything else, Andrew?
No, thank you.
Thank you. Lindsay?
Thanks very much for that. There's a real consistency of approach from some submitters about MPSUD is now in play, therefore all the strategic work that's been done, particularly with PC1, no longer applies. Do you not find it quite odd that PC1 went through a relatively recent SPP process, which was signed off by the minister, and you know, and then we get MPSUD, and saying, well, basically, if you're looking at a responsive approach, therefore that previous work doesn't really matter. Do you think that's fair?
I think from a legal position that we're required to give effect to the higher order documents, the most recent higher order documents. So the indication from the government is that they've seen the challenges with the housing supply, with the higher level, with the local planning, and this is their solution. Whether or not that's the right thing is not something I guess that I'm going to comment on today, but I would say that because there is a national direction, because it is very clear on what it seeks to do, and it essentially seeks to prevent the situation that we've got with the RPS currently, then in my submission that should be applied to the Selwyn District Plan, despite the panel yourselves all being in a very difficult situation where you don't have that guidance from the RPS yet.
And you mentioned that you'd actually, you've read the legal submissions from the Regional Council, who are pretty firmly of the view that where Plan Change 1 or the existing provisions in the RPS actually does implement the MPSUD. Where do you differ in your opinion from that, rather than you say it's a high level document, it needs to be given effect more than the RPS as we now have it?
Yeah, so I mean, I am quite firmly opposed to that view. I don't see how you could come to that view on the basis of an avoid. So there's an avoid policy in the RPS, and we've got a responsive planning frameworks, which requires out of sequence activity. So I can't reconcile, in my view, my legal opinion, I don't think you can reconcile those two. So in my submission, the higher policy statement on urban development must take priority.
Yeah, but the lower order documents need to implement that as well and give some direction about where, the how, when, why that urban development should occur. And are we left in a situation where, as long as you can make your case, you're going to get development approved regardless of what the RPS says? Is all that work, that very recent work that went through with the SPP, to be completely discarded by the fact that you have something which is pretty general in terms of direction, being responsive to out of sequence developments?
Well, I think the RPS still stands in terms of most of the provisions. It's the ones that directly conflict with that. All it does is enable a developer to have a case by case, have a chance to provide their development and explain why it's got significant development capacity. I don't think it's going to create a floodgates of development, and if it did, it would be because there's a really strong demand for development, and that developers are able to demonstrate how they are providing infrastructure and how they're working within the existing environment which we're operating currently.
Yeah, but I'm thinking about, if you're looking at a merits-based assessment of a proposal to rezone, which is outside the PC1 area, how does a decision maker actually get to the bottom of whether or not it's appropriate in terms of the NPSUD when you're looking at the provisions of the plan? It really is, to me, it just seems that the NPSUD is quite general, and then the lower order provisions need to be relatively specific about whether or not it meets both the NPSUD and the wider urban growth outcomes which are trying to be achieved about, consolidated town centres, looking at infrastructure capacity, looking at being well located in terms of transport provisions and so forth. Isn't there quite a complete disparity saying it's now potentially you'd be able to going to be able to make your case without having reference to the other strategic work which has been done before?
So I acknowledge what you're saying. My view is all of these matters that you're listing are within these objectives in terms of achieving attractive, pleasant, high quality urban environments, integrating with existing neighbourhood centres. It's all there. All the NPS does is open the door for people to be able to argue that they're consistent with the remainder of the planning frameworks of the RPS and the Selwyn District Plan. So it's simply, instead of avoid, as in you cannot prevent the occurrence of, it is you can apply for, but you've still got to demonstrate how you're consistent with the remainder of the RPS and all the objectives and policies that are put through for the planning provisions. And all of those policies, it's not an easy case. You've still got to demonstrate exactly how you integrate with infrastructure, what your effects are, how they're justified. So I don't think, with respect in my submission, that you have got a broad, wide-ranging environment. It's simply allowing that opportunity to go through that process and compare consistency with the relevant local documents.
Sure.
And in most districts, that would be our right. But in Canterbury, it hasn't been because of this map A.
Yeah, okay. But you would say it's fair that the priority which should be given in terms of urban growth, those already identified in PC1 over those which aren't identified in PC1?
Well, I think the challenge is there's a number of reasons why areas of land aren't being developed. And so is it fair that everyone waits till those people might develop or don't develop when there's a need for housing, when there's other land that's available as well? So in terms of priority, there's obviously a clear priority in the RPS for that development in those areas. if you're not one of those areas, you're going to have to work very hard to justify how you meet all those predetermined objectives and policies, which were essentially set for those areas, weren't they?
So you'd be happy with a much higher bar for urban growth outside of the overlay?
Well, I think the bar's are already quite high in terms of what the objectives and policies show. The presumption is that those greenfield areas within MAP A already achieve that.
Okay. Finally, from me, policy 3. I think we're going to hear quite a bit about policy 3 over the next couple of days. What you mentioned that policy 4 framework is actually much more permissive than policy 3. Do you not think there needs to be a distinction between those areas and the Greater Christchurch area as opposed to other parts of the district which are not, in terms of that where you're looking at urban growth?
Yeah, no issue with there being a distinction between the areas, provided that you're able to apply for a plan change in either area.
But by deletion of P3, you're basically saying something in Darfield's got to be treated the same way as something in Rolleston.
Well, you could achieve the same result by having them separately identified, but with different words. So one's got managed, the other one might be restrict instead of avoid. Restrict the zoning of land to establish new areas. That isn't consistent with the RPS, policy 8 criteria or something like that.
So you're still saying that potentially there's an option to leave the RPS framework in this policy framework in Selwyn.
Yeah, although I was responding to a question from the chair, and I think wording like that might be a way to resolve the tension. But I definitely don't think that there should be a presumption that just because you are now an area, I think based on the MPS on urban development, why should a new area be considered or have a harder bar to pass than an area already identified? I think each person needs to submit on the merits based on the policies that are applicable.
Okay.
There's no issue as to what if you were to distinguish between Greater Christchurch and outside, provided the door was still open for private plan change applicants to be able to make an application.
And your amendment that you've got to the new P4 about otherwise consistent with MPS UD, isn't it going to be hard to actually quantify, because there's different parts of the MPS UD, and how is there going to be an evaluation of what is consistent with the MPS UD without actually spelling it out in the policy?
Correct. So I think that the chair's submission in terms of talking about the significance development criteria, and then looking at the challenge then as a panel you have is by including that criteria, you're then required to talk about what that might mean in my submission for the district. Because otherwise it's a little bit awkward because we're referring to a criteria that hasn't been decided yet in the regional policy statement. So how do we demonstrate from a planning perspective against the RMA that the costs or the benefits of that are appropriate if it's not determined yet what that criteria might be?
Yeah, but isn't the MPS UD rather broad to be included in the policy?
That's rather broad, and it could be clarified more in terms of consistent with, say, policy 8.
Yeah, which needs to be read aside other parts of the MPS UD as well.
Correct.
Okay. Thank you.
Malcolm?
Yeah, thank you. Andrew and Lindsay have certainly investigated some of the lines of questioning that I had. I just wanted, you've mentioned that you want to avoid hard boundaries because that would not allow responsiveness, and you seem to be saying that because there is demand, it has to be met. Well, what happens with the next demand if your proposal was to go ahead? Does that mean the demand carries on and we end up in Lincoln? Is this good planning?
Well, it all needs to be assessed on the site-specific, criteria, And the words of the MPS, as you'll be well aware, having listened to us all, is at least providing at least sufficient development capacity. So, you know, if there is a demand for housing, can you say that we're fulfilling that criteria if it's not being provided for? And is it appropriate, as suggested by the Regional Council, to be providing for a certain type of housing on the edge of Rolleston when there is a demand for it in Prebbleton? In my submission, that it's more appropriate to look at that significance criteria in light of the local context within the existing environment, which is what the RMA does. So it's the same arguments as environmental creep under the RMA. You know, can you get one and then get the next, and it just sort of creeps along. But ultimately, there's no precedent effect, and you would need to assess everything on a site-specific basis. Prebbleton, I should say, just while I'm putting a plug in for the developers project here, is quite limited in the way it can grow through the motorway boundary, the power lines. So there is capacity limitations to growth in Prebbleton.
I'm very aware. You've also mentioned in paragraph 12 the Prebbleton Structure Plan, February 2010, which was heavily worked with the community at that time, where they did set a hard boundary to the future. The people at the time wanted to keep a village, as they still like to call it, I believe. So it'll be very interesting to see how we go, and I think I'll leave the rest of my questions until we get to the subdivision hearing a bit later on.
Yeah,
Thank you.
Thank you, Commissioner. And I would just note there that it is interesting that there's been a reserve put out from that hard boundary, you know, obviously identified in the development plan area too. And that's
I'd just clarify that was put there because it was the only piece of 20 hectare land that could be bought on the outskirts of the township. So, and it's shared reserve between Prebbleton and Lincoln. So that's to give you some clarification on that.
Thank you.
Thank you. Nicole?
No further questions now after all the discussion we've had. It's been good. Thank you.
Thank you. Deborah?
Yes, I have a couple of questions. Mine centres around, I guess, the extension of national policy statement, policy 8, require at least giving a leeway to rezoning land, but it has to be in accordance with the availability of infrastructure. It's been highlighted earlier. The statement on, well, we call it versatile soils, but productive soils. And we've also heard from submitters who have farming operations on the edge of where the growth is actually planning to go, and that consequences of reverse sensitivity issues. When you actually look at all of the policies and the hurdles, I guess, that have to be met, is there going to be some locations that are better suited to actually get over those hurdles than other locations?
Absolutely, without a doubt. So there's no presumption that by removing an avoid policy, you know, people will be able to develop everywhere, because there are quite a lot of policies within the Selwyn District Plan itself, and also in the regional policy statement relating to infrastructure and relating to your highly productive soils. Yeah, I mean, in this case, it's the arguments about infrastructure have fallen away because obviously the council's investing in infrastructure out towards the reserve, and in terms of the highly productive soils, you will find that your inner plains areas, which are the rural residential that can develop to 4 hectares, because of, I haven't seen obviously the latest version, but the last version of the MPS on highly productive soils did exclude that sort of land, that you will find that those sort of pockets or the existing rural residential development would be able to perhaps go through those hurdles, but not larger plots of rural land with higher class soils. So there will naturally be limitations, agree. Thank you.
So just for clarification, you do agree that some townships, when you take in the whole of infrastructure capacity, versatile soils, will have limitations in their growth structure?
Yes, absolutely. And that's part of it.
They won't go on exponentially.
Well, it's just part of assessing the receiving environment and the site-specific circumstances of each case in light of all of the policies, you know, starting with the development plans, moving to the Selwyn District Plan, moving to the regional policy statement, and the NPS until such time as that's been implemented within the RPS.
So just with regards to understanding rezoning of land, if land was to be rezoned, but you didn't have the infrastructure capacity at that time, it had to be upgraded, purchased, applied for, how would, how would you see growth? Would you see growth actually being restrained if the infrastructure capacity couldn't handle all the private plan changes that are being, requested at the moment?
Correct. And I mean, when you look at your urban growth objective 1, it talks about how urban growth needs to be provided for in a strategic manner, which is coordinated with available infrastructure and utilities, including land transport infrastructure. So there are checks and balances already within the planning instruments that require that.
Okay, thank you.
Right, any questions?
Yes, thank you. Many of my questions have been asked by previous commissioners, so I've got a reasonably specific one where you have proposed an amendment to clause 5 of policy 13 to delete the references in terms of which gives some assessment of why the diversity in housing type, sizes and densities. Just sort of wondering why you've recommended that deletion. I know the HDCA and FDS are referred in clause 2, but to me it added sort of clarification to that clause, and I'm just wondering why you have that deletion recommended.
So when you look at the right from the top, it shall only occur where, and you've got, a systemic at the bottom lines, and you've already got the housing studies identified in number 2 being a need for feasible capacity. So you've already looked at that under there. And then subject to urban growth overlay. And then when you get down to diversity in housing types and sizes, my view is, and in our submission, that shouldn't be linked back to something you've already considered in terms of whether there's sufficient development capacity. You should be able to consider that in the local site-specific context.
It's different from how I read it. I read it, and that's identifying where these assessments tell you, identify what kind of diversity and stuff. Without that reference, it could be anybody's definition of what is the diversity of housing type, size and densities without referring it back to the prior document. Clause 2 says you've got to do this before you can carry on. Clause 5 sort of said you've got to deliver based on these previous assessments. I mean,
the challenge I see is when you look at those assessments, they are at a really high level, so they aren't specific to the community in which you are advancing a private plan change. And I referred with Commissioner Willis earlier in relation to Prebbleton, for example, and in the broader assessments, they just bunch Prebbleton with West Melton, and then they just give a housing number, and they don't really otherwise talk specifically. So I saw challenges that you couldn't, if you were linking it back to that document, that you couldn't be more creative in what you were doing in terms of your site-specific assessment. So I thought it was superfluous and unnecessary.
Okay, I guess it's where the level at which the assessments in clause 2 are done, whether they are sort of sub-regional or more specific to sort of a particular application, is where we have this tension as to, if you're looking at a greater Christchurch area, the assessment would be very broad brush and not specific, whereas if it was in the context of Prebbleton, it might be more specific to the topologies that are required to give good outcomes in that context, which might be different from West Melton or Lincoln or Rolleston. I guess see where we're coming to.
Yeah. So housing types, I'm understanding your concern, and I'm wondering whether it could be addressed through simple wording. The challenge is obviously with the plans, they're controlled by council, and then like we've heard in terms of development plans, they're very out of date now. So it was enabling that sort of site-specific, relevant, current time assessment. And the challenge is that if you are referring back, you may not be able to do that.
Yeah, well, I was sort of reading it, if in a standalone case, if we were of a mind to support some sort of allow both NPS and the regional policy statement to stand together, then an application outside of the regional policy zones might come with its own assessments that say it is needed and this is the type of development that is needed to justify its plan change, for example. That's kind of where I read it, and I can understand how you've read it, that so you might refer back to the existing future development strategy, which is too broad brush to come down to that level of design. So thank you.
Raymond? Sorry, Raymond, your microphone's muted. Okay, we'll assume we'll move on. Yvette?
No questions. Thank you very much for the robust discussion. A lot of my queries have been answered. Thank you for your responses. Well done. Thank you.
Gary?
Thank you, Commissioner.
Just one question, thanks. Yeah, just in relation to UGP 7, I just wanted to test with you how strong you are about requesting deleting the words township boundaries. The reason in relation to urban form, and I'm just asking that because in UGP 4, you seem happy to have a reference to township boundaries maintaining the consolidated and compact urban forms. So, is there any particular reason?
Yeah, no, I obviously you wouldn't expect development not to maintain a consolidated urban form.
So you still, sorry, just to confirm, you still.
So as long as we're not maintaining existing township boundaries, but we're saying township boundaries maintain a consolidated and compact urban form, which I would actually be comfortable with. I'm happy to remove that delete, because when you're applying for a private plan change, you'll be applying to shift the township boundaries with it.
Yeah, that's right. And I think there's a third reference to township boundaries further down. So that clarifies it.
Comfortable with that, and I can clarify that as part of my homework.
Thanks very much. No.
Thank you. We're running over time, but nevertheless, I've got a couple more questions for you. Just coming back to UGP 13 clause 5 that you had a discussion with my colleague about. I had read that provision as stating that the demographic changes and the social and affordability needs would be identified in those documents that you've asked to be deleted. That's how I read that clause. So my question was, if you delete reference to those documents, where would a decision maker then turn to find what the demographic changes and social and affordability needs actually are?
Well, you do site-specific relevant assessment, generally economic. So to support the Birches Village plan change, there's two pieces of information. One is from Mike Blackburn, who is, what would his title?
Management.
Blackburn Management. So he essentially looks across, doesn't he, at
the building consents that have been applied for and delivered.
Yeah, and the statistics. And then also, I suppose economic assessment wouldn't look at demographic changes in social and affordability needs.
So maybe in terms of the further little bit of homework you're going to do for us, you could give some thought to some wording that might clarify that. Whereby we might leave reference to those documents there, but you might add a provision on that would say something along the lines of, or any further more recent or updated information on demographic changes and social affordability needs that's properly researched and has a strong evidential basis. That's too long of words, but
something to that. No, and that would be something that we would support in terms of retaining those existing words if it had qualifiers to that effect.
Yeah, thank you. Now, I just got a couple of questions arising from the legal submissions that you provided in response to the Adderley Head memorandum, which we invited. And paragraph 7. And I just got a question there. You say, and towards the end of that paragraph, it's the words, but which contribute to a cumulative effect of increasing the same. And that just made me raise a question in my mind. If we were to be receptive to that legal submission, would that mean that any zoning request, no matter how small, would then be considered favourably? Because then any rezoning request, no matter how small, does contribute in a cumulative way to increasing housing ability.
And it's further clarified in the paragraph 18 in terms of, I think the situation we've got in Prebbleton, for example, is there is I can't remember the exact number, it might be 1,500, is that about right, in terms of the demand that's been identified in the council planning documents in terms of the shortfall of housing. And then you might have, there's 3 plan changes that between them provide just over that volume. So in my submission, that would be, even though you're not providing the 1,500 yourself, you're cumulatively providing with other developments. So there would need to be some level, you couldn't just tack on a very small amount, it would need to be qualified. So I think the submission there is that the word significant doesn't mean that it's a numbers game and the landowner with the most land gets to develop because they can provide a large amount of capacity, because that would be anti or contrary to the competitiveness aspect and directions of the NPS and urban development.
Yeah, well, I guess we won't really know what that means until the criteria are inserted into the RPS.
Right, yeah, so until such time everyone just needs to speculate on what it could mean. But in terms of the significant development capacity, I believe that when you read the words and when you look at the documents that have been provided by MFE, something that's significant may not just be, it could be a smaller development, provided it added something in terms of those other values and directives that have been sought through the higher directions of the NPS and urban development. So we shouldn't discount development simply because it's not a large number of housing in terms of supply, because it may contribute to a well-functioning urban environment in other ways.
Yeah.
It might be another piece of the puzzle for a community or a local environment. And in my submission, I'll be putting forward to a panel down the track that, you know, next to a reserve, for example, obviously adds a lot in terms of a well-functioning urban environment and the nature of being able to use that reserve for walkability and things like that.
Yeah, I guess the challenge for us, which I've alluded to earlier, is giving effect to the RPS as it currently stands, and then also giving effect to the NPS, which that latter part will rely on criteria that have yet to be developed for the RPS. Yeah. So we need to think about that without then providing a gate that's sufficiently big that leads to death by 1,000 cuts and sees just ad hoc development everywhere. Mm. So obviously we'll need to give that some thought, as will the officers in their reply report to us. Paragraph 8D. Just the very last sentence you say is precisely the type of hard boundary provision that the NPS identifies as requiring attention. Which provisions of the NPS do that?
What provisions?
Yep.
So it's only the provision 3 which talks about avoid. So you're talking about 6.2.13.
No, you're saying precisely the type of hard line boundary provision that the NPS UD identifies as requiring attention. So my question was, which parts of the NPS UD do that?
So I'm in that paragraph, I'm referring to the responsiveness provisions, which would be NPS, it's like objectives.
Yeah.
So in terms of, you've got your policy 8,
yeah,
obviously, which is creating an outer sequence type. And then you've got your policy 6, which talks about being responsive. I have to go back to my original submissions to find all the.
Don't worry about it now. Maybe you just include that in the information that you're going to provide, just the precise parts.
I mean, they are identified. So objective 6 requires planning decisions affecting urban environments, integrated, strategic and responsive. So responsive, particularly in relation to proposals that would supply significant development capacity. Mm-hmm. This concept of responsiveness is further built into policy 8 in subpart 2.
Yeah.
Together, these provisions in my submission can be read as supporting the general intentions which are expressed in that urban growth agenda, which you would have heard about, to remove the barriers to land supply and to make room for growth up and out.
Right, so it's those provisions. So there's no provision in the NPS that actually says a hard boundary isn't appropriate.
No, it's my submission based on reading the background documents and the policies that flowed through as a result of that.
All right.
Set out in paragraph 8 to 10.
Yep, great. Thanks very much. No further questions. Good. Thank you.
Thank you.
So the next submitter on our list is it Michael House? Yep, come on up. So good morning and welcome. Thank you very much for coming in. Not sure if you've appeared before us before, I can't remember.
No, tēnā koutou. So my name's Andrew Scoulter. I'm appearing for Mr. House, who is a further submitter. And so as such, obviously we were very cognizant of the potential for scope issues that arise from anything we say. But I guess in a nutshell, Mr. House is keen to maintain the level of flexibility that other parties have already referred to the panel. And I guess it's really just a matter of keeping that door a little bit ajar and allowing that to happen. Hopefully that came through in both the evidence from Ms. Thompson, who's with me today, and also in the submissions that I've given. And we're happy to answer any questions you might have on those.
Excellent. Thank you very much. Nice and concise. We'll see if we do have questions for you. Andrew.
I don't have any questions on the legal statement, legal submission.
Okay. Would you prefer it if we take questions on the legal submissions and then on the planning statement separately? Like, were you going to?
I think it would be better, more efficient if we just take all the questions for
and then either the best person can answer them. Okay, so Andrew, so any questions overall?
I was hoping to give myself a bit more time. So paragraph 42 of the Ms. Thompson, your planning evidence. It's just really a question for me. Are you supporting large lot residential on these sites or full urban on these sites?
Supporting large lot residential.
Okay.
I believe that's
which is equivalent to rural residential, basically.
Yeah.
Yeah.
That's one of our difficulties in terms of the scope, because the client hasn't really come to a final decision on that. I think probably urban is the preference, but in terms of when the time comes for them to consider what the actual form of that might be and to really crystallise what they're looking to do, it could be, it depend on the constraints or the circumstances at that time.
And the demand.
And the demand, obviously.
Okay. So I guess in terms of paragraph 24, so with reference to that paragraph, and I guess the issues are around providing for large lot residential, which is akin to rural residential in the Canterbury Regional Policy Statements. I guess whether you have considered the requirements around those areas to be identified through a rural residential strategy and as a forerunner to being zoned in a district plan, and how you've considered that requirement in regards to these particular sites.
I'm not really sure if we have considered the large lot residential. Sorry, could you please repeat that question?
Yeah, I'm just trying to open up the document. So the Canterbury Regional Policy Statement sets out a process for providing for rural residential, in this instance, residential large lot sites in Greater Christchurch. And it provides a pathway for that via a rural residential development strategy prepared under the Local Government Act. And unless it's identified in that, and technically the council has some limitations around providing that type of zoning pattern outside of that strategy. And my question is, had you considered the limitations applied or limitations on the council and on its district plan for that type of zone, given that in terms of whether the sites had been included or not in that rural residential development strategy?
I don't know if I can assist, but I think that the simple answer is probably no. And I think that is down to the circumstance of this particular submission, in that if the occasion arose between now and when development is actually able to be contemplated on a more detailed basis, if there has been further processes that we've able to be part of in terms of local government processes that have allowed us to review, or the council will, I imagine, at some point be looking at reviewing those rural residential type of developments and the constraints and the I suppose the demand and the capacity for them currently, then obviously we would look to be involved in that, and that would obviously direct where we could go in the future. But I think in terms of what we have before us now, we are looking to keep the door open as much as we can, and I think probably via the NPSUD is probably the one way that we can actually look to achieve that for the client.
Thank you for that. No further questions.
Thank you. Lindsay?
Thank you. Just one question of clarification and another question later on. Your paragraph 12, the final sentence there, submissions. Oh, sorry, Ms. Thompson. Sorry, I've got no questions of the legal submissions. But Ms. Thompson, your paragraph 12, submissions also propose rezoning other areas to 3,000 square metre average lot size, not less than 5,000. Is there something missing there? Shouldn't it be, you've got an average of a certain amount, but
that was in reference to one of the other submissions. I can't recall which one it was, but
if you've got an average lot size, surely the minimum lot size will be less than the average lot size.
yes, correct.
So I don't know. I just had a question mark beside it. At the end of the day, it probably doesn't make too much of a.
No, I see what you're saying there. Yep. That might just be an error in my evidence.
Yeah. Okay. No, that's fine. I'm sure that can be tidied up. And then your paragraph 27 about larger lot residential zoning enables rural residential activities and not considered a transition to urban development. What is the purpose of rural residential development then? If it's not seen as a transition, or it's not seen as a middle grounder between full urban and rural.
I mean, I do think it does give that middle ground between rural and urban, but it restricts them to staying within that middle ground. I don't see a rural residential development as a pathway to further urbanisation of that particular area.
But it will never be rural again, will it? As a full rural, it's not there for production purposes.
No, it's not.
Okay.
No production. No.
Thank you. I don't have anything further.
Thank you, Malcolm.
No, I have no questions. Thank you, Chair.
Thank you, Nicole.
No questions, thanks.
Deborah. Deborah, any questions?
Yes, I do have a question, and it just follows on from Lindsay's last point about. Hello?
Yeah, we can hear you.
Can you hear me?
Yes, we can.
Oh, sorry. Yes, I do have a question. Okay. My question is in regards to if rural residential is not seen as a regards to rural production, do you see it as an area where it is more contained to having a large house and a nice garden versus a neighbour that might want to actually have a horse or a couple of sheep with regards to their amenity value? Just trying to tease out a little bit what you are meaning by rural residential with regards to its availability to function, and do we have policies and objectives that allow that to happen?
Yeah, in terms of amenity, I would actually say that rural residential is different to larger lot residential. That rural residential kind of does give that scope for having a sheep and some cows, where I see larger residential lot as having, a larger garden, which could be seen as having a higher level of amenity. In terms of the objectives and policies, do you have anything to jump in with?
Not specifically. And again, because of the limited nature of our submission, we probably haven't canvassed the full range of growth options that might be available under any of those particular scenarios.
Yep, understood.
Okay, thank you.
Mark, any questions?
Yes, thank you. you talked just briefly, you touched on the demand for large lot residential in Selwyn. Do you have any evidence for that? Because the converse is actually, there's been a poor uptake of existing large lot residential zones. In fact, some of them are being applied for to be converted to living zones at present. So it seems to be, the evidence seems to point in the other direction, that there is in fact a dearth of demand. In fact, there's more demand for standard living zones than large lot.
I think you're referring to paragraph 32, is that correct?
I was referring to a comment you just made, but that may well refer to.
Yeah, it's in here as well. That was actually taken from one of the submissions that I was considering. I believe it was.
Okay, well, that's fine if it's it's in a different submission that you're referring to. I guess then the other question I have is to the very preliminary stage of this concept, is that there's been no thought given to the servicing of this area. If we were to have a mind to grant that it could be large lot residential, there's no water, there's no sewer, roading is, you know, this, it would have to come up potentially off Trents. It sort of seems to fail on a whole bunch of criteria that we'd normally expect in an application for this kind of zoning. So any comment?
Again, it's just our client wanting to keep the door very ajar for any future development.
And as we understand it, there is in fact a number of services already provided, almost to the gate of the property on Trents Road, in terms of water and potentially some sewer as well. That's the understanding from the client.
So how much, it might be these matters are better addressed in the subsequent hearing, where the specific proposal will be considered rather than the overall strategic level provisions. Thanks. Raymond, any further questions?
No, no thanks.
Thank you. Yvette?
No, thank you.
Gary? No, thanks. Just a couple, two questions from me. The first one is that right at the start, you referred to an issue of scope. And so I'd invite you to, I'm looking at paragraph 43 of the planning evidence, where you say if the council was to accept the request for rezoning of those parcels you referred to, it would be logical to include another property. So was that the scope issue you're drawing our attention to? Yeah. So again, as with the earlier submitters, I'll give you the opportunity to provide us with a further legal submission or minute outlining why you think we do have scope for that.
No, I continue now. We don't have scope for that. We've not specifically requested any particular rezoning because we didn't have an original submission. Yeah. Therefore, as I say, the intent has been to maintain the door up. And I don't know if it's the proper opportunity, but I want to take the chance while I can. But it's in terms of the MPSUD discussion, certainly the solution that the chair identified with my friends earlier is one that certainly, I don't know if you have read my further submissions, is certainly where I've leant in respect of that. Yes, and we did in fact just prepare just a little bit of some wording that could maybe go with that. I actually went a little bit further than yourself in terms of looking at not only whether or not when the criteria does exist in the future, but also in the meantime, providing an outlet in terms of if you could convince ECAN that you actually were qualifying under whatever criteria it chose to apply, then that would be another avenue that could potentially be as an unless, and to avoid the avoid.
Yeah, well, certainly in that regard, I did find your conclusion at your paragraph 29 of your further legal submissions that were in response to the Adderley Head submissions very interesting, which led me down that train of thought. So if you have any further assistance in that regard, then we'd certainly appreciate receiving that.
You can certainly put up the suggestions we have for the wording.
Yeah, so you don't need to do that now. That could just be provided to our 42A reporting team or to our hearing secretary, and then that can be sent to us. And we'll feed that into our deliberations. All right, but apart from that, no further questions, but thanks very much for coming in.
Thank you.
Thank you.
Right, our last submitter this morning is Horticulture New Zealand, who hopefully are going to be zooming in. couldn't hear what you said then. So it's Lynette online. She just so Lynette, if you can hear us, can you please turn on your microphone and your camera?
You.
There we go.
Right, can you hear me?
Yeah, we can hear you and see you. Good afternoon and welcome.
Good afternoon. I have circulated. I just turned my YouTube off. Are you there?
Yes, we are. Yes.
Yep. I did send Emma a short summary statement for today. I don't know if she circulated it to you or not.
Yes, that's correct.
That's good. I'm not going to read it all, especially in the interest of time, but I just thought it was helpful to where I was particularly responding to your questions that you asked the 42A report writer, where I agreed or didn't agree. I thought it was good to tabulate my response to those issues. So the Hort New Zealand interest in Hearing 3 is the interface between the rural and urban zones, and you've heard a bit about that today, and the rezoning of rural land for urban development, and in particular concern are the areas of highly productive land and also the impacts on urban development on rural production. If I go down to my paragraph 1.5, there was some debate in the 42A report around the definition of versatile soils, and what I'm seeking is that it be extended to include class 3 or as assessed by more detailed site mapping. And the reason for wanting to include class 3 is because it's consistent with the proposed MPS HBL. Now, my latest advice, I think we had a discussion on this earlier, was that that's going to go to Cabinet early next year, so and be issued by the middle of next year. So before the hearings finish, probably the Ministry's staff have got rather involved in writing new legislation rather than MPS. So, but that's just an update where that is. And I thought that there should be a cross-reference to the definition of versatile soil in the Canterbury Regional Policy Statement so that there is some linkage between the two documents. In terms of the Urban Growth Objective 1, it's the 42A report's recommending the addition of an additional clause regarding highly productive land, which I've supported to the inclusion, but have proposed a slightly different wording. Does not compromise the use of highly productive land for rural production. But when I was re-looking at the responses to the hearing panel questions, I've re-reviewed the 42A report on Urban Growth Objective 1 regarding the link to rural production. And a particular note in the 42A report of paragraphs 1111 to 1114, where they discuss both the submission of Fonterra and Hort New Zealand. And there are actually two matters raised in those submissions, but they're actually dealt with as though they're all to do with highly productive land. The report states these two elements, the highly productive land and existing and consented farming practices, are appropriately addressed in the policies, but the overarching objective needs to recognise the soil or productive land in the first instance. I agree with that statement, but in fact the recommend changes to the objective only include the highly productive land, not the existing rural production, which may or may not be highly productive land. And therefore I think the 42A report writer needs to actually give you a recommendation in terms of that statement about needing to recognise those two elements. And it becomes important when you're looking at UGP 10 and 11, where there's not a direct link back to the objective in terms of general rural production, even though this is identified in the 42A report.
Therefore, I would consider it appropriate to accept the Hort New Zealand submission regarding HPL, but also the Fonterra submission to link to existing rural production. I'll skip over policy 8 and go to policy 9, which provides for the recognition of highly productive land when undertaking urban subdivision. Hort New Zealand sought that the policy be amended to strengthen it, and as a result of the hearing panel questions, there's another recommended change. And there's also a question about the use of the wording "to the extent reasonably possible" as being potentially ambiguous. And I note that the phrase is used in the MPS for Electricity Transmission Policy 10, and it has been included in a number of plans to give effect to the MPSET. So, to my experience, there's been no issues raised as to the wording of "to the extent reasonably possible" as yet, but it would be interesting to know if there is some case law or something on it, which we could explore if need be. There's also a question as to whether adjoining rural production is provided for in policy 11, and so it doesn't need to be included in policy 9. While that may be the case, I consider the wording in policy 9 provides an appropriate consideration of adjoining rural production, particularly given the recommended changes to UGP 11 in response to the hearing panel questions. And therefore, I've put there a recommended change to policy 9, which I would support, which is some of the changes recommended in response to questions. In terms of policy 10, it sets out the framework to ensure the establishment of high quality urban environment and considers the interface between rural and urban environment. Hort New Zealand sought that clause 3 be amended to include reverse sensitivity effects, and it's rejected as it's supposedly covered in P11. But again, there are now recommended changes to P11, so we need to make sure that they all interface properly. I do support the change by changing it rural outlook to rural amenity values, because I think that's far better quantified, and that what is to be considered is more than just the outlook and the look of something in terms of policy P10. Policy P11, in my evidence in chief, I still supported the change to include adverse effects, including reverse sensitivity effects. As a result of questions from the hearing panel, the Section 42 report writer has now recommended that this be amended to significant adverse effects. And I note the comments from Ms. McLeod earlier in terms of Transpower in response to this issue. I've reviewed the submissions on UGP 11 and find that no submission sought that the focus be on significant adverse effects. Therefore, I consider that there is no scope for the recommended change. There were submissions that sought the inclusion of adverse effects, but not significant adverse effects. In addition, there is little guidance in the policy framework to determine what may be significant adverse effects, as noted in terms of UG Objective 1. The directive in the policy is to avoid adverse effects, including reverse sensitivity effects on any existing or anticipated activity on an adjoining rural zone. In my opinion, this policy is consistent with RPS Policy 5312, which seeks to avoid development which forecloses the ability to make appropriate use of that land for primary production and results in reverse sensitivity effects that limits or precludes primary production. By amending UGP 11 to significant adverse effects would not give effect to the RPS. Therefore, I do not support the recommended change in the 42A report writer's response to the questions by the hearing panel. And I also note I don't support the option, Ms. McLeod, without seeing it in writing, but from my assessment of what she actually said, her option 3 seemed to have significant adverse effects for everything other than the national grid. And I don't think that's necessarily an appropriate response, but I'd need to actually read her, make sure I've interpreted what she said correctly. In terms of the other matters I've set out there are as in my evidence in chief, and I don't seek any changes other than what I set out in my evidence in chief.
Thank you very much. I'll see if we have questions for you. Andrew.
Thank you, Mr. Chairman. Ms. Wolf, thank you for your evidence. Appreciate that. I have a couple of questions. So in relation to your paragraphs, I think around 5.6, 5.7, 5.8 of your evidence in chief, you talk around what's class 1 and 2 and that how the RPS limits its definition of versatile soils to those, and you talk about the LN 2021 and proposed MPS for high productive land as including class 1, 2 and 3. So I mean, my question for you is, do you think the RPS is out of step with general practice and good practice in New Zealand, and do you have an understanding of what other regional policy statements do in relation to versatile soils or productive land?
There is increasingly, some RPS have limited it to class 1 and 2, but increasingly class 3 or specific classes of class 3 are included, and I'm trying to think which one particular, like there's some subclasses within the class system, and I know one includes class 3E, for instance. I can't remember exactly which plan that is off the top of my head, but certainly some plans have considered class 3 as highly versatile or highly productive.
And so do you think the RPS is out of step though? So not necessarily in relation to other RPSs, but where I guess the general best practice is heading at a strategic or high or central government advice level to include class 3?
I think it potentially is out of step. It's probably a bit out of date in terms of some of the more recent work that's occurred in this space.
Okay, thank you. So paragraph 7.9, and you talk about having, and again, it's in relation to the same thing. So, I mean, do you accept that policy 5 through 12 in the RPS wouldn't apply to class 3 soils? So the whole approach around avoiding, protecting in the RPS and relying on the RPS to provide that support at a district policy level, district plan level, wouldn't actually apply to class 3 if the planning provisions were broadened out in the Selwyn district plan to include class 3. Do you accept there's a disconnect there though in terms of that the RPS support?
No, 5.3.12 is about rural production and isn't specific to avoiding the development, isn't necessarily limited to to the definition of versatile land. As I read it, it's about rural production across Canterbury.
Okay. All right. Well, thank you for clarifying that. And I have no further questions. Thank you.
Thank you. Lindsay.
Good afternoon, Ms. Wolf. Just one question from me, and it relates to policy P9, which is the versatile soils one. I understand what you're saying, and I see the reporting officer has removed the term "and adjoining land," which has been the subject of a number of other submissions as well from that policy.
Yes.
Okay. Do you not see that would mean that could be potentially vast amounts of adjoining land which hasn't got versatile soils but adjoins land with versatile soils could be could mean that there could be no compliance with that policy? Do you look at some of the larger land holdings that there are which may not, which might adjoin areas with versatile soils? Wouldn't that mean it's a no-go completely?
Yeah, look, my caveat on policy 9 is a little bit about what you decide to do about policy 11 and whether adjoining rural land is appropriately addressed in policy 10 and 11. And if they are, that deletion would be appropriate. But if there's not appropriate protection for adjoining rural land in policy 11, then we would want it in 9.
Yeah, they do two different things though, don't they?
Yeah, they do to a certain extent, and I accept that, but we just want to make sure that it's covered somehow. But by adjoining rural land, it would only be where it's adjoining a proposed development.
Okay, all right, thank you.
Thank you. Malcolm?
No, nothing for me, thank you.
Nicole?
Can I just have a point of clarification? I've sort of looked up. So we're talking about the different classes of soils and you're wanting the class 3s included. How do class 3 soils differ from the class 1 and 2? Sorry, my ignorance about it, but just as a clarification.
Without going into a lesson, class 1 are definitely the most have the greatest qualities. Class 3 are still very suitable for horticultural production. So a lot of the land that's used for growing in Selwyn will be class 3 land. So it's got some limitations, and that's where the subclass comes into it, be it an erosion or a water wall. But as I say, I think Miss McClung's evidence on hearing 1, the strategic direction, set out a map with the various class 1, 2 and 3 soils and their attributes and where they are used in Selwyn. So it might be useful to go back to Miss McClung's evidence on hearing 1.
Thank you.
Anything else, Nicole?
No, that's me. Thank you.
Thank you. Deborah?
Yes. Thanks very much for the email you've just sent through. With regards to UG Policy 10, you want to ensure that reverse sensitivity effects do not arise from proximity to rural production activities. Do you see the benefit of having a density buffer zone, shall we call it, where you have high development and then you have a lesser of large lot living, and then maybe you have the term rural residential? Do you see that as addressing reverse sensitivity where it's hard up against, where growth is coming and it's hard up against rural production?
Potentially, but actually some of the biggest reverse sensitivity effects arise out of what's been called here today rural residential. Under the National Planning Standards, it's called rural lifestyle. But it's actually potentially the rural lifestyle that creates greater reverse sensitivity effects in the up against an urban boundary where you can often have a buffer anyway. I think the issue is that people go into the rural area with an expectation of a level of amenity that they then find doesn't equate to some of the rural production that exists around them. And so I'm not sure that it does necessarily create the buffer that you mention. Have you lost me?
No, thank you for that explanation. Given that it's rural lifestyle, it actually causes to have more reverse sensitivity effects. How do you see that we have actually covered, or what's an appropriate buffer that you would like to actually see addressing that amenity effect where development does happen harder?
I just can't, I need to check the submission, but I know in the Hort New Zealand has sought a larger setback for residential dwellings in the subdivision chapter or the rural one, I think they've sought 30 metres. I would need to confirm that, but the intent has been that a larger setback for residential dwellings will assist addressing some of those reverse sensitivity effects, and that will be addressed during the rural hearing.
That's me finished.
Thank you. Mark, any questions?
Yeah, I guess my question is actually more for the reporting officers. If the commissioners were of a mind to include class 3 soils in the definition of highly productive land, what would the implications of that be, particularly with respect to the regional policy statement? Would that make the plan inconsistent? Or if our definition was broader, would it still be consistent with the regional policy statement?
Thank you. Anything else? No. Raywin?
No, thank you.
Viet?
Kia ora, no, thank you.
You, Gary?
One question, thanks, Ms. Wharf. Just in your evidence at 3.2, you said that you've, in undertaking the assessment, you've considered the NPS UDC. I presume you mean the NPS UD.
Yeah, UD, sorry.
You know, that wasn't my, I wasn't going to make an issue of that. I was just keen to know where you have applied, where in your evidence have you given consideration to the national policy statement and coming to any particular conclusions? Is it just a broad assessment? Because I couldn't see any reference to that document in your evidence.
No, I haven't, because it doesn't really address the rural interface issue within that document, which is a concern. So I've just taken the broad principles, but I haven't applied it to any specific provisions because of the lack of detail regarding the rural interface.
All right, no, that's fine. Thank you.
Thank you, Ms. Wolf. I've just got some questions about UGP9, and I'm basing my questions on your summary statement.
Right.
So if you could go to the very last part of your discussion of UGP9, which is just above the heading for UGP10.
Yes.
Yep. And in the words in italics that you say you would support, what does the extent reasonably possible mean?
Well, we've used this in the context of the NPS, but in here there's a protection for that highly productive land from inappropriate growth, but there may be some instances where it may not be appropriate. So that's where an assessment of, well, to what extent can we protect that land, and if there's valid reasons that it is not possible, then they should be considered.
Right, well, thanks for that. That doesn't really help me understand as a decision maker what obligation that would impose on me. And I guess my question to you is based on my thought that those words are quite subjective, and is that appropriate in a policy?
Well, I suppose because it's been used in other legislation, I'm interested to know, and I've asked a question, I haven't got a response yet, as to whether in fact there's some case law that may have actually clarified or furthered that. And if I get any response, I'm happy to share that with you if that would assist.
Okay. All right, thank you. And in terms of that same provision, what does inappropriate urban growth mean?
Well, it's inappropriate urban growth in the context of with its effects on the highly productive land and that policy.
But wouldn't any urban growth on top of highly productive land be inappropriate then in terms of your interests?
Potentially.
So when you wrote that, you weren't thinking of inappropriate urban growth being defined in terms of the urban growth overlay or the RPS provisions or MAP-A or the RPS?
Well, I think you go back to the objective that gives you some direction as to what's appropriate.
And just finally, you've referred to RPS provision 5.3.12. And that provision clause 1A of that talks about avoiding development and or fragmentation which forecloses the ability to make appropriate use of that land for primary production, with that land being the land described in the chapeau of that policy.
Yep.
So my question is, does that RPS wording and the use of the word foreclose actually support a policy provision that has the word protect in it?
I think it does, because I was putting the emphasis on the avoiding the development. Because the foreclosing means a stopping of that ability to be able to use it, which would link to the protection.
All right, thank you. No further questions from me.
Thank you.
Thank you. So now we're going to adjourn for lunch and we're running behind time. So I'm going to suggest that we still reconvene at 1:30, which gives us 40 minutes for lunch, which I think should be plenty of time for people to have something to eat. So we'll reconvene at 1:30. Thank you.
Thank you. I'm Michelle Mallet, Council for the Canterbury Regional Council, and I'm appearing with Ms Scott on my right and Ms Phillips on my left, who have both given evidence, which has been pre-circulated. So I have presented legal submissions in respect of the Strategic Directions chapter, and also in response to I think it was the Carter Group memorandum in respect of that chapter, and those legal submissions are also relevant here. You'll also have my legal submissions of 20 August and further submissions in response to the Adderley Head memorandum. And just in respect of those legal submissions, I just wanted to make one update to those. So since preparing those, I have noticed that the Legislation Act 2019 has now commenced, which does set out how to ascertain the meaning of legislation, and it does apply to secondary legislation, which would include the NPSUD. That is in section 10 of the Act, and it is very similar to the Interpretation Act, where it says the meaning of legislation must be ascertained from its text and in light of its purpose, but it also now specifically refers to and its context. So that is a new addition there. Now, even though there has been this change in legislation, I don't consider that it changes the substance of my submissions or the conclusions that have been reached, but it was something that was brought to my attention on Friday, so I thought best to update the panel in respect of that. So just by way of summary, as is evident through the various legal submissions that you will have received, one of the key issues for the panel is how to give effect to both the NPSUD and the regional policy statement. Integral to this is how the provisions are to be interpreted, and there is a divergence of views on this matter, including whether the responsive planning provisions in the NPSUD are distinct, or whether the NPSUD should be read as a whole. And in my submission, the NPSUD should be read as a whole, and careful attention does need to be given to the way the provisions in the NPSUD are expressed. And in particular, the requirement for local authorities to be responsive, or their decisions to be responsive in certain circumstances, should not be considered in isolation of the other requirements and obligations in the NPSUD. And that includes that local authority decisions are integrated with infrastructure and infrastructure planning and funding decisions, and are strategic over the medium term and long term. And I would reiterate that there is no express direction in the NPSUD to enable or approve unanticipated or out of sequence development. There is no clear direction in the words of the provisions in the NPSUD in that regard. And in my submission to interpret the NPSUD in that way would be to effectively draw a red line through the strategic planning that has been undertaken in Greater Christchurch and the steps that have been taken to respond to this NPSUD and its predecessor. That was all I was going to say by way of summary. But in terms of questions, in your hands, whether you'd like me to address legal questions first or address Alcesa.
I think it might be helpful in this case if we have legal questions or questions arising from the legal submissions first, because a lot of the matters that are at issue here are about interpretation and the weighting to be given to various documents. So I think if we deal with any of those first, and then we'll deal with the evidence after that, if that's okay.
Yes.
So Andrew, any questions arising from the legal submissions?
Thank you, Mr. Chairman. Paragraph 22, thank you for your legal evidence. Paragraph 22
sorry, which?
of your
Original
original submission.
ones.
Submission in chief, evidence in chief.
So paragraph, sorry,
22. So this is date, yep. Got the right one, the absence of the significance criteria. No, sorry, that's the 19th of November.
19th November.
Apologies.
Yes, got that now.
Yeah, apologies for that. I've got a number of windows open. Just clarity around. I'm just interested in how a decision maker would consider applying the criteria around adding significantly if they're not actually in the RPS. Do you have any guidance on what someone would do on an interim basis, or any understanding of, or how a decision maker is supposed to interpret and provide for or consider proposals on the interim basis without those criteria being developed?
And I do understand the challenges associated with that for decision makers. The MFE guidance material does provide some guidance in terms of matters that may be considered. I do also think that in terms of proposals, it will be relatively clear on its face what is, in some circumstances, what is significant and what isn't significant. But there is a question which has been raised by other submitters this morning, I guess, in terms of at what scale are you looking at significance? And in my view, given that the significance criteria is to be included in the regional policy statement, that criteria, in my view, does relate to the urban environment, which is Greater Christchurch.
Okay. So clearly at issue amongst the plethora of legal submissions and other evidence that we're wading through today and will continue to do so tomorrow, there, it appears to be just fundamentally a question around whether or not the RPS, as recently amended, gives effect fully to the NPSUD, or whether it still hasn't quite fully given effect to it. And clearly the arguments focus around policy 8 and the responsive planning framework. Would there be any issue to the urban growth provisions showing a nod to or including a provision lifted directly out of NPSUD, which could clearly show direct line of sight to policy 8, but within the context of the existing urban growth chapter, with all the various restrictions applying, save for that one policy that's such as except in these circumstances? I mean, have you thought of that approach to show that to demonstrate a line of sight in response to all of the submissions that have come in, evidence that we've received?
Yeah, I guess there's two parts to a response to that. And first is, I guess I wouldn't recommend repeating the wording in the NPSUD itself in the district plan without some form of further consideration around that. And the reason I say that is there are various different views on what the provisions in the NPSUD mean. And I don't know that that will get you any further in respect of providing that direct line of sight. For those plan changes, it is a requirement to give effect to both documents. And I think care would really need to be taken in terms of crafting that provision, that it isn't inadvertently giving rise to unconstrained development or ad hoc development, which the RPS has gone through its process to determine where those preferred locations for development, such that development is not being undertaken in an ad hoc way. It is undertaken in an integrated and strategic manner, which is also an objective of the NPSUD. And that's I think the challenge of placing too much focus on the responsive planning provisions in the NPSUD. I think when you bring it up to the objective 6, being responsive is one of 3 clauses in that objective. And I think those first 2 are being overlooked by some with the focus on being responsive.
So, I mean, there is an opportunity for review, and there's the various development capacity assessments that are required through the NPSUD. Is there an opportunity to trigger or consider that responsive policy through that pathway within the context of the urban growth overlay, etc.?
Yes, I think that's another really good point, in that policy 8, in terms of being responsive, is in relation to all local authority decisions. So it's not just about a district plan or a plan change. That would extend to your capacity assessment, but more so your future development strategy. So it's ensuring that you are engaging with developers and landowners as part of that process, and you can be responsive through that process, and also be doing that in an integrated and strategic way.
Okay, thank you. No further questions.
Thank you. Lindsay?
Thank you very much for the legal submissions and the evidence which accompanies it. Obviously, I think you've encapsulated the key tensions that there are, and we're hearing quite a lot of opposing views to yours, in that policy 8 seems to provide some primacy to the responsive planning provisions over and above the strategic provisions that that are contained in the RPS. But in terms of the background to it, and I think this is well explained in the evidence and so forth, that it was largely a matter of timing, that PC1 process, the SPP process, was going along in parallel with the NPSUD. And there was a delay to the SPP process, so it could respond to the NPSUD. So the regional council its bottom line is that it does give effect to the NPSUD. What parts of the NPSUD are out of, apart from policy 8, does PC1, sorry, I might need to recouch this. NPSUD policy 3.8 says there is responsive planning provisions required. Number of submitters have said, okay, that seems to trump the PC1 and particularly the maps. I'm trying to work out which other parts of the NPSUD are particularly in play here over and above the responsive planning provisions. Rather a roundabout question, but hopefully I can, I've explained it well enough.
And yes, in terms of the responsive plan provisions, they are, I guess, 2 and a bit provisions in the NPSUD, and there are other key provisions as well. And in my view, they all work together. In terms of change 1 to the RPS, one of the key policies that we're seeking to implement was policy 2 relating to providing at least sufficient development capacity. And obviously change 1 started in the context of the NPS UDC, but that process was, as you say, delayed so that it could consider and implement the policies in the NPS UD as well. I think and there is a danger in isolating specific provisions in the NPS UD, but I think we can't lose sight of the objective 1 and policy 1 about decisions contributing to well-functioning urban environments, and also the provisions around reductions in greenhouse gas emissions and the effects of climate change.
Is there potentially some middle ground in that a large focus in the hearings today, I don't know whether you've heard that, is been in relation to policy 3 of the urban growth policy 3, which basically says avoid outside of the areas identified in the urban growth overlay. Is there potentially a policy framework which would still fit in with the general intent of the regional policy statement? It could say, well, you leave policy 3 as it is, but you have policy 3A, which looks at a much more integrated focus on those activities which are outside of the urban growth overlay in terms of overall consistency with the RPS. Is there some sort of middle ground which could be investigated from a legal perspective?
So in that respect, it is challenging in the sense that the district plan already does provide for so the further rezoning of future development areas. So it is being responsive and flexible in that regard. And there are some requirements around those to be rezoned. I have considered amending the UGP3 to, I think other submitters have suggested, unless was it provided for by the NPSUD or reflecting wording of the NPSUD. And I guess the difficulty there is with the RPS. The RPS has already worked through where the preferred areas of development are and should be. And I think very careful care and attention would be needed to craft a policy that would still give effect to the RPS and address the submitters' concerns around the responsive framework. And I haven't come up with how that policy may be crafted.
Okay, and in relation to the criteria which are to be developed, presumably it's a work in progress, and it's understandable that it's a work in progress, but presumably they'll be aimed to be, well, they're certainly required to be consistent with what the NPSUD requires, particularly in terms of well-functioning urban environments, all the good stuff about locating, in relation to infrastructure provision. So those criteria are work in progress, and are they? When are they likely to see the light of day? Do you know?
And as far as I know, it was to be intended as part of the review of the RPS.
So 2024.
Yeah, unless that's my understanding. And I would say with the significance criteria, the way the NPSUD is framed, so that criteria is separate to whether a plan change, for instance, would contribute to a well-functioning urban environment and is well connected along transport corridors. They are separate considerations to the significance criteria, and that significance criteria, I think, is dealt with in a couple of different ways in the NPS, but in respect of clause 3.8 and in respect of plan changes, if you do make that significance criteria, then it means that the local authority must have particular regard to the development capacity provided. So that's if you meet the criteria and if it contributes to a well-functioning urban environment and is well connected along transport corridors. So I do wonder whether the significance criteria is being there's different opinions as to what might be included in that significance criteria, whether it is in relation to capacity or something more broad than that.
So do you think that the submitters who are concerned that there is no significance criteria have potentially overinflated that issue?
I think in respect of how that significance criteria is applied within clause 3.8 in respect of plan changes.
Okay.
And we've seen that plan changes are progressing in the absence of that criteria at present.
Okay. All right. Thank you, Chair.
The consideration of plan changes.
Consideration of plan changes. And it's a little bit hard to keep up with what's happening with some of the plan changes and so on as well. But I appreciate your comments. Thank you.
Malcolm?
No, nothing from me, thanks. Chair.
Nicole?
Nothing from me either, thanks.
Thanks. Deborah?
I just have one question, and it's clarification around climate change. When you're considering climate change, what aspects are you considering? Is there, when we're talking about climate change, can you please explain to me what the characteristics are?
When we're talking about climate change in respect of the NPSUD?
Just assume that's the case.
Okay, yeah, so in that respect, it is, so looking at the provisions of the NPSUD, it's around urban environments being resilient to the current and future effects of climate change. And also that when you are making planning decisions, that decision makers have particular regard to the likely current and future effects of climate change.
So just with regards to looking at the climate change, do you see a crossover with natural hazards with regards to intense rainfall versus dry weather conditions?
I do, in the sense that there is an overlap between the effects of climate change that do result in natural hazards. So the effects, so in terms of, for instance, sea level rise and giving rise to inundation. And coastal erosion.
Thank you.
Okay.
Thank you.
Thank you. In your view, or in ECAN's view, does the lack of the assessment criteria make it harder for plan changes outside of the urban growth overlay to argue their case? you're saying that the regional policy statement gives full effect to the NPSUD, but without the assessment criteria, we have submitters that are arguing it isn't complete, it isn't giving full effect, it's giving partial effect, and therefore we should have the unless clause has been kind of discussed, because that the absence of that criteria just could potentially, you have the black and white argument, it's not on the overlay, go away. What's your response to that?
So I think it would be easier for plan change applicants in terms of preparing their applications if there were criteria in the RPS, because there'd be criteria that they could refer to. I think in terms of the having an absence of criteria, then it's a matter of undertaking their own assessment as to significance without reference to the RPS. So I do, it is acknowledged that the RPS gives effect to the NPSUD in part, say, for the significance criteria. Stumbling on my words there, but the absence of those criteria, significance can still be considered, but the absence of that criteria doesn't enable or provide a reason to, in my view, provide more flexibility or enable growth outside of identified areas.
I guess it's acknowledging that it puts us in a dilemma, that we have some who would argue that while we need to give effect to both documents, if the regional policy statement didn't give full effect, how do we give full effect to both when one doesn't? So would you support, I guess I'm trying to clarify in my mind, that kind of reasoning that's been discussed earlier of having with the exception of, or allowing consideration of the NPS until ECAN has got such criteria in the regional policy statement? Because potentially if you're talking a regional policy statement in 2024, it could be 2026 before it has full effect. So we're talking potentially a gap, a considerable gap for development in this area.
Yeah, at this time. In terms of providing any guidance in the district plan around that criteria, simply reference to the NPSUD, I don't think takes the provisions any further. Having said that, trying to craft that criteria now and insert it in the district plan, I think is preempting that exercise to come, and the NPS is specific around that criteria being set in the RPS. And in my view, in the context of Greater Christchurch being a Tier 1 urban environment, the criteria being at that Greater Christchurch level.
So what do we do in the interim?
And I understand that presents a challenge, and through plan change applications, there are, I guess, evidence and legal submissions around what is significant and what isn't. And it's obviously that's not an ideal scenario, and it's a function of timing, unfortunately.
Yeah, thank you.
Raymond?
Yes, I just have one question. In the Adderley Head submission, they talked about the responsive planning framework being distinct. Can you explain to me what is meant by that, the word distinct? Because when I read it, I didn't see that it was distinguishable from anything, from any other part.
Yes, and I think in terms of that opinion that it is distinct, I took that as meaning you could consider those provisions in the absence of the rest of the NPSUD, and I think that is a flawed approach to interpreting the NPSUD, as I do think it all works together.
Okay, thank you.
Yvette?
No, thank you.
Okay, Gary. I just got one question for you. I'm not sure if you were listening to this morning's.
Most of it.
So I had floated with one of the submitters the option of amending UGP3 to have an unless provision. And at that stage, I floated potential words that went along the lines of unless it was consistent with criteria in the RPS, without specifying what those criteria would be. But just listening to your answer to some of the questions now, would it be more appropriate if we were to have an unless policy, that it would say unless applicants demonstrate that the zoning will add significantly to development capacity, which I think you said the onus would be on them to demonstrate that?
I think if the panel was minded to have an unless policy, it would need to include that, but it would also need to include reference to the other requirements in the NPSUD as well.
Well-functioning urban environments, integrated infrastructure planning and funding decisions, and being strategic over the medium and long term.
And being connected with transport corridors. So there are all of those other considerations as well, not just the significance criteria.
Yeah. I think you well understand the conundrum that we have where we need to give effect to superior instruments, and we need to find a way through that.
Yes, and I would say there has been some discussion around giving effect to the NPSUD because it is the later document in time. And I would add that the RPS has been changed since the NPSUD, and that has gone through a process that was signed off by the minister. So I don't think it's correct to say that because the NPSUD is the later in time document, that should be given more weight because the RPS has taken steps to implement it.
Yeah. Okay, so I just had a couple of questions arising from your 19 November legal submissions, which were the ones you put forward in response to the Adderley Head memorandum. So paragraph 18, you talk about in limited circumstances there in the second line.
Mm-hmm.
So are they the matters that we just discussed in the previous answer?
Yes.
Yeah. Yeah, okay. And my final question in terms of the legal submissions was the very last paragraph of that 19 November suite of submissions, the paragraph 23. And the very last part of the last sentence, by identifying additional greenfield areas for development, does that mean beyond those that are in MAP A in the RPS? Is that what you meant by that wording?
That the councils have responded to a potential shortfall in capacity, and it should be by identifying future development areas rather than it.
Yeah, but is that MAP A or is that something different?
That's the FDAs that are identified in MAP A.
It's MAP A, so that's what you were referring to there. Yeah. Okay. All right, well, no further questions for me, but thank you very much for your series of legal submissions, which we have found to be extremely helpful and detailed. So thank you for that. So we just have whichever witnesses.
Yes, so I think Ms. Scott, I think if anyone has questions.
So Ms. Scott, do you want to say anything by way of summary, or are you happy to go straight to questions?
It was fairly brief evidence, so I think we can go straight to questions.
Excellent, thank you. Andrew, any questions?
Thank you for your evidence. I just have one question. Paragraph 24, I think you say various studies have noted high failure rates and inadequate maintenance of on-site systems, whereas centralised systems are usually better maintained and monitored. And I'm just wondering, do you have any comments on the scale of systems that fail? Because you're talking about on-site for one house, or you're talking about on-site for 3 or 4 houses, or you're talking 10 or 15 houses? What is the scale for on-site systems? Because I'm also aware in other districts that community schemes with 15 or so houses also often have maintenance issues and fail. So I'm just interested in your professional views on the scale of these these treatment systems, and if there is a scale where we're more likely to fail or less likely to fail?
I guess any system can fail, but with on-site systems, I was just referring to systems that serve single properties. And just the reference I gave there sort of had some numbers. It sort of varies, but some studies have had failure rates of about 29% all the way up to, I think, 77% for on-site systems.
Okay, thank you. Thank you.
Thank you. Lindsay, any questions? Ms. Scott?
No, I don't. Thank you.
Thank you. Malcolm? No. Nicole?
No, thanks.
Deborah?
No, thanks.
Cool. Mark?
No, thank you.
Thanks. Raywin?
No, thanks.
Yvette?
No, thank you.
Gary? And no questions of clarification either from me, but thank you very much for your evidence.
And we now have Ms. Phillips.
Hi, I haven't prepared a separate summary statement in addition to the summary that was provided with my evidence, but there were a couple of points that I thought I might pick up on just from listening this
Just want
morning.
to swing the microphone around a bit closely. Great, thank you.
Most of which have already been covered off by Ms. Mallett, but just to reiterate, so the first point was just that the Regional Council is generally really supportive of the proposed urban growth chapter and the proposed Selwyn District Plan as a whole. Hopefully that came across in my written evidence. So just picking up on some of the points from this morning, in my opinion, the regional policy statement gives effect to the NPSUD with the exception of the insertion of criteria for significant development capacity. But the absence of criteria in the RPS does not, in my opinion, prevent the consideration of the merits of unanticipated or out of sequence plan changes. Ahead of the inclusion of criteria in the RPS, the Ministry for the Environment guidance on the responsive planning policies provides quantitative and qualitative factors to determine what constitutes significant development capacity. I also note that while the NPSUD requires local authorities to be responsive to plan changes, that is only if relevant requests satisfy certain criteria set out in 3.8 and other parts of the NPS. There is nothing to express or inherent in the NPSUD, as far as I can see, that demands flexibility more generally to enable urban growth. The NPS places emphasis on integrated and strategic decision-making to achieve well-functioning urban environments. It does not, in my opinion, warrant the enablement of unconstrained growth in the proposed Selwyn District Plan outside of the areas already identified in the RPS and also through the urban growth overlay. I'm happy to take any further questions.
Yeah, thank you. And I see you were reading out that statement there. Would you be able to take the trouble to type that out and provide it to our hearing secretary, and then we can all be provided with a copy of it?
Yes.
Thank you. I'll see if we have questions for you. Andrew.
Thanks, Mr. Chairman. Thank you for your evidence. So there's been a comment today, and I see, for instance, in your paragraph 63, and you talk about with change one, there's sufficient housing capacity across Greater Christchurch to meet expected demand in the medium and long term. And you talk about Selwyn District predicted sufficiency shortfall. So my question is, a comment was raised earlier around the need to provide supply in each town, as opposed to at a district, or as opposed to at a Greater Christchurch level. And do you have a comment on that? Do you think it's necessary to provide capacity in each town in Greater Christchurch?
No, that's not the way I read the NPSUD. And also note somewhere, I'm not sure if it's in the NPS or in some of the supplementary guidance, it actually leaves it to local authorities to determine the scale of location where it refers to providing for capacity in certain locations. But I don't think that necessarily requires it to be provided by township.
Thank you. To Council. Just in relation to policy 7, and there's the question around the changes around referring to, I guess it's planned or future. Planned or future strategic transport requirements. And I think you prefer future. And you talk about the author has recommended a wording change on the basis that the use of the word future is too uncertain, whereas the term plan is more appropriate. I consider the wording sought by the council is appropriate. I'm just interested in your thoughts on that. And clearly that's the position that you hold. So what could future entail? And is it within a 30-year time period or a 100-year time period, or do you have a context around future in your mind when you make this statement?
Not specifically in terms of the time frame, but I would think that when somebody was looking at that policy and how it might be implemented, they might refer to other documents, for example, the regional public transport plan or the regional land transport plan, to identify what might be required to meet future strategic transport requirements. To me, the word planned is more specific, that it would need to be an actual planned sort of piece of strategic infrastructure, whereas future could be anticipating something that might come forward, might be being considered through a business case or otherwise by sub-regionally or regionally or by the district council.
Sure, but the examples you provided around that someone might refer to a regional land transport strategy or those other documents would, that is an example of where it is planned in those, isn't it, in those documents?
I think some of it is planned. My understanding was that some might be sort of future anticipated projects.
Okay, so you didn't have a 30-year horizon or any particular time frame in that. It's just you prefer the word future because it provides a bit more flexibility.
Yes.
Okay. So paragraph 103, this is my final question. It's the 15 households per hectare issue and the recommendation in the Harrison and Grierson report. So I'm not sure if you've read any of the evidence provided by other submitters around the difficulties of providing 15 households and the questions around whether it meets market demand, and around 12 being far more desirable. Do you have any comments on that? I mean, you said in here you support or you agree with the officer's recommendation for 15 households per hectare, and you refer to that Harrison and Grierson report. But do you have any more comments on why you support that, or any rebuttal, I guess, of those other comments that it's too dense?
I don't have any specific rebuttal against the comments that it's too dense, but I do note that the way the policy is proposed to be worded does enable consideration being given for 12 households per hectare where constraints have been demonstrated on a particular site. In terms of support for 15 households per hectare, I mean, the regional policy statement currently requires a minimum of 10. So in terms of giving effect to the RPS, it certainly achieves that, in my opinion. Mm-hmm. And then the policy 6.3.12, which relates to the future development areas, also supports higher densities being considered within those areas, and that's in recognition of the benefits of high density development in terms of making more efficient use of land, sure. Reducing greenhouse gas emissions because it can support the uptake of public transport, okay. Reduce urban sprawl onto versatile soils, all those planning outcomes.
Sure. So again, just helping the panel out then. So I'm not sure if we've got evidence presented as such to us around the appropriateness or otherwise of 15 households, and other than evidence such as yourself. But I mean, did the Harrison Grierson report, did it actually assess specific developments around Greater Christchurch and demonstrate that 15 households can be delivered? And other than just a recommendation.
My recollection is it looks at some specific examples that have been built out. And that have achieved higher density, so around the sort of 13 to 15 households per hectare. That's my recollection of the report.
Thank you. Appreciate that. Was a challenging question. Thank you for no further questions.
Thank you. Lindsay?
Sorry, excuse
Sorry.
me, Chair, if I could
Yeah.
just close out one of the questions you had. Ms. Phillips was referring to where local authorities may determine what the locations are. So clause 3.2.4 in the NPSUD.
Okay.
So clause 2 sets out that local authorities may identify locations in any way they choose.
Thank you.
All right, Lindsay?
Yeah, thank you for your evidence. It's quite thought-provoking what we've actually been tasked with dealing with here. Just that the final discussion with Commissioner Willis about housing numbers per hectare and the relationship with policy 13. Now they've come out of a piece of work which says these are the sorts of densities which are going to be required over time. When I was reading that policy, I thought, why is this so prescriptive? Why does there need to be a regional emphasis upon achieving a level of density? Have you got any background to where that came from over and above the housing density assessments which have been done? Well, is there a reason why there's a magic number?
By magic, do you mean the number that's in policy P13? That's Selwyn District?
Well, it's policy P13, but you mentioned that's come out of a minimum of, what was it, 10 households per hectare in the RPS. Obviously, the residential areas in particular, whether they're in the urban growth area or existing residential, there's a move to intensify and so forth. I'm just wondering why there's a need to have a very specific target in there. It could be expressed a different way, that there are development densities which provide for greater range of housing types and housing styles, rather than the potentially single-story houses on large lots. Is there some necessity to have numbers in there in a policy?
I suppose it provides a minimum standard, a sort of benchmark or threshold, and then within that, developers are able to provide different housing typologies based on the market preference, and also taking into account relevant policy provisions. I don't know where the minimum for 10 came from, other than Chapter 6 was inserted by way of the LERT. So that has been in the RPS since 2013. And I note that the 15 households per hectare for greenfield areas is the requirement in the RPS for Christchurch City. So
so presumably that would get applied to those areas within Greater Christchurch, within Selwyn as well.
So my understanding is that's what the policy in the proposed Selwyn District Plan is seeking to do. So
yes,
a minimum of 15, unless it can be demonstrated there are constraints, in which case 12 should be achieved.
You're obviously involved in the Plan Change 1 process. Is that right throughout the process, from initiation through to the Minister signing it off?
Yes.
Okay, and during that process, there was a delay in order for the Regional Council to consider the provisions of the new NPSUD?
That's right, yeah.
Okay, and in terms of that process, was there a specific question or a specific recommendation made to the Minister that in making a decision on PC1 and inserting Map A into the RPS, that gave effect to all of the provisions of the NPSUD?
So when we submitted the recommendation report to the Minister on Plan Change 1 to the RPS, we were required to set out in an appendix the ways in which the proposed change gave effect to the NPSUD.
Yeah, and that's encompassed in the appendix to the legal submissions.
I believe so.
That document, yeah. But I guess, well, because we had the minister acting in two functions here, we had in terms of promotion of the NPS, as well as being the entity which is approving the SPP process and the outcome of the SPP's process, which were running not quite in parallel, but almost in parallel.
Yes. There was acknowledgement in the recommendations report that it wasn't possible to
do the criteria.
Yes.
Okay. Well, that's helpful because, we are getting a lot of contrary submissions that basically the NPSUD is overriding PC1. And I understand the Regional Council's position is that is not the case. It was done in the knowledge that the NPSUD was had been formulated.
Yes, yeah.
And you would have heard the discussion that the chair had with your legal representatives about the potential amendments to that there may be to policy UG3, which is an avoid policy as it's written at the moment. Because I think that everybody's fairly clear from King Salmon days about the implications of avoid policies and what they mean. But I understood from an answer to a previous question from Commissioner Willis that there is still potentially with that avoid policy in place for an applicant through plan change to make their case under the responsive planning provisions. And if that is the case, how would that sit with the very directive policy that it is, that PG3 is at the moment, particularly in terms of avoiding those areas out of the urban growth overlay?
Okay. Sorry, it was quite a long question. Yes, so I do think that the NPSUD provides a pathway for plan changes that aren't anticipated by our planning documents or are out of sequence to be considered. So in terms of out of sequence, the change to the RPS or to MAP A and the RPS already enables development that might be considered to be out of sequence to be considered where it's within a future development area. We've got a number of private plan changes that have already been accepted by Selwyn District Council for processing and have been notified based on the Policy 8 response.
Okay, so they're outside of the PC1 map A.
And a number of them are. There's a mix. There's quite a number within the future development area in Rolleston, and there's also a number that fall outside the projected infrastructure boundary.
Yeah, well, where I basically have some concern is that you've got something which is very directive, which is the map, and then you've got something which is very potentially open-ended in terms of the responsive planning framework, and the district plan has to reconcile those two particular things. And if they are to be reconciled and to give guidance to decision makers, which is what I often think about in terms of reading the policy. If I have this particular development scenario put in front of me and I'm looking at the objectives and policies and there's a case of conflict, where do I go in terms of a decision? And with policy 3, UG3, it is very directive at the moment that you avoid going outside of those urban growth overlays. So where is the policy direction apart from the policy 8 in the NPSUD, which says that local authorities have to be responsive? I think you and legal counsel have covered that, but it's still very high in my mind that there isn't that ability to be able to reconcile the RPS and the NPSUD with what we have at the moment. Do you have any comment on that?
I agree. It's difficult. I haven't given specific consideration to the wording that was suggested this morning. But I do note that the regional policy statement has the objective and policy around directing growth to particular locations unless otherwise expressly provided for in the RPS.
So some of these, but some of these plan changes which are outside of the urban growth area are not expressly provided for in the RPS, are they?
Not currently, no.
No. So therefore you've got an automatic policy barrier to be able to consider and then potentially approve those plan changes outside of the plan change, the map A area.
Yes, I mean, that is something that the decision makers on those plan changes will have to reconcile, is the direction in the regional policy statement and the responsive or policy 8 in the MPSUD.
Yeah, I think it's not only the decision makers on those plan changes, it's us in terms of considering the submissions that there are on the urban growth provisions here as well, because there's a real tension, and what I'm really trying to work through is how to be able to give effect to the RPS while also being able to give a nod to those or give some sort of methodology about the way you would deal with out of sequence developments in terms of the responsive planning provisions. So you probably don't need to answer that. It was more a statement than a question, but
Correct.
Thank you, Chair. All right. I have no further questions, and thank you for your evidence.
Great. Malcolm.
No, I have no further questions. Thank you for the evidence you've given. It is a quagmire, as Lindsay has said in not so many words. Nothing further to ask.
Thank you. Nicole?
I agree with the two previous speakers about this whole housing thing, and obviously we've got, and this is just a statement, but obviously we've got the government's enabling housing supply thing going through as well, which will potentially affect any numbers that we try and put in our plan anyway around density. But that's me finished. Thanks.
Thank you. Deborah?
Yes, I've got one question. Where do you see rural residential? Is it inside map A or outside map A with regards to looking at housing density? That's under the regional policy statement.
So some of the rural residential areas will be within the area shown on map A as part of Greater Christchurch, but in general, my understanding is rural residential areas that have been identified sit outside the greenfield priority areas and the future development areas that are shown on map A. Does that answer?
So with regards to rural residential, just for clarification, large lot living, would that be included in map A and say the rural residential 1 to 2 hectares located outside at map A? How are you interpreting that rural residential standard?
So is this in regard to policy P13, which talks about...
That's correct. Sorry, I should have actually mentioned, yeah, with regards to density, yes.
So my understanding is that the urban growth overlay identifies areas that are shown as greenfield priority areas, or perhaps not the GPAs, but the future development areas on map A, and in addition shows areas shown in the adopted rural residential strategies for rural residential development. So I had understood that within the urban growth overlay, there are areas shown for rural residential development that aren't shown on map A.
Okay, thank you.
Thank you. Just seeking clarification what you said in your opening statement about the absence of criteria in the regional policy statement doesn't prevent consideration of out-of-sequence plan changes. That's within the context of being within the urban growth overlay. The out-of-sequence plan changes being within the urban growth overlay rather than the number we've got that are outside?
Yes, so I suppose I think of out of sequence plan changes being coming forward ahead of when they were anticipated to come forward. So I feel like in Rolleston, there could be some areas within the Rolleston future development area that were identified in the Rolleston structure plan or elsewhere as coming forward later, but now could be considered earlier because they've been identified as an FDA in the RPS.
Right. So that those that are outside of the FDA or our urban growth overlay are not, you weren't including those in that consideration.
I think that the NPSUD does provide a pathway for those applications to be considered, but I acknowledge it's problematic because you might be in a situation where you're considering a proposed plan change that identifies a site for rezoning that doesn't align with MAP-A, so it wouldn't be giving effect to that RPS.
And we have quite a number of those, and that's where I come back to the absence of the criteria, and I come sort of the fact that, and I guess I want to tease out a little bit why in the plan change 1 changes there wasn't the criteria, because it would clearly seem that would have been ever so helpful if they'd been included in that change, and we wouldn't be having a lot of these discussions, because there'd be a set of criteria that these could be assessed against. And I guess you're able to sort of educate me a little on how that it didn't happen.
So the plan change 1 to the RPS was initiated before the NPSUD came in. So we applied to, well, the Environment Canterbury applied to use the streamlined planning process for the purpose of giving effect to the previous National Policy Statement on Urban Development Capacity, because through the Our Space, the Future Development Strategy for Greater Christchurch, through that process, it had been identified that there was potentially a shortfall in development capacity in Selwyn and also in Waimakariri over the medium to long term. So change 1 was to identify future development areas so that the district councils could then look to rezone some land to address that potential shortfall through their district plan processes. When the NPSUD was gazetted, we were already partway through the minister's streamlined planning process that he had directed. We did pause the process so that we could consider and review the NPSUD, but it was considered that the introduction of criteria to determine what would be considered significant development criteria would fall outside the scope of what we had applied to use the streamlined planning process for. And it would also require further consultation and engagement that was unlikely to be able to be achieved within the timeframe that we had in the minister's direction for completing the process. There's also the complication that we will be required to provide the significant development criteria for areas outside of Greater Christchurch, so Timaru and Ashburton, which will be urban environments too.
So there's no opportunity in the interim between now and the full review of the regional policy statement to get that criteria made, I guess, is sort of.
There would need to be a separate RMA process initiated. So it's not impossible, but it would be a decision for.
It's probably above this witness's pay grade. So.
Well, I'm questioning, thank you, Mr. Chair, I'm questioning the process and not necessarily implying that the witness has the power to sort of create it, but it had to be lobbied at a more political level, perhaps at ECAN level, to get it through the process. Thank you. You've answered the question.
Thank you. Raymond?
No, thank you.
And Divette?
No, thank you.
Eric?
Just one question, thanks. Yeah, I just wanted to be clear on the Regional Council's position with respect to change 1, whether it gives full effect or partial effect to the NPSUD. And the reason I'm asking that is the solicitor for Michael House has quoted the reasons in the decision, which state that the proposed change gives effect to the NPSUD in part and to the extent it is reasonably practicable. So I'm just not sure whether that was taken out of context or whether what the council's position is on that.
Well, in my view, the RPS gives effect to the NPSUD other than the requirement to insert the criteria to determine significant development capacity.
Which is a reasonably important distinction.
It is, but the MPSUD requires regional councils to insert that criteria as soon as reasonably
Right.
practicable.
Yeah.
So,
Okay. That puts it in context. Thank you.
Thank you. I just got 4 questions for you, but first of all, thank you for your evidence. It's very comprehensive and helpful. Paragraph 63. And I'm looking at the sentence near the bottom of page 18 that says it only requires development capacity over the medium term to be zoned in a proposed district plan. And that raises a question in my mind. Does that mean that this council's urban growth overlay should be an urban growth zone?
I wasn't saying that. I suppose that might be a question better for Selwyn District Council to respond to. I mean, that is a requirement, as I understand it, in the MPSUD, is that for it to be considered to be medium-term capacity, it should be zoned.
Yeah.
I do note that there are a number of private plan changes within the future development area that would provide additional capacity. And also, I haven't looked at whether that additional capacity plus the intensification provisions that Selwyn's looking at would address the shortfall that was identified through the capacity assessment.
So is that a yes or no or a maybe?
In relation to whether I think it should be a zone,
Yeah, from your planning perspective.
I would say potentially, but I imagine that Selwyn District Council will be looking at that. With all the private plan changes, I imagine it would be quite difficult to decide which area to zone.
Yeah.
To meet that capacity shortfall.
Right.
If any greenfield land is necessary.
Yep. Can we have that addressed in the reply report, please? And can you refer back to MPSUD policy 3 or section 3.4 bracket 1 bracket B in terms of context for that question? I think Kaingaora has raised a similar issue in their submissions as well. Turning to para 77. And the issue that you pose there is the solution, the one set out at your paragraph 100. If you want to just quickly flick to that.
That could be considered, I think.
Yep. So in the reply report, can we please have a specific response to that in terms of the issue raised at para 77 and the solution posed at para 100? And Commissioner Deborah also referred, I think, to the same issue. Just 2 last questions. They relate to UGP9. Which is the highly productive land or versatile soils provision. Does the RPS support a policy provision that would commence with the word protect? And if you want to go away and think about that and come back with a written answer, I'm more than happy for that.
Okay, thank you. Yes.
As far as I can tell, the provisions in the RPS talk about not foreclosing opportunities to use versatile, highly productive land, not those exact words, but I'm not sure I found a protect provision in there. And secondly, in terms of that provision, what would an appropriate subdivision be, do you think?
Sorry, I just wanted to flip back to that original wording. Just going back to your previous question, I think where I referred to the policy possibly being simpler to just say protect, that was in response to my concern that to the extent reasonably possible was a bit ambiguous. But in terms of inappropriate urban growth. I had thought that that could tie into the other objectives and policies within that chapter.
Right. But still appreciate just some further consideration of the word protect, and if there's any RPS support for it, and if not, what appropriate wording that does give effect to the RPS might be. There's a range of wording kind of suggestions in front of us. And
sure.
Yeah. Just protect has a quite strong meaning, which I'm not saying is inappropriate. I'm just wondering if there's RPS support for it. And we floated, well, and other commissioners have floated the possibility of amending District Plan Policy UGP3 to roll in an unless provision, which is more or less to provide a gateway for dealing with, or to be responsive to plan change requests that aren't within the urban growth overlay, or etc. Just thinking about that some more though, even if we did do that, would a decision maker nevertheless be faced with the avoid policy in the RPS, which would defeat an application no matter what the district plan said about that?
After the significance criteria has been inserted?
No,
or
before. So we've talked about possibly softening UGP3 to try and give effect to the RPS and the MPS. But even if we did that, the RPS would still say what it says now, which is to avoid those types of rezoning proposals. So I'm just wondering where that might even get us.
Unless I suppose unless a companion change was sought to the RPS.
Yeah, which only local authority can do, can't it? Yeah, which we certainly can't do as a panel. But all right, interesting. Not an easy issue. Thank you very much.
Thank you. Great. That was all from the Regional Council, and we'll ensure to provide that response around the protect working in the RPS.
It's not a huge issue, just interested in the answer. Right, moving right along. Urban estates, etc. So good afternoon and welcome. I think you've appeared before us before, so you know the drill. We've read the pre-circulated material. Thank you very much for providing that, but you're very welcome now to highlight key points for us, and then we'll see if we have questions for you.
Okay, so I've just got a bit of a summary here. Is that okay?
Your pardon?
I've got a bit of a summary here.
Yep, sure.
Sure. Not exactly like relief, but I'm just thinking, since we've been talking at a very high level, I've recently the government released this policy statement, a government policy statement on housing and urban development. And I'll just briefly quote one section that says, over the past few decades, Aotearoa New Zealand has failed to consistently build enough homes of the right sizes and types in the right places, which are affordable for households on low to moderate incomes. During this time, the housing market has generally failed to respond to changes in demand for housing in different places, including as a result of population and demographic change, evolving household composition and preferences, and changes in local economic conditions and incomes. The mismatch of housing supply with local demand for homes has fueled high house prices and rents, contributed to growing rates of housing stress and homelessness. So that, to me, that's something we need to keep an eye on. Okay, I am here on behalf of Urban Holdings, Suburban Estates and Kenbro have joined together to obtain residential zoning of an important block of land in South Prebbleton. This block is bounded by Springs Road, Trents, Shands and Hamptons. At the eastern end of this block is Stirling Park, which is 22 hectares in area and rezoned Living Z through the Environment Court appeals on the previous district plan review. This area is now fully developed and there are a number of streets on the west side of Stirling Park that have been formed to extend through to the adjoining land, which is the land we're talking about today, presumably with the council anticipating its future residential zoning. It is the only large block bordering the current township of Prebbleton that can provide for significant residential development, including incorporating substantial medium density development. This is significant as Prebbleton has almost no medium density housing and has relatively large minimum and average lot sizes of between about 700 to 800 square metres. This fact and the lack of new areas for expansion has resulted in Prebbleton being less affordable than other towns in Selwyn district, as there are limited sections available and few intensification options. This is detailed in the unique economics assessment that accompanies the Plan Change 68 request. The submitters are seeking recognition of the suitability of the block to provide for the growth of Prebbleton by its identification as an urban growth overlay area. The Section 42A report comments that the urban growth overlay applies to land that's identified within a development plan. The analysis here is not whether a new urban growth areas have merits, but whether it is identified as within an approved development plan as being potentially suitable. Then lists a number of submitters, including Urban Holdings. As these sites are outside any of the development plans, the land should not be included as it does not fit the criteria outlined in the chapter. They therefore recommended that the submissions be rejected. Firstly, this is simply not correct, as the central area of the Prebbleton block is within a development plan and in fact is covered by the urban growth overlay. This is an area of nearly 22 hectares, which has been included because it was identified in the 2014 Rural Residential Strategy. This strategy is recognised as a development plan as defined in the proposed plan. The submitters are seeking that the remainder of the block is included in the urban growth overlay, recognising that it's very well located for residential purposes, connects directly with an established residential area, and that its use is far more efficient than rural residential. This matter is actually recognised in the Rural Residential Strategy, as it requires any rural development on this particular area to be future-proofed to enable it to develop for full residential densities. The second point I'd like to make is to briefly address the manner in which Prebbleton has been treated with regard to provision for growth. I say here, a bit like a poor cousin. I was involved in submissions on the current district plan, including appeals to the Environment Court. This process provided for the rezoning of Stirling Park, and the court agreed with the council that Prebbleton should grow to the east and west of Springs Road, but not south, so to retain its compact character. At the time, however, there was a major restraint on Prebbleton because it was reliant on sending its sewage to Christchurch City, and the city had set a limit on the number of households it would service. This resulted in Prebbleton not being considered for growth by the District Council, and I presume this was the basis for the limited urban development strategy boundaries during the period up to and following the earthquakes. However, Prebbleton is no longer limited as it's part of the Eastern Selwyn sewage system, which is a fully reticulated system, taking the sewage from Prebbleton to the Pines and Rolleston for treatment and discharge. This occurred in 2011. This significant change has not been reflected in planning documents in a meaningful way, despite the fact that Prebbleton is very close to Christchurch City, and in fact, closer to a number of its own suburbs, and so commuting is relatively efficient. In my opinion, basing the location of urban growth overlays for Prebbleton in 2021 purely on what constitute development plans is not robust or appropriate, as these plans have not been reviewed since 2014 in the case of rural residential development and 2010 for the Prebbleton structure plan. These plans are very out of date and could not possibly be considered to implement the NPS urban development. This request should therefore be assessed on housing and growth needs in urban form, not on dated policy and plans. I've set out in paragraph 15 of my evidence the reasons for and benefits of including the submitter's land in the urban growth overlay as a precursor to zoning.
Thank you. Now I see you're reading out a statement there. Have you provided that to our hearing secretary?
No.
No, can you email it in to our hearing secretary, then we can have a copy of that
sure.
for our when we come to think about these matters. Right, let's see if we have questions for you. Andrew?
No questions from me, thank you.
Lindsay?
Just the one. The main thrust of the submission and evidence is in relation to the urban growth overlay. Did you have any comment or on the objectives and policies that which apply to urban growth?
No.
Well, if you haven't got a submission on it, you don't need to comment. But
there were further submissions that I put in relate for the same submitter, generally supporting the use of an overlay as an indicator of places where urban growth was suitable. We didn't go to the full extent of doing a full analysis of that. We see that there's merit. So I guess that what I'm raising today is that shouldn't be based just on what the term of development plans, and that they need to be a little broader. And this is an example of a case where that should apply a broader consideration than just existing development plans.
okay, thank you. No further questions.
Thank you. Malcolm?
There being no comment around the policies, I'll leave anything for the substantive hearing and subdivision a further date. Thank you.
Thank you. Nicole?
No questions from me either, thank you.
Thank you. Deborah?
Yes, I have one question. Future proofing. With regards to the decisions that were made in 2013-14 with the land use recovery plan, due to submissions, the area that you've talked about was identified as a possible future growth area, along with others in Lincoln and Rolleston. And if I'm gathering correctly, your question to us is that why haven't those policies been updated and put into the district plan strategy? Is that what you're asking us? Or council?
I'm pointing out that yes, I think that should have happened prior to actually determining the urban growth overlay extent, because it was relying on old information.
Which then I guess leads me on to another question, and this may be for section 42A reporting. Could we have an explanation, please, as to why those growth area or future proofing land areas that were highlighted in the LERP have not necessarily been included in Planning Map A?
Do you think that's within your scope to answer, given Planning Map A is a regional council initiative? Take your mask off when you answer the questions.
Oh, good point. Look back.
I'm trying to.
Yeah. Okay.
Yeah. If it's not covered in the Section 32 analysis, and therefore it won't be covered in Section 42A, and we've already heard in strategic directions that certain land areas that were picked up, I guess, as suitable for growth and the LERP hearings. It would be interesting to know why, or understand why they have been left out of, I guess it's ECAN or the regional policy statement. It would be a question that maybe needs to go to Environment Canterbury or the Greater Christchurch Urban Development Planning. Just in fairness, just trying to understand, not being involved in that process, why they have not been included.
Yeah, Deborah, sorry, my
Okay.
last question wasn't addressed to you, it was addressed to the reporting officers. Their answer is that they can review that history and give a brief summary of it in the reply report. So basically they've said, yes, they can respond to your question. All right, we'll move on. Mark, questions?
Yeah, thank you for your comments, but noting that you said that
Thank you. That'd be appreciated.
the urban growth overlay
Thank
is
you.
based on outdated documents. The recent change to the regional policy statement isn't an outdated document, and the urban growth overlays are based on the limits within the changed regional policy statement, which allowed growth at Rolleston and not Prebbleton. How do you respond to that?
Well, I felt it most appropriate to deal with this at district level. I could spend a long time talking about the relationship of regional and district plans, but I felt it was best to focus on Prebbleton, what I know about Prebbleton, and those documents, and the fact that unlike the Rolleston one and various work that's been done, it has simply been left out of the picture. I can't be completely sure why the region has, but in relation to the district, I can say that they're relying on out-of-date documents.
Well, this is also relying on the regional policy statement changes, which had supportive documentation. I'm just wondering why that you weren't using that as part of your documentation that you were using, because that is a more recent set of documentation.
Yes, but it didn't even look at Prebbleton. What can I say about that?
Looked at the Selwyn in the wider context. I think we just have to, thank you for your comments, and that's me done.
Great. Thank you, Raywin.
No, thank you.
Excellent. Yvette?
No, thank you.
Gary? Just got one question. The area, the PC 68 area that's shown in the figure in your evidence under your paragraph 6, what's the LUC? What class land is that? Class 1, 2, 3? What does that mean? Do you know?
It's a mixture because, of course, it's quite a large block.
Yeah, right. Well, don't answer it now. So maybe could you come back to us and
It's
write
definitely documentation, but that you wouldn't see. But of course, you wouldn't know quite in detail on plan change and set. So yes, I can supply that. There's no
Yeah, and
problem.
what I'm interested in, so as you said, some of the areas within the urban growth overlay. So I'd be interested to know what the LUC class is within the urban growth overlay portion, and then what it is in the other two portions each side of it.
I know it's at least two.
Yeah. Yeah, and you're quite right. We haven't looked at any of that rezoning request information yet. Right, that's great, but no further questions. Thank you.
Thank you.
Hughes Development. Okay. Mr. Brown, just while that's been handed out, through no fault of your own, our panel members on the Zoom call won't have this in front of them.
Sure.
So would you just be able to read it out to us and then they can hear, and then we'll make sure if you could email, or we can get a copy sent to them, we can scan it and send it to them.
No trouble.
Thank you.
Good afternoon. My name is Mark Brown. I'm a director of David Lovell Smith, where I've worked as a planner for the last 12 years. I've over 22 years experience in planning, and during that time, I've acted for a number of land development clients. I also have extensive knowledge of the land development process, the industry, and through a combination of my consultancy and personal experience, this has informed my submission. I prepared a brief summary of my evidence in chief, which admittedly in itself was relatively brief. The two key areas I've previously addressed relate to net density and the importance of a policy framework that is responsive. Net density, as defined, has occupied considerable prominence with urban growth discussions, both within these proceedings and other regulatory forums. I believe this prominence is misplaced, and admittedly, the relevance of net density has been somewhat skewed by the recent announcements contained within the
Enabling Housing Supply and Amendment Bill. Aside from the yield discrepancies that occur when applying a blanket net density minimum, other outcomes in terms of matters such as design and diversity tend to run counterintuitive to proposed objectives and policies, such as those listed below. Do you want me to briefly read through those for the benefit of our Zoom?
Yeah, if you don't mind, yes.
Yeah, so in referring to those objectives and policies, it's urban growth objective 1, which requires attractive, pleasant, high quality and resilient urban environments. Objective 2, which seeks to maintain and enhance amenity values and character anticipated within each residential area. Objective 3 refers to a wide range of housing types, sizes and densities are available to satisfy social and affordability needs and to respond to demographic change. And policy 13.5, which seeks to achieve a diversity in housing types, sizes and densities. The inflexibility of the current regulatory planning environment and its lack of responsiveness is there for all to see in today's environment. It is my opinion that in creating a future framework to manage urban growth, flexibility and responsiveness needs to be inherent within policies such as P1. No matter the intentions or implied interpretations of policy wording, these carry little to no weight when the policy gets interrogated. Never has the need to be responsive been so clearly evident when one contemplates the impacts of earthquakes or global pandemics, let alone matters such as monetary policy or social housing shortages. Such matters have largely rendered forecasts and modelling redundant, yet they continue to be embedded into objectives and policies in a rigid and absolute form. Instead of being able to respond to demand pressures, whatever the cause, we've been faced with regulatory constraints that cause delays and inevitable escalation in land prices. Thank you.
Thank you. Happy if we see if we have questions for you now?
Yep, absolutely.
Andrew?
Thank you, Mr. Chair. Thank you for your evidence. Just interested in paragraph 7, you talk about inequitable yield on the basis of, I guess, the net number of households per hectare and how that's calculated, net density.
Yep.
And I think I understand what you're saying. So you're talking about one, it excludes areas required to be set aside for stormwater treatment. And what you're saying is that some areas need to set aside areas for stormwater treatment and some areas don't. And there are examples in Rolleston where you don't need to do that. And so you're saying it's inequitable because, and I'm just seeing if I get this right, is it because those stormwater treatment areas provide an amenity component in like a reserve in the first place? So you're like double counting it? Is that what you're saying? Or because I'm trying,
yeah, I think it goes just a little bit deeper and probably a bit higher level than that. It's just there's a large emphasis in all the planning documents on achieving a net density and the benefits that entail from that, whether it's efficient use of land or supporting critical mass for public transport and other modal forms of transport. But applying this blanket density actually doesn't give those sorts of outcomes. That there's different outcomes in different areas due to land conditions predominantly. And you don't look at a net block and you don't look at an area and how many houses you get out of that area, because it can be easily skewed by the land conditions. And it's not a choice to set aside land for stormwater requirement, particularly in the city. It's a given fact, given their land requirements, given their land conditions. They're unable to discharge the land. So they need large blocks of land that are set aside for that type of retention and treatment. So you've got all these requests saying 15 is this aspirational level that will help in all these areas. But I think applying such a rigid net density is flawed, because the calculation and the actual outcome is flawed right from the very start.
So it's having the minimum density requirement in the first place, and so the solution would be not to have that or have something less of, which is what you talked about. Would an alternative solution be to get the definition correct, or do you think it can't be fixed because every site's individual?
Yeah, well, there's a difficulty in fixing it through this process because it's embedded into the RPS.
Yep. I understand that. Yep.
So, but yeah, look, I think it needs to be addressed, and given we've gone to national planning standards and so forth, I think something as critical as a net density probably should be nationalised as well, with territorial authority to territorial authority differ in terms of how they calculate density.
Okay, thank you. So I think the section 42A report talks about unless there are constraints that would apply. And is that not sufficient for you to point to those and have a lower density as a result of any constraints that apply?
Yeah, well, my experience, constraints actually are used around sort of geographical features or areas of unsuitable land due to TC rating or so forth. You know, the constraints don't actually go as far as to be applied, you know, where it's not practical or not desirable for the market to have a minimum starting point of that type of density. So I think I don't really agree with the assertion in the 42A that flexibility is enabled by that constraints provision.
Okay. All right, thank you.
Lindsay?
Yeah, just one, and leading on from that, what's your relief? Is it to remove clause 4 from policy UGP 13? So you actually don't have a density target there?
Yeah, I think the relief is to, at the very least, work to a 12 minimum. Given that these densities are minimums, it's not precluding you achieving high densities in more appropriate locations and circumstances, but I think the original position of the council was to promote a 12 household per hectare, which, given that the RPS has got 10 and plan change 1 stuck with 10, for a reason. I think it's acknowledgement that although we talk about Greater Christchurch, each authority that makes up Greater Christchurch have got their own characteristics. That's recognised by those density provisions. Our starting point of 10 would still promote similar outcomes, but I know the plan notified included 12. So as a starting point, I'll be happy with that.
Okay, so your relief is to have the plan as notified version of UGP 13.4, clause 4. Minimum net density of 12 households per hectare for residential activities, or 1 to 2 households per hectare for rural residential activities. That's your preferred relief.
Yes, it is. Yes.
Okay, thank you.
Thank you. Malcolm?
Yeah, thank you, Mr. Brown. You've been heavily involved with the Hughes developments in the past. Can you give me an indication of what their average density has ended up at over the last year or two?
Yeah, well, ODP 6, which was the main body of Farringdon that started back in 2012, that had a density of around 13 that was achieved. Then further carrying on from that and other smaller ODP areas down Springston, Rolleston Road and the like. Again, that sort of dropped back to about 12, although all of those developments are actually encompassed solely medium density lots under the Living Z zone, which is up to between 400 and 550 square metres. And then latterly, obviously, the special housing area that we embarked upon was 600 lots there. That was achieving around about 12, and our most recent fast track consent that we've got for just under 1,000 lots, we achieved the 12 household per hectare across those sites.
Thank you. So you're already achieving what is suggested in point 4 here, the 12 minimum.
Yes, that's correct. On behalf of my client, we feel that that requirement, and picking up on Mr. Dace's earlier comment, it does seem strange to have such a prescriptive element in here, but I at least know those are achievable and getting a really good mix of densities for my client.
Yeah, thank you. I mean, there was a large discussion around this in the airspace document with pressure from the city to go to 15. So it's interesting to see where we sit. Thank you for your submission.
Thank you. Nicole?
No questions for me, thanks.
Deborah?
I've got one question. With regards to large lot living, within the Hughes development, are there any large lot living developments that are happening within the urban growth overlay under map A?
No, they're all, as I just alluded to, they're all achieving a minimum of around 12. So they're based on the Living Z low and medium density zoning requirements.
Okay. Now you gave support for rural residential being 1 to 2 houses per hectare, which comes under the that they would need to be located within MAP A or outside MAP A.
I haven't really submitted on that point, so I'm not really in a position to provide an answer there. Sorry.
Yeah, fine.
That's fine. Thank you.
Right, Mark.
Thank you. And if we were trying to achieve a more compact urban form, won't retaining a minimum of 12 households per hectare become the maximum?
Could you expand on what you mean by that?
I mean, if some parties are arguing that we need a target of 15 to achieve a more compact urban form in Selwyn, if we set the minimum at 12, won't that necessarily become the maximum? That's all people are going to achieve?
No, I don't think so at all. I think 12, like I said previously, 12 does provide the flexibility to sort of take an unders and overs approach. You can have lots of the 500 and 600 square metre variety and offset them with some lots that are still, palatable to the market out here, 300s, 350s. So they sort of offset. And because we've got no stormwater retention or anything set aside here, that's more net density in its truest form. So we achieve the necessary sort of variety with that. It is a minimum, and it, I think, given land prices the way that they are at the moment, developers may definitely favour areas or pockets of high density, and that's not precluded with a minimum.
Thank you. I was just going to ask you to sort of for comment on the urban form that's delivered here, perhaps in terms of what you perceive is desirable in Selwyn versus other areas which Christchurch where medium density means something entirely different. If Selwyn was to force a much higher level, is that going to be attractive to the market, or is it going to be just impossible to sell?
If it's priced right, it'll probably sell, and Selwyn's got an inherent ability to deliver quality product at a good price point, just because of its ground conditions and it's the infrastructure that it's built up over time, both community infrastructure and infrastructure in the civil sense. But it just depends. There's a whole lot of factors that will determine what that critical mass and suitability is around employment. But I think fundamentally, Selwyn's got its own character, and to compare Selwyn and Waimak with Christchurch City, one of New Zealand's biggest cities, and yet hold those two sort of outer-lying territorial authorities to the exact same measure, I think is slightly optimistic.
Thank you.
Raywin?
Yes, I have a couple of questions. You talked about requesting enabling provisions in the PDP for providing such things as affordable housing. How many affordable housing initiatives has Hughes initiated?
Well, back in the special, the Housing Accord site, so the special housing area known as Farringdon South, there was 55 affordable houses provided and delivered at a price point of 416,500 as initiative of that development. But I think, and then going forward through our most recent sort of consenting exercise through the COVID Fast Track Act, we went to sort of great pains to point out that for such a long time, Hughes has achieved an affordable price point in its own right. So initiatives like the Home Start and the KiwiSaver type fund and all of these initiatives that enable first home buyers to access favourable lending conditions, they've always been predisposed down here around the 550 to 600k mark. So without even building anything special into our consents, we've been achieving that quite comfortably until recently, and that's solely due to a lack of supply. Now you've seen a doubling of prices literally in the last 12 months. So hence my request for the ability to be far more responsive than what our current planning framework lets us be.
Thank you. And you've just answered my second question, which was going to be what constitutes affordable housing, but I think you've explained that. So my last question is, in this day and age of COVID-19, with regard to density, should we be increasing density?
I'm not sure if I'm overly qualified to go that deep. There's probably two trains of thought. There's people, if we're ever forced to endure more lockdowns, then could be an argument to say that larger lot sizes allow people to recreate within the confines of their own home and so forth. So there's benefits there.
Well, I live next door to a subdivision that's got 15 households per hectare, and they're living on top of each other, which is why I've asked the question.
Yeah, well, look, I definitely understand that, and I think that's the difficulty with our current framework, because if you're really talking about net density and talking about the numbers that 15 households deliver, then you should be entitled to offset that type of living density with green space. But at the moment, green space prohibits you achieving the 15 per household density in our environment down here. So you can't offset, you can't adhere to good urban design principles by providing dense housing, but then providing good public green space to offset that. And I think that's the trend you see over in Europe and the like. They have dense housing, but they have a lot of parks and so forth, which enable that spatial offset.
So just on amenity, do you think living in an area with 15 households per hectare gives you good amenity?
Currently,
especially when you're used to living in New Zealand with plenty of space.
Yeah. Oh, look, I'm definitely of a mind that ironically, given the way land prices have increased, a denser type of living is becoming a necessity. But again, I go back to my original point around the way we calculate and are forced to comply with net density. It's at the exclusion of good design outcomes, and that's a combination of the designing the public and the private realm together. And at the moment, that's not achievable.
I tend to agree with you. It is about design. But thank you. That's all the questions I have.
Kia ora. Are you there?
Yes, we
can
hear you.
Yep, sorry. I wasn't sure. Look, I just want to carry on from Raywin and also Commissioner Willis in terms of the equitable yield, but just looking at the hectares and what it includes and then what is excluded. So what I am assuming is that the land that is set aside for protection of significant ecological, cultural and historic heritage or landscape values is already included within that space that you're working within. But is there, and if that is so, then is there the possibility then to look at the inclusion of green space? Because I agree with Commissioner Solomon in terms of that design and ensuring and enabling that recreation opportunity, which point 3, B3, doesn't quite cover. It's already there, but if we were to include space for green space, is that a possibility, or am I going right off key? Kia ora.
Thank you. I think you're right on the mark there. I think we're slightly constrained because the definition of net density is derived from what's in the regional policy statement, so it can't be changed through this proceedings. And if you were to put a criteria or so forth around it, I think there's going to be tension between those two documents. So, yeah, unfortunately, we're sort of lumped with it at the moment.
Yeah, kia ora, because I think definitely then there is an equitable comparison on the sites that we could look at. So kia ora and thank you for that comment.
Thank you. Sure. Yeah, thanks. Just a quick one. Thank you for that. We're looking at the policy level, and the 15 is a sort of an aspirational level, I think is how you termed it. What we haven't got to yet is the rules framework, the assessment criteria, those sorts of things. Have you got any comment to make on how difficult it would be to pass those hurdles, bearing in mind a developer would have to get a consent anyway, and there'd be an additional hurdle, if you like? We haven't got to that point, but is it quite an onerous task, do you think, to get a reduced density for development?
Yes, it is.
It is.
Yeah, very much so. Particularly, and I'm not sure, I don't want to cast aspersions, but it's become particularly difficult in Christchurch City, and I presume that's aligned with how hard they're pressing the density issue. But even sites that are less than a hectare are being held to achieving a proportion of the 15 and so on and so on. So it is difficult, and even out in Selwyn here, it's that density target at the moment it's 10, and it does vary from ODP to ODP, but not to the point where it's 15, and 15 does become challenging. And in terms of achieving it, you have to make sacrifices, which I don't think are ideal.
We'll come back to that when we look at the provisions, but thank you for the answer.
Mr. Brown, I was very interested in your response to the query put to you whether or not the recommended wording to us, which was to provide an exemption from the 15 unless there were demonstrated constraints. And you said in your experience, it really doesn't help you at all. Just listening to what you've said in response to other questions and your summary, if we were minded to add in some additional words in terms of further exemptions that refer to urban amenity and residential character considerations, would that go some way to meeting your concerns?
Yeah, it could be a thread that could be latched onto.
Yeah,
definitely. Yeah, I think anything like that would definitely be beneficial. It goes to I know it's quite a vicious circle in some respects, though, because it then goes to the point that sometimes you have to compromise design to achieve compliance, but then sometimes councils actually don't sort of buy into the treatment of the public realm in the densities, particularly now with land prices. The acquisition of reserves and the price that has to be paid for those. I think that's going to be under very close examination. The treatment of road reserves and berms and even small little pocket parks and so forth, have become quite difficult over the past few years. And I can cite an example in the city where developers had to form a residents association for the residents to own and maintain additional landscape initiatives that he's put in because the council wouldn't accept them. So, having that written in, you might have to ask the council if they'll accept it as much as the submitters.
Well, it'll be up to us as a decision-making panel. But why I asked that question was I, like my colleagues, do a number of hearings in other parts of New Zealand, including in the North Island and the ones I've been doing recently in the Horowhenua and the Bay of Plenty. In terms of residential issues, it's urban amenity and residential character are quite often the deciding points. So.
Yeah, look, absolutely, and that would definitely be the way it should be.
Yep.
But unfortunately, we do get sort of hamstrung a little bit by this density target.
Yeah, no, understood. All right, thank you very much for your evidence. Very helpful.
Yes, thank you.
So apologies to the remaining submitters because we're running a little bit late. I'm sure you won't mind. We're now going to take a break because we have been going for quite a wee while. We'll break for just over 10 minutes and we'll try and resume about 25 minutes to 4. Thank you. Sorry. It's all right. It's all right. We're live streaming. All right. Thank you very much. So the next submitter we have is Davina Penny. Good afternoon and welcome. You've appeared before us before, so I think you know the drill. And if you don't mind just turning your microphone on. Excellent. Oops, no.
Got it. Thank you.
Right, yeah, over to you. Thank you.
Okay, thank you. I understand I had sent in my submission a while ago before we had the lockdown. And I remember from my last time I was here, you asked me just to present a summary because you'd all read it. So
yeah,
I remember and I've done that. And I will provide a copy of the summary as well.
Thank you very much.
At the end for you.
Great.
As cited in my hearing submission you've read, in the space of just 16 months, and I'm including the Templeton Quarry in the figures, there's been 726 hectares of LUC 1 to 3 or highly productive land, which have been subject to applications and then taken out of production or potentially out of production. So this is also linked to the issue of private plan change requests, which I will be referencing in this summary. And I appreciate as I arrived, you were discussing the issue of private plan changes, so it's probably quite pertinent. And I had questions in mind before I came to this hearing, and I don't know if you've got the answers already. If you have, I do apologise, but they were the ones which came to mind. Does Selwyn have a plan for controlling the rate, and how Selwyn District Council will ensure they meet any target sets with regards to the taking out of production of LUC 1 to 3 or highly productive land? And do they know how they can meet those targets? Are there any criteria or objectives for meeting those targets? And will these be included in the forthcoming district plan? Have projected losses been mapped out based on where the curve is currently heading? I initially raised the issue of focusing too much in the current district plan on the township development, and it's the rural area of the district which is very vulnerable to large tracts of valuable land being subject to application for rezoning or land use. So I do ask if the rural and township volumes can be given regard with regards to this subject matter. The reason I'm raising this is, as the chair knows, I was involved in a hearing for the Templeton Quarry, and the issue of the land was raised at the very end of the hearing, but there seems to be very little reference in the township, in the rural volume, and the township volume focused on development, not land use. And I think that may have been a factor as to why that land was actually consented. I also raised concerns regarding the wording used in the district plan. Having been through consent hearings, I'm very, very aware that the wording is very important and can be open to legal interpretation. So can I ask that any wording with regards to the use of productive land or LUC 1 to 3 land is watertight and doesn't have any potential which could lead to game playing or be exploited as a legal loophole? As I said, it did seem to happen a little bit with the Royden consent, whereby because there was a focus on development in the wording, it was suggested that it therefore didn't apply. Now, to summarise the issue of dominoes, creep and sterilisation, these are the words which were in my initial submission. By nature, the creep occurs incrementally, with each single consent not being seen as part of the big picture, yet the cumulative effect can be hugely significant over time. And this has now been identified as a concern by the Environment Court. And it was contributory to the declining of the request to rezone land in Auckland. And I do ask that this issue be given regard in the district plan. That case went to the Environment Court, then High Court, back to the Environment Court, where they actually upheld their initial decision not to rezone the land. And that hearing was from December 2020. And it was interesting to see that the key issues and concerns from the Environment Court was the accelerating rate and the cumulative taking out of this particular land. They are concerned the cumulative issues are not being really taken into account. I also maintain my support in the horticultural industry request for a setback of 500 metres from land being used productively. I also maintain the request that the district plan cite HPL land as being LUC 1 to 3. This will bring it in line with the land use registry, CRC policy, and also the forthcoming national policy statement, which I've been advised is now not likely until the first part of next year at the earliest. If I can have slide 1, please. Next slide. Thanks very much, thank you. Now, these slides indicate how little of the land is available nationwide and the important role Selwyn plays, because it's got a significant proportion of productive land for the country. Only 5% of the country has LUC 1 and 2 soil available for use, and we're very fortunate in Selwyn to, certainly around the Lincoln-Prebbleton area, to have the best of the best. And when we come to the next slide, please. This shows the available LUC 1 to 3 soil on the South Island. As you can see, Selwyn does have a significant proportion. So factors which may need to be considered for inclusion in any policy or any plan. Not all land is used at the same time, so production is rotated so as to maintain soil health. So it might look you've got a lot there, but not all of it can or will be used at the same time. In addition, where the use of nitrates and fertilizers is to be significantly reduced, and we understand obviously that is something which is in process with regards to the regional, Canterbury regional policies. They're trying to reduce the fertilizer use on the land. That may result in slightly less yields. So that makes whatever land we do have even more important, that where possible we safeguard it, because if yields are reduced because of having to reduce fertilizer or nitrate use, whatever land we do have is going to become even more important. My September presentation indicated concerns of land being taken out when alternatives were available. So it's important the district plan makes it clear that it's being discouraged and encouraged on areas which do not contain LUC 1 to 3 or productive land. And I ask that there is a clear policy on this issue. These are only thoughts which came to mind. I offer them as suggestions, but I appreciate I'm presenting at this level, and you've had presentations much higher. If it is to be consented, there is a clause requiring verifiable evidence showing that the site will be restored to its original state or better in line with current provisions if it's going to be land use. To be a prohibited activity if the use is long term, i.e. 25 years or more, and this time frame is in line with what is stated in the regional policy statement in chapter 15. Again, this relates more to land use, but will the post-activity use require significant management or input in order to restore to productive use? Again, if this is going to be the case, could it be a factor against the considering of granting such a consent? The reason HPL is so valued is because it does not require as much by way of management or additional nutrients. Okay, so this is just taken from Canterbury maps. This is a map of highly productive land, and the green areas are shown as LUC 1 to 3, and the non-green areas are not classified as highly versatile or productive land. So as you can see, we've got both in this region. So where there is a possibility of using non-productive land, then really that should be the first port of call and serious justification given if there is no other alternative. And just to give you an indication of the size there, that wee box you see, that is 170 hectares. So when I referred earlier on to in just a space of 16 months of having over 700 hectares potentially at risk or consented, that's quite a high proportion. And if I can have the next slide, please. With those images you've already seen, that is not necessarily the land which is available. This is taken from Canterbury maps and it's zoomed in. I zoomed in on Wollaston and I just asked for an indication of Wollaston Drive. So here you can see Wollaston Drive is indicated. Already Wollaston is built on LUC 2 and 3 land. So those images you've seen, please don't assume that is the available land. A lot of that may have already been taken out. I live in Templeton, and the Globe Bay Dry area is already taken out, which was HPL land, obviously built in some time ago. This slide is just a reminder of what can happen when land is consented whereby it's not restored to productive use. This land was actually quarried with the promise that it could be restored to productive use through the rehabilitation which was proposed, and this was less than 1 year after it was signed off. So this is just going back a little bit to what I said in September as a reminder really that if you do sign off land for land use, there has to be serious evidence provided that it will be restored, not can be. I described the issues arising in the plan change hearing I attended in my initial submission to you, and I believe the issue of private plan changes highlight either a loophole in the district plan that's never been closed off, or there has perhaps not been full regard to the importance of curtailing development on this land. Without clear and stringent criteria in place, particularly with regards to private plan changes, consenting will not be consistent, and at present it does appear to be somewhat of a lollygab. This has actually been mentioned by the Green Party in the parliamentary report on the MBA, and unfortunately the private plan change issue in Selwyn was raised, and I don't think really it shows Selwyn in a particularly favourable way. As you can see there, this was their initial statement. They're seeking stronger recognition and protection, as you asked about the word protection earlier, protection of highly productive land in the full bill, given its importance to food security and human health, and to avoid the current trend of cumulative loss for subdivision and urban development. And this cumulative loss, say, was covered by that Environment Court decision from December. We also note the importance of planning protections for food production land in the proposed spatial planning legislation, and in ensuring alignment between that legislation and the NBEA. And you see the footnote there for point 39. Horticulture New Zealand noted that 14 of 18 private plan changes in the Selwyn district saw urban zoning for land that is land use classification 1, 2 or 3 suitable for growing food. Having been involved in the consenting process of a private plan change, and this was plan change 66 I was a submitter for, even when it was shown the land in question is HPL, in this case it was 100% LUC2, with non-LUC 1 to 3 land available less than 3 kilometres away. Consent was still granted, and I think this shows really consent is not likely to be declined in such circumstances. So my belief is those breaks need to be applied, and it's certainly supported by the Environment Court ruling. An ex-mayor of Selwyn, who was a friend of mine, he's recently been involved in an appeals process, and very much to do with LUC 1 to 3 land, highly productive land. And he's actually estimated, based on the current acceleration rate, removal rate of the land in Selwyn, it could occur whereby if it's not stopped, we wouldn't have any land left HPL in 50 years in Selwyn. So that's basically my submission on that issue.
Thank you very much. I'll see if we have questions for you, Andrew.
Thank you, Mr. Chair. Just a couple. It's just for, I guess, further information or clarification. So in your first paragraph, you talk about you're involved in 2 consent hearings.
Mm-hmm.
So again, just for clarity, what were those consent hearings?
The first one was the Royden Quarry, where on the last day of the hearing, it was evidence that the 170 hectares is LUC 2 and 3 land, 98% LUC 2 and 3 land. Yeah. It didn't come up until the end of the hearing though. And the second one I was involved with was the Plan Change 66, which was 27 hectares of 100% LUC 2 land.
Okay. And then again, just for clarity, you talk about the heating reverse sensitivity and sterilisation. I'm aware of an industry requesting to be classed as highly productive. and you talk about this was considered my submission presented last week.
Mhm.
So just for my benefit, what was that activity that was requested to be classed as highly productive, the industry?
Sorry, say that again.
What was the industry that's requesting to be classed as highly productive?
Oh, the quarry industry.
If it was quarry.
Yeah, the
thank
quarry
you.
industry want to be classed as highly productive. They do have the luxury of being able to use non-LUC 2 to 3 land, and I actually produced a slide of an overlay which the industry provided of available land in Selwyn, and there's hundreds, if not thousands, of hectares which is not on LUC 1 to 3 land available. And I think if they are allowed to be classified as highly productive, they will want to quarry in areas closer to cities, and that will be on that land which will take it out of use.
Okay, thank you.
Yeah.
Thank you. Lindsay?
Just one. What, in terms of the objectives and policies we're looking at in terms of urban growth, what do you want? Do you want the strengthening of the relevant provision relating to versatile soils, but basically saying a blanket prohibition, or what exactly do you want?
I think there needs to be a prioritising where possible, and if there is no other choice, then yes, I understand. You can't necessarily just put a brick wall around it and protect it. I think really when you've got competition for the land, then the priority should be given as far as possible to actually safeguarding it when there are other alternatives available. And I think at the moment, from what I've seen with regards to the plan change requests, it's almost like a lolly grab. There have been so many, and there doesn't seem to be anything really provision wise to say perhaps you should be looking elsewhere.
Okay, thank you.
Malcolm? No questions. Nicole?
No questions, thanks.
And Deborah?
Thanks for your submission. Just with regards to rezoning requests, we tend to look at residential zonings as being compact in nature and sort of, I guess, established in or around as we're proposing. Do you see an opportunity where high residential use is integrated with the protection of those soils? So what we will end up with is not a nice compact urban shape, but sort of like an irregular urban shape or an urban township where protection of those soils can be used for other alternatives, growing vegetables, etc. I'm just trying to get an understanding of how you visualize with the protection, what will be the shape and design of our townships, irregular or highly regulated or highly regulated?
I think that's going to be out of my remit. It's going to probably be more for the planners in the district council to look at. It could happen. Yeah, it could happen.
That's okay, that's fine.
Okay, Mark.
Thank you. And thank you for your submission and your presentation today. I guess my question is trying to tease out which, in your view, is the better environmental outcome. Consolidated townships that have as small a footprint as possible, even if that involves building on some particularly class 2, 3 soils on the edge of townships, or growth across a district that's scattered to the pockets that aren't class 1, 2, or 3 soils, and therefore involves much more travel. Which is the better long-term environmental outcome in your view?
I think, playing devil's advocate, if you had the first idea where you keep expanding the town, then the issue is that expansion is just going to keep continuing and more of that land is going to be taken up. So you know, this is where I'm saying, has the district council got a footprint of, this is how much land we've got, this is the rate at which it's being taken out, and planning accordingly. I think that's where you need to start, because at the moment, I think the real risk is if you go with the first idea, it will just keep continuing, because that area which is just next to the bit already urbanised, that becomes sterile. You can't grow there, you're not within the 500 metres, and it's going to be open then for that to be developed, and that's where the creep starts. So I think the second part, you can manage it. It wouldn't necessarily involve huge distances.
Okay, thank you. Raywin?
Yes, I just have one question, or perhaps two. I just wonder, I think your opening remarks alluded to the fact that this land is highly productive because it's got access to water and nutrients. Am I right in thinking that?
I think the best person to answer that in detail would be someone from Lincoln University, but the criteria which helps make it highly productive is it doesn't need necessarily as much irrigation as the non-productive land, and the actual composition of the soil has got nutrients naturally, probably more so than the non-highly productive land. So it
and naturally occurring minerals and nutrients, as opposed to spraying superphosphate on there.
Absolutely. I live in Templeton, and this potential quarry site, they're going to be looking at getting 3 really good grass cuts off of it, and it needs absolutely minimal irrigation. It's just Templeton Loam is one of the main ones. That's LUC2 land up there. So yes, it's less management, less maintenance, less fertilizers, less irrigation. It's just naturally occurring.
Fertile.
Yeah, very fertile.
Thank you. No more questions.
Thank you. Yvette?
Yes, kia ora. Look, I just want to follow on from Lindsay in terms of what it is that you're actually wanting in relation to the provisions. You know, because I agree that you know, the importance of protecting this productive, you know, and highly productive soils land. But just wondering where within the provisions, as was asked by Lindsay, where we can strengthen some of the protection within there. Currently we have it in UGP 17, but have you looked at those provisions and thought about where it might be strengthened, the comments that you are making? Yeah, kia ora.
Again, it's not something really I feel I would have any input on of any value there. I'm just raising the concerns and noting what's currently been in the district plan and how that has potentially left some loopholes or openings which have been laid into the situation we're in. I think with the national policy statement coming in, until that comes in, it might not be really easy to stipulate any further as to what you can do, because that may actually lead you in certain directions. And until that comes out, we won't know.
Well, kia ora for expressing your concerns, you know, and so well and as well. However, to enable us to be able to move forward, it would be good to have had some direction in terms of that protection and where. However, we will keep the comment you've made in mind in terms of your concerns. Kia ora and thank you.
Yeah, thank you for providing that information, especially the map showing the extent of LUC. I've got no questions, but thank you for the effort you've gone to.
And no further questions from me, but just to let you know that we do have a explicit provision, policy UGP 9, which refers to either versatile soil or highly productive land. There will be a provision in there of one form or another, which they have to decide exactly what it's going to say. So the issue is well before us and we will be giving it our attention.
Thank you.
Thank you. So the next submission submitter is Lloyd Bathurst. Good afternoon, welcome.
Thank you and good afternoon to all. I do have three themes for today. They're all pretty brief. And firstly, I'll express my sympathy for you all because the role that you signed up for does not include or did not include the impact of COVID-19 as we now know it, nor the lunacy of the 3 houses per section or upzoning as some would call it. I have no financial interest in the housing sector, but a lifelong interest in and study of urban issues and a desire to see New Zealand and Selwyn in particular a great place to live. Firstly, I'll explain why I won't have consultants appear, and I'm sure most of you are very aware of this. I can recall final year studies at Lincoln Uni where the lecturer described discovering consultants saying one thing at a hearing and the opposite at the next hearing, and a discussion between the principal of a consultancy that Selwyn has used considerably and a very highly ranked RMA solicitor and myself when the consultant advised that their practice considered it reasonable to represent their clients' interests rather than their independent views as expert witnesses. In short, I know I could have senior consultants arguing on either side of any issue, but that does not produce good planning results. Only commissioners making good decisions can do that. And I was heartened by your earlier response to the submitter from Hughes Developments, where you have a ready appreciation of quality, and that means an awful lot to living in New Zealand. I'll speak further on that later. Then I'd like to address upzoning, or putting 3 homes on one section as is currently proposed, although we don't know the details, and that will be most important. But without proper setbacks and recession plans, this will be building the slums of the future with consequent mental health and wellbeing issues and subsequent crime. I spoke in an earlier session when I addressed Christchurch City's attempt to force higher density into Selwyn about the advantages of living in Selwyn. And since then, even since then, many more New Zealanders from all over the country have chosen to make Selwyn home, even though section prices have doubled in less than 2 years. I spoke of the need to reject minimum higher density requirements to retain the real advantages that larger section sizes provide. This includes maintaining a green outlook, sunshine, privacy, and other matters. One issue I didn't discuss is the effect on crime statistics, because at present Selwyn enjoys 1/4 the crime rate of Christchurch. Christchurch has a crime rate similar to New Zealand's other major cities. And forcing higher density onto Selwyn townships will result in a lower quality of life for nil environmental benefit. And 3 is affordability, and it's gone crazy in the last few months. And of course, as commissioners, if you're not making it easier for young New Zealanders in particular to afford a good home, you're failing in your role. Because of poor governance of the New Zealand economy, we now have rampant house price inflation, which is rapidly eroding the proportion of New Zealanders able to own a home. Being a property-owning democracy is one of New Zealand's great strengths and hugely important to the quality of life that New Zealanders enjoy. Selwyn, for many reasons, is one of the best places in New Zealand to live and capable of housing many more people really well. Any decisions you make that can improve housing ability in Selwyn will serve Selwyn and New Zealand really well. Finally, I'd like to expand to a small extent on the question from Councillor Alexander about maximum densities. I think it's something we should consider seriously, because maximum densities put on developable land will put an upper limit on the price that that land can enjoy. And thereby it will ensure quality at no greater cost. So it's something I would recommend. That's it.
Thank you very much. See if we have questions for you. Andrew.
I'm just interested in your thoughts on the government's housing density bill, 3 houses per section, 3 stories high, etc. And do you have any views on what that will mean for, I guess, the character of the district's settlements, but also I'm interested in affordability, but also quality?
Yeah, it could provide affordable slums. That's about as far as I would go. Yes, there's some ideas around setbacks and not recession plans, but those rules will be so important to safeguard the quality of developments.
Do you think, just following on from your comments around, my final question, comments around having a maximum density and how that puts an upper limit on, I guess, a development potential and cost, do you think allowing 3 houses on a section, whether they're built or not, will actually have a counterproductive effect on land prices?
I suspect in some parts of New Zealand, yes, and in others, no. I think that the effect of the proposal will vary enormously throughout the country. But I think in probably the majority of occurrences, it will result in much poorer quality living space. And that to me is a tragedy. And certainly in Selwyn, an unnecessary one.
Sure. Thank you. No further questions.
Thank you. Lindsay?
No questions. Thank you for your presentation.
Thank you. Malcolm?
Thanks for coming, Lloyd. Note your comments on density. You were very consistent in your approach. Thanks for coming. I don't have any questions. Thank you.
Nicole?
Thanks, Lloyd, for coming along. Comments you raised about the availability, well, the cost of housing and more people not being able to afford their own homes. How do you marry that up with the situation that we've got at the moment and with land availability? And we've also had, you will have heard the speaker before talking about versatile soils. So we've got quite a few pressures on us. How do you propose, if intensification isn't the way to go, how do you propose that this a solution to this?
I think intensification in cities is a reasonable thing and it occurs naturally, but it's not necessary for Selwyn.
Okay, thank you.
It's a holistic view, I guess, that as long as we get a reasonable density nationwide, some places can cope with it. You know, to have 10 stories overlooking the Avon River is a pretty good outlook, and you can have quality rather than having 1 or 2 stories as it is at the moment. But for here, on flatlands, we don't want that.
Okay, thank you for that.
Deborah?
Thanks, Lloyd. Yes, I've got one question, and it extends from the Hughes development submission by Mr. Brown. The suggestion that you could have high density, but you need to supply the green space to accommodate it. Are you in approval of that sort of model with regards to 15 houses per hectare?
It will result in a similar net density, I expect. And I think when I'm in foreign cities, I tend to walk a lot, and I experience this from Moscow and New York, most of the European cities. If they have good green outlooks, and even Russia from their most horrible times provided this, then they enjoy a far greater quality of living. I think it's one of those things that New Zealanders are really only now starting to talk about the advantages of having a green outlook. It's never been something that's been front and center of mind, but it's very tied up with our mental well-being, I believe.
Thank you.
Right, Matt?
Thank you. Just tease out a couple of questions around the density issue, Lloyd. Doesn't a lower density target, whether it's a minimum or a maximum, imply if someone is to grow increased sprawl, and isn't that less sustainable?
I can't see why. I mean, there'll be an absolute limit, but we've got a long way to go before we get there.
In terms of, if you take Rollston, for example, currently with it going down to Selwyn Road, but the shopping centre being up here at the northern quadrant,
yep.
It's everybody effectively has to drive to get to do their shopping, their house, help provision their household. Whereas if there was provision of a higher density closer to the retail centres, wouldn't that be more sustainable?
We need to plan it from 20 years ago, I suspect, to have quality, higher density in the middle of the township. But then perhaps, as is originally planned, well, certainly since 2006, when the Greater Christchurch Urban Development Strategy was working on it, and thereafter, when we decided on the ultimate township limit, with a maximum population of 50-odd thousand, then perhaps that should be our limit. And then the next time we need a township, because Lincoln will grow also, and we perhaps look at the railway line if rail is going to be affordable, and we go, hey, why don't we have another township there? Why don't we go down the road, form another township, which also has rail and road links, good road and rail links.
It's interesting that you mentioned sort of the provisional, the older target where we thought we'd get to within the current urban limits, 50,000. We seem to be getting to the current urban limits with a much lower figure of something like 30,000 with a significant number of plan changes outside those limits.
I think inside the limits will fill up too.
You think
there is still some land that's not proposed to be developed inside the limits.
Thank you. I think that sort of teased out some of those issues for us. Thank you.
Thank you. Raymond?
No, thank you.
Thank you, Vet.
No, thank you.
Gary? No, and no further questions from me, but thank you very much for coming in this afternoon.
Thank you. I wish you well in your endeavours.
Yes, so do we. Trice's Road Rezoning Group. Yes, I think we got that. Right, good afternoon, welcome.
Thank you. Good afternoon. Council's name is Ms Ford and I represent the Trice's Road Rezoning Group, which is both a plan change applicant and a submitter on the proposed district plan. TARG seeks the rezoning of 28 hectares of rural land in Prebbleton to general residential zoning with a small area of large lot residential at the corner of Hamptons and Burgess Road. The proposal will release approximately 290 residential sites and abuts the new Burgess Road Reserve where development is underway. The reserve serves as a clear and defined boundary to residential development to the south of Prebbleton. TARG land immediately adjoins the existing urban boundary and is the most efficient use of this tract of land. The TARG submission on the urban growth chapter is supported by planning evidence of Mr. Ivan Thompson from Aston Consultants. Mr. Thompson has already appeared before the panel on both the strategic directions and definitions and other matters hearings. TARG relief sought has been carefully considered to enable a pathway to provide for the rezoning of the TARG land at the future rezoning hearing, and I'll leave the specifics to Mr. Thompson. TARG land is located within the urban growth overlay in the proposed plan, is identified as Area 8 in the rural residential strategy, although it's accepted that this proposal seeks residential rather than rural residential rezoning. TARG did not provide further submissions to address the Adderley Head legal opinion, largely as Council generally supports and agrees with the conclusions reached, and any site-specific matters will be addressed at a later stage in submissions at the rezoning hearings. I have a few key points from my legal submissions, but unless you would like me to run through those, I accept that you've taken submissions as read, and I'm happy to answer any questions.
Thanks. Do you think we should hear from your planning witness as well, and then
Yes,
put
absolutely.
questions out, and then whoever's best to answer them answers them?
That sounds like a great idea.
Okay.
Mr. Johnson.
Thank you. Just to perhaps follow on from the previous submitter, as a member of the Planning Institute, I've signed a code of ethics and I give objective evidence. Whilst I'm representing a particular client, my evidence is objective and in accordance with the normal expectations of a professional. I have written, because the wicket has changed a little bit since I wrote my evidence. I have prepared an extra document which I think has been circulated, and hopefully those on Zoom may be able to access it electronically by now.
So just check. Panel members who are on Zoom, do you have a copy of the additional information? Well, some do and some don't.
Okay. Well, I'll read it out anyway, if that's
Yeah,
the wish
I
of.
think probably that's best, and then we can just make sure that everyone gets a hard copy.
Okay, so just some points of clarification regarding my evidence. Since my evidence in August, I've been able to reflect on a number of matters as new information has become available. This new information includes the Adderley Head legal opinion and the council's rezoning framework. I have also prepared or helped prepare evidence on 4 private plan change requests, answered growth-related questions from commissioners, and have generally had more time to reflect on the urban growth hearings. As a result, I have not had to fundamentally alter my evidence on urban growth, but there are some aspects of my evidence I need to clarify or reiterate. Now, the issues where I consider clarification or reiteration may be helpful around the term significant development capacity, the meaning of urban environment, the statutory relationship between the proposed Selwyn District Plan, the Canterbury Regional Policy Statement, and the National Policy Statement on Urban Development, particularly around giving effect, and the application of Policy 8 of the NPS on urban development. In broad terms, I agree with the approach being put forward in the Adderley Head legal opinion as a planner, because I'm not a lawyer, of course, and the methodology put forward for its assessment of zoning proposals in the council's rezoning framework. So specific points. Now, these references are to my evidence. So I tend in that evidence to perhaps dismiss Mr. Baird's approach, but I don't. I think I do not entirely dismiss Mr. Baird's approach in considering urban development capacity as in a sub-regional context. Some account needs to be taken at the high level of the overall capacity situation, particularly the theoretical capacity of the intensification areas in Christchurch. It's Christchurch City, that is. But I do not hold the view that further rezoning outside the projected infrastructure boundaries should be avoided because of this surplus in Christchurch City. Local and district market conditions need to be taken into account with the overriding objective of ensuring urban decentralisation does not lead to urban decay in Christchurch urban areas. So I think the approach that Mr. Baird was in his report has some validity. You do need to take into account those wider strategic issues. But I reiterate that the township network should provide the main basis for allocating growth outside of Christchurch City's urban area. Furthermore, the hierarchical structure and function of settlements should be outlined in a sub-regional spatial plan, which of course we haven't got yet, but you do have one in your operative city plan, operative district plan and proposed district plan. The meaning well-functioning urban environment. Carrying on from my first point, I wish to reiterate my evidence at paragraph 36 on page 11 of my evidence. In my opinion, just excuse the spelling mistakes, I was done a bit of a hurry. In my opinion, the NPSUD sets out what constitutes a well-functioning urban environment at the sub-regional level, and this is to be given effect through what should be a sub-regional spatial plan or future development strategy. district and other local plans, then implement the strategy in a manner that meets local conditions, but also ensuring that their communities also form well-functioning environments in a local sense. This includes being responsive to local needs. So the third one I'm going to cover is the statutory relationship between the proposed Selwyn District Plan, Regional Policy Statement and NPSUD. I agree with the stance in the legal opinion that the directive approach of Objective 6.21, or more particularly 6.213 and Policy 6.31, does not give effect to the NPSUD, in my opinion. However, the remaining objectives and policies are, in my view, in line with the overall direction and intent of the NPSUD. So my evidence, I've suggested that paragraph 61, that some criteria could replace urban growth policy 13. And these are not that different to those suggested in the rezoning framework for greenfield areas. Application of policy 8. I refer to the head legal opinion relating to policy 8 and its application to a review. That's paragraphs 174 to 178. The opinion considers that policy 8 applies to district plan reviews. However, consideration of submissions on district plan reviews which do not meet the policy 8 significant additional development criteria should not be excluded as an overall in the overall responsive provisions of the as the overall responsive provisions of the NPS still apply. This is consistent with Mr. Baird's approach in his 4208 rezoning framework report as discussed below. So just to clarify that point, policy 8 does contain the proviso that it must be significant development capacity that's offered up. In a review, that's not always possible. So, but I still think that policy 8 does have some use, but I think it needs to look at the NPS as a whole and around its responsive provisions. An interpretation which limited the council to approving only submissions that offer up significant development capacity would place severe limits on how a council can meet any projected capacity deficit, as well as lead to decisions that, in my opinion, are clearly contrary to the purpose of the Act and potentially Section 31. As I said in my evidence on strategic directions at paragraph 41, the current sub-regional policy framework in Chapter 6 of the RPS is highly prescriptive, and this rigid approach has prevented several meritorious smaller land parcels in Christchurch City from being rezoned, even though they would have supported the policies of both the Christchurch District Plan and the Regional Policy Statement. So I'll be back here tomorrow with one of those examples on behalf of a submitter. She hasn't submitted on the urban growth policies and objectives. There'll be a statement to clarify just what the something around the officer's recommendation. It is a 1.5 hectare site which falls into that category. So do the proposed district plan objectives and policies provide a framework for assessing the merits of unanticipated development? Mr. Baird states that unanticipated development areas are not preferred as they do not support the council's strategic approach and infrastructure planning. These areas face a higher threshold but are not precluded in order to be rezoned. The objectives and policies provide a framework for assessing the merits of these applications. Mr. Baird's recommended amendments to the urban growth overview seem to support this, but the actual objectives and policies don't seem to. So, for example, Urban Growth Policy 3 is recommended to be retained, i.e. avoid rezoning in the Greater Christchurch area outside the urban growth overlay. Now, the urban growth overlay only applies to land identified in an approved development plan, defined as spatial plans that have been adopted by the council where urban growth areas have been identified. Development plans do not provide for an anticipated development outside MAP A, other than in the Selwyn Rural Residential Strategy, where you've got preferred rural residential. which is not consistent with the responsive, in my opinion, provisions of the NPS. Also, all of the Selwyn development plans are substantially out of date and could not have anticipated the current land supply situation of Selwyn district. So, for example, the Prebbleton structure, I think Prebbleton came up this morning from Ms. Hart. It does mean to say that the council's planning has been substandard. I think the council's planning has been great, but these plans need to be updated and perhaps, which I know is a resource intensive thing, but so the urban growth objectives and policies as recommended to be amended by Mr. Baird, which are minimal changes, do not appear to align with Mr. Baird's recommended framework for assessing rezoning submissions. So clarification would assist. This may be a timing issue regarding when the two reports were prepared, with the rezoning framework report benefiting from the Adderley Head legal advice. So the recommended zoning framework is, I don't want to read that out necessarily, but it's 9.2 and it sets out steps. And I think that sequential approach is quite appropriate, in fact, not too different to what I've got in my evidence. So when under 9.21 B and C, if they're outside the urban growth overlays, Mr. Baird is recommending a pathway for considering these proposals on their merits. And I think that provides the flexibility that we're looking for. The other need test applies to greenfield rezoning requests that is not within the urban growth overlay, nor meets the significant criteria that it could still be accepted if it fills some other need. This could be a zoning anomaly or fills a gap or links the provision to infrastructure. As these are bespoke request considerations will be up to the reporting officer's discretion to consider if it's appropriate in this context. Again, I think that's a very pragmatic and sensible approach. The new provision of urban growth P13 I've recommended, and Fiona for that matter, is essential to provide the objective and policy basis for assessment of the merits of rezoning submissions against the rezoning assessment framework recommended by Mr. Baird. So I've actually set out that. Now, I don't say that's perfect, but it provides a basis for a criteria-based approach ahead of the regional council, of course, but we're not going to see that until 2024, I understand. But I think as a methodology, this sort of approach is more responsive to a rigid urban limit and therefore is perhaps more in keeping with the urban development, national policy and urban development. So yes, that's in my evidence. I'm very happy to take questions on.
Thank you. See if we have questions that either of you could answer for us. Andrew.
Thank you, Mr. Chair. Thompson, thank you for your evidence. I do have a few questions. Some of them are around just points of clarification, because I think I wasn't entirely clear at times on what your position was. So I'm just looking at paragraph 39.
Yeah.
And you talk about important that decision making relating to where development capacity should be provided needs to consider the function of each township. So, in that regard, are you comfortable with paragraph 39?
39 of my evidence.
Yes, I think
counter
so.
argument is that oversupply creates.
Okay, hold on.
No, it's not 39.
Trice's Road rezoning, 13th of August. Have I got the right one?
Yeah, you do.
Yeah.
Oh, that's printed out. Oh, I've got mine downloaded. I got this off the internet, so decision making related to the yes, okay. I'm not sure where that is. Anyway,
I can
I understand
clarify
now.
it for you. You're just talking about relating to capacity being provided and consider the function of each township in relation to the township network. And I'm just interested in your views on should development capacity be provided or supply be provided on a township basis or a district basis or a Greater Christchurch basis? And can you accurately determine demand on a township basis?
So at the sub-regional level, I think the job of the regional council is to broadly allocate growth around the Christchurch City, Waimakere and Selwyn. How those areas distribute that growth, I think, is really up to them with the district development strategy. So Selwyn, for example, gets a bundle of growth. Now, obviously, Rolleston is its key centre. It's got others according to its hierarchy. So Selwyn will, I'm just supposing here, could allocate that growth according to what the future function of that area is. So you might have, West Melton may have a different role to Prebbleton. It might have a different role to Rolleston because of employment, location, public transport, connectivity, etc., etc. And it's up to the town centre or the township network to define those roles, and then growth gets allocated accordingly. And I think it's possible to do that. And again, you'd have a kind of a structure plan approach that Selwyn's already got, but needs to be updated.
Okay, so it's not simply just saying we think there's lots of demand here, so let's just overzone it or whatever. It's actually applying a lens on with a township basis.
I think you still need at least sufficient capacity to meet the anticipated demand. So those demands could be assumed, but those functions may change. I think Prebbleton, as I said previously, it's changed its role, and it will continue to change its role. So will need to be monitored over time. But so if you get a town like West Melton, same thing. The policy team will predict, will try and anticipate what sort of growth is going on in there, what's anticipated, what's the market telling them, and provide capacity accordingly. Okay. But I think there needs to be some sort of rationale and kind of making sure, say, that West Melton doesn't become a Rolleston, for example, unless it's planned.
Yeah, no, thank you for clarifying that. So the next point of clarification I was thinking, so paragraph 40, and I appreciate you may have a different version, but you refer to policy 3 and policy 4, and how the Trisus Road or TRRG sought to delete P3 and amend P4 to remove the distinction between towns within Greater Christchurch and those outside of it. And paragraph 41 talks about their change, and then you've got a statement in paragraph 42. And I'm just interested in your views on that proposal, because earlier in paragraph 29, you recommended differentiating between within and outside of Greater Christchurch in relation to the objectives. Yes, but yet are you saying that actually we shouldn't differentiate between those in relation to the policy, or you're not supporting this change?
No, I'm saying that differentiation takes place at policy 13.
Right. Okay. Not policy 3 or 4.
Well, policy 3, I think, could go. Policy 4 then is made as a general across the district type policy without distinguishing, and then policy 13 gives effect to the takes on the Greater Christchurch colour of the
So the differentiation is still there, but it's within policy 13. Thank you for clarifying that. So paragraph 46, and I guess paragraph 45 as well. You talk a little bit about, and 44, you talk about versatile soils and how policy 9 should be worded. And you work through that, assessing the reporting officer's recommendation, and you end up saying that you think it should be considered the finite nature of versatile soils. I guess I'm just interested in that, and your views on whether versatile soils is a section 7 matter or even a section 5 matter, and whether the word consider is actually sufficient or not.
Yeah, well, that's the recommendation of the officer in the strategic directions report, I think. And yes. That's a holding pattern while we sort out the national policy statement on highly reductive soils. And I guess the main point is that at the moment I've got have regard to, well, I think rather than recognise and provide for, which is, section 6, perhaps that may be too high a threshold. But in terms of versatile soils generally, and I was listening to one of the previous submitters, I think was a very good submission. Somewhere along the line, either a national policy statement needs to draw a line in the sand and say, how important are these soils? And whether it's class 1 and 2 or 3 as well, whatever. And what sort of constraint are they? Are they non-negotiable, or are they constraints which are sort of subject to other factors? The approach in fact, the current approach of the RPS within the Greater Christchurch, I think the RPS is quite silent on it. So versatile soils don't carry a lot of weight at all. The previous version of the RPS basically said that versatile soils are important and need to be protected unless there are compelling reasons to do so. Now, what that did was put some pretty severe constraints on the growth of Christchurch City in particular. And so that is the ongoing conflict around the extent to which versatile soils, in association with other constraints, inhibit other meritorious growth proposals. So if you overlay, I'll take Christchurch City, but I'm sure you can do it with Selwyn. The noise contours of the airport, the outstanding landscape values of the Port Hills, if you overlay the versatile soils, the hazard areas, ponding areas, and sea level rise, etc., you start running out of growth options. And you can do that through a sieve mapping technique. And so if you overlay these constraints and say, well, versatile soils are on a pedestal, then you end up, I think what Commissioner Alexander was saying, you end up with little holes where growth can go, which doesn't make sense in terms of urban form. So I think that is the issue here, that I think whatever policy comes out of versatile soils, it needs, I think, there needs to be an economic assessment of how versatile they are, because some versatile soils have been fragmented to the extent they're no longer versatile. They're probably in a situation where growth options are, viable growth options have been thwarted. And so there's a kind of an overall judgment, unless, as I say, that someone in, the national policy statement puts a firm line on a map saying you'll not touch these soils. That would be a courageous decision, actually, because I think it really put a huge constraint on urban growth and probably maybe conflict with national policy statement on urban development.
So, thank you. So, I mean, part of your recommendation and all your advice here and your evidence is that it's the context that you've given us, plus also the absence of national direction you think consider as appropriate, as opposed to simply saying, well, we think this is probably best planning and doing it this way until told otherwise.
Yeah, look, I think that should be considered. I mean, and then the right RMA language around that might be to have particular regard to or take into account, or if that national policy statement, which is forthcoming, then it might be a matter of national importance. You've got to recognise and provide for them.
Sure. Okay. Just almost there. Probably my last question here. So, paragraph 61 and clause 5, Roman numeral 5, or B.
Yeah.
Talks about with the proposed developments and or in clause 5 is in accordance with the National Policy Statement Urban Development 2020. And I guess that's quite broad in my mind. I'm just wondering, how would you determine whether your proposed development is in accordance with it? Do you mean it in the round or across all of the objectives and policies or particular components of it?
Yes, that's a fair point. I think it would probably in accordance with I think it need to be tightened up, perhaps with the responsive provisions of the National Policy Statement, something like that. Yeah, that would need to be perhaps wordsmithed a little bit to make it a bit more specific.
We have also received advice in regards to that similar question that if it's too narrow to just the Policy Act responsive provisions, then it actually that's then taken out of context with the rest of the document, and that's also unhelpful.
Yeah, yeah. So it is I mean, I think it's not dangerous, but I think it's not that appropriate to take policy A to put it on a pedestal without looking at, I think, first of all, what the overall intent of the policy statement is, and to understand that, you go back to the intent of the bill, the regulatory impact statement, and some of the guidance that's come out of the Ministry for the Environment to help kind of form a view on it.
Okay. Oh, thank you. No further questions.
Lindsay.
Thank you. Just one question for legal counsel first. It's more a matter of clarification. Your paragraph 13, where to about the middle of the paragraph on the second page, you say to submit that in the context of Selwyn District, an increase in minimum net densities has potential to prevent development in some areas. What do you mean by that?
I simply mean that moving from 12 households per hectare as notified to 15 would make some development in some areas untenable, and that my understanding from discussion with expert technical consultants is that development at that higher level would be incredibly difficult to achieve in some areas of the Selwyn district.
Okay, so it's a point I think one of the submitters made before, that some sites don't need stormwater retention, so that automatically might take out 20% of the site. So achieving that density might be difficult.
Yes.
Okay, all right, thank you. Try not to be repetitive with Commissioner Willis, but this policy 3.4, the splitting out of those in terms of direction of urban growth within the greater Christchurch area. I'm sorry, I'll be talking to Mr. Thompson now. And outside of those areas seems to be a fairly fundamental issue, because isn't that the way that the regional policy statement is set up, its direction on urban growth?
Yes, it has, but I've probably stuck my finger in the sand here and said that that particular map A, in my opinion, would struggle, or I'd say does not give effect to the NPS with the responsive provisions. And the reasons for that is that it can't respond. Map A cannot respond in a timely manner to even simple rezoning requests, and that's been proven through the LERP, through the Christchurch District Replacement Plan, and through our space. In each of those occasions, meritorious proposals of a relatively small nature had to be turned down because they weren't giving effect to Map A. And I think that is this flies in the face of what this is a national policy statement is about.
But Map A is very recent as well. Were you here for the Environment Canterbury evidence?
Map A came out in 2007 with the
Map A as we know it, which is now included in the regional policy statement.
Yeah. Well, there have been two changes to Map A. One that I'm aware of. There may be others in Waimakariri area and Selwyn I'm not aware of. The first was. Sorry, yeah.
Sorry, I was just going to say, we can just focus on Map A, which went through the recent SPP process. I'm sorry, I wouldn't call it deficient, but I'm a bit geographically challenged, and certainly in terms of some of the murky history there has been in the Canterbury region. But we were told by the regional council that the SPP process, which put Plan Change 1 into place, which ran parallel and was delayed so it could take into account the NPSUD, does comply with the NPSUD, or does give effect to the NPSUD. And you take a contrary view to that?
Well, I was actually on the, I actually had something to do with Map A and Change 1. Change 1 was promoted in response to the 2016 Urban Development the National Policy Statement of Urban Development Capacity. That's so right. The assumptions that went into Change 1 were based on the 2018 housing capacity assessments. Now, it was assessed at that time that the infilling of the Rolleston and Rangiora rural areas that were not zoned as greenfield priority areas, but were still inside the projected infrastructure boundary, would suffice in meeting the projected demand for housing. So that's why so the plan change 1 was limited to those future development areas, because all those areas, both the Rangiora, I think there might have been one in Kaipoi, but let's say Waimakariri and Rolleston, were seen as sufficient, and they were, planned because they're inside of the PIB, projected infrastructure boundary. Now, what seems to have happened is that since that time, the housing capacity assessments have been reviewed. They are now they have come up with different surpluses and shortfalls, particularly for Selwyn. And there's been evidence given in recent plan changes that the FDAs they'll need to be, they need to be actually zoned right now. And even then, the projected land supply is going to be, they probably won't meet the medium-term needs. So, yeah, that's basically the context.
Look, I understand that we've had quite a bit of evidence on this, both for and against it. But the Selwyn plan needs to give effect to both the RPS as well as the NPSUD. And we're tasked with the job, if you like, of providing a framework which can give effect to both documents. And so what I'm hearing from yourself is that plan change 1 is, even though it's there, it doesn't have as much importance as the NPSUD, particularly in terms of responsive planning provisions. Am I correct? That's your position?
Yeah, that would be my position, in that because it would take another plan change or a spatial plan or some other instrument to further expand, in this case, say Rolleston, then I think that the RPS isn't giving effect. I think Selwyn probably has to put more, this is a legal thing more than the planning thing, but it would need to give more weight to the NPS and responsive provisions. But the problem with that is that because Selwyn is part of a partnership, so it's obviously going to meet some resistance from its partners possibly in doing that. So Selwyn's in a rock and a hard place really. It probably needs to expand, but is up against some partnership protocols, I guess, that it would need to negotiate through. So that's
I understand that, but we're also told by the Regional Council that Policy 8 in itself can't be seen in isolation. It's nested under, I think it's Objective 6 of the NPSUD, where the responsive process in Policy 8 is only one of the matters which needs to be considered to achieve the overall objective of the NPSUD. So the NPSUD can't be seen in isolation. This is what we were being told. You've got to read the entire document all the way through and apply the entire document. So what the policy 8 does, well, it says unless it is only one part of achieving that overall objective, which also has things about infrastructure capacity and so forth. I actually haven't got it in front of me at the moment. So the position that you're taking is that the RPS is relevant, but it's not important because you've got these responsive planning provisions through Policy 8, which means you don't need to take into account the RPS.
I think you need to take into account the policies and objectives of the RPS apart from Objective 6.213 and Policy 631. Which is MAP A and the policies that actually implement MAP A. I think the rest of the RPS is quite relevant. And
but the passages you've quoted are the ones which are directly related to where urban growth in the Greater Christchurch area should occur.
Yes, but it's not the.
They have less weight, no weight than something which is in terms of the responsive planning provisions.
Well, because MAP-A is such as a rigid, provides a rigid line, then I think that there's a question mark over where it should be given much weight. Well, given weight, but I think it's less weight than what it would have done had not the NPS came along.
Okay, even though it was done more or less in parallel, and the PC1 process was delayed, so it could be, so the NPSUD could be taken into account. This is what we were being told.
Well,
the regional council.
Well, I mean, as I said before, MAP-A was the methodology for MAP-A was developed a long time back. The fact it's a recent plan change to MAP-A, I think is of some relevance, but it was actually promoted to give effect to a previous national policy statement. And as far as I know, it wasn't updated to reflect the more recent one.
Okay. Well, it certainly is a very live issue for us. Thank you, Mr. Thompson. The other matter which I was going to raise with you is about the planning purity of inserting just a document within a policy like NPSUD. If you comply with NPSUD, which is what your major suggested change to policy 13 is, whether it should reflect the intent rather than just to include the whole policy, the whole national policy statement.
Yes, well, I've already agreed with that.
Yeah, you have, and that was going to be my main other line of questioning to you, but that's been covered. So, thank you for that. Move on. Thank you, Chair.
Thank you, Malcolm.
Yeah, thank you. Thank you, Mr. Thompson. It would appear that you seem to think that we should be throwing MAP-A out with the bathwater and going straight into the NPSUD from your submissions. Find that quite interesting. And of course, you are also aware that Christchurch 2050 is in the planning process at the moment, which is also taken into account the housing assessments that have been made. I do agree with you in your 2018 housing assessment, and I do believe it was flawed, but I do think the model on the later housing assessment was a far more thorough assessment and holds more water. It is a thorny issue. It'll be interesting to see how the panel deals with this as we go through with the other submitters. Thank you for your input.
Thank you.
Nicole?
No questions, thanks.
Deborah?
Just for clarification, when you're talking about the Trisus Road rezoning group, within the loop, has any of that land been rezoned following the loop, or is it on the boundary, or was part of it just for future growth and others have added on that make it outside the future proofing growth area?
It's outside the projected infrastructure boundary in the loop and on MAP-A.
But it is identified as a future rural residential area in the Prebbleton strategy.
Yeah.
So just for clarification, it was under the loop identified for future rural residential?
No, under the Selwyn District Council rural residential strategy, it was identified and that followed the loop.
Okay, thank you.
Thank you, Mark.
No questions.
Thank you, Raymond.
Yes, I just have one. Where's it gone to?
We don't know.
Here it is. And this is just a general question. If we were able, if we were to enable urban growth in the way that you've requested, how can we be reassured that the significant income generated from rural land use activities will be maintained by urban growth given that the majority of the agricultural exports income for the entire country is derived from the Selwyn Hinds area? And if urban growth can maintain this income, how will it do so?
So it comes back to the criteria that I guess Selwyn, if it wants to pursue it, and eventually the region when they have to do it, what that criteria says about highly versatile soils and rural productivity. So so when the region produces or prepares its criteria under the national policy statement, which I think is going to be 2024, then following consultation or whatever process, it may well be that criteria states that high quality soils will be protected from urban development. I mean, that's still to be debated, I think. So it's not.
But that will conflict with the NPSUD, won't it?
Well, yes, potentially it can, and I think the government, or the Ministry for the Environment, will have to resolve that conflict. It'll be interesting to see what happens when the next draft of the National Policy Statement on highly productive soils comes out and how that conflict is resolved.
So to answer my questions, can urban growth not maintain the income that agricultural activities can?
Well, it depends on what form of income we're talking about. There is income and there is economic benefit from urban development. It's just a different form of economic benefit.
But not at the same level as agricultural income.
Well, the two different sources. So agriculture, one will derive export income potentially, and will grow food and income through the farm gate or whatever it is. Urban development will help people meet their social and economic, housing will deliver other benefits. And it's that tension which is problematic. And I agree with you, it is problematic. And it really depends on, just as I said before, what line is drawn in the sand when it comes to protecting good agricultural land. And I think there's a lot of factors need to be weighed up when defining what that line is and where it is.
Well, in actual fact, that's the dilemma that we as a panel are facing right now.
Yes, and I feel sorry for you because I don't think you have the guy, I think maybe one or two documents are missing in order to help make that decision.
Thank you. That's all from me.
Thank you, Vic.
Kia ora. No questions from me, thank you.
Gary?
Just one question, thanks, Mr. Thompson. In relation to the issue about district versus township, you've asked to insert the words each township into policy 3. And there's also a legal submission on that at paragraph 18. And the legal submission is, it's submitted that the term district must apply to townships within the district rather than the district as a whole. I'm just interested in the legal basis for that statement and other than the observation that demand is generated at the township level, is there any other legal basis for us to accept that?
Other than the function of a territorial authority under section 31, that's simply the basis for what I'm putting forward, which is in my subs. So nothing additional.
Okay. And Mr. Thompson, maybe you could clarify why you're advocating using the words township rather than district.
This is where minimum sufficient, paragraph 3.
Paragraph 25.
Oh, 25, I'll go for the written one.
It's probably elsewhere as well.
Yeah. With regards to policy 3, yeah, objective 3. Yes, because if it's left at Greater Christchurch level, I think it's a very high level of generality, and so you get the situation, I think, where with the latest housing capacity assessments, there is a lot of surplus capacity in Christchurch City in the intensification areas. So what the city may argue is that, well, we don't need any more land in Selwyn because we've got a whole lot of surplus capacity in Christchurch City. Let's use that up and keep Selwyn where it is. And there'll be perhaps some good planning reasons why you might want to consider that. But another option is for Selwyn's townships to grow as well in a managed way, and let the city's intensification carry on in a managed way, and you kind of get a slightly different urban growth strategy than, if you just you're getting at with just using the surplus into Christchurch as your backstop.
I think I understand that.
Yeah.
Thank you. Yeah. Thank you.
Yeah, I probably didn't make a very good job explaining it, but that's basically, yeah.
Well, thank you very much, Ms. Ford and Mr. Thompson. No further questions from me. Thank you.
Thank you.
Thank you.
The next submitter and last submitter for the day on my list is simply called combined presentation. That's right.
And I have with me representatives for two of the submitters. This is Mr. Robbie McRae, that's right, who's the landowner representative for the Daly Family Trust, and Robbie and Julie McRae. And then Mr. Phil Kennard, who is Director of Gulls Development and representing also 4 Stars Development. So Mr. Kennard has produced a statement in relation to the density issue, and he's happy to answer questions in relation to that. And Mr. McRae is really here just if any observation, and if you have any questions that he may be able to help with. So there's a few corrections that I'd just like to draw to your attention, and I apologise for them. First of all, on the cover page, we missed off West Melton 3, which is submission 160. And it is, that submitter is identified in the Appendix A, which is the maps of where these rezoning requests are. So essentially, all of these submitters are seeking different types of rezoning, some in Greater Christchurch, most in Greater Christchurch, a couple outside Greater Christchurch. And obviously the urban growth policy framework is relevant to all of them. And that's why we've done a combined set of evidence. And also just to explain, since writing this evidence, things have moved on in some cases. So Galena nominees and Hines Wattie Limited Pension Plan, submission 493, that has changed hands and is now also the subject of a private plan change request. Plan change 82 Brookside Road Developments Limited. And that was lodged just 2 or 3 weeks ago. And it's also covered a wider area than just the Galena land. It's actually 110 hectares. So it's on the website as Plan Change 82. Page 3, paragraph 7. Just this evidence needs to be read together with that should be Mr. Thompson's evidence for the Trices Road Rezoning Group. In table 1 in paragraph 19, that just lists the various submitters, their numbers, the land that they've asked to be rezoned. And just for 4 Stars and Galena, in terms of the final column, they've just got superimposed. So the one that says for 4 Stars zone rural in the plains should be the Galena one, and they're just the wrong way around. I apologise for that. So it's the 4 Stars and Gould, which is partly under the International Airport Noise Control. I think that's pretty much it. Okay. In Appendix D, just to clarify, I've listed the amendments to the urban growth chapter that the submitters are seeking. Just for completeness, we're also seeking that the McIlroy land, Daly Trust McIlroy land, and the Galena land also be covered with an urban growth overlay, but that's obviously a change to the planning maps. I just didn't want it to get missed. So Mr. Thompson and I have conferred in preparing our respective briefs of evidence, and you'll see there is some commonality in terms of the amended plan provisions that we requested, and so it's an agreed combined effort has gone into those amendments. And clearly I also conferred with Mr. Thompson in terms of his summary that he prepared today, and I agree wholeheartedly with it. So I haven't prepared any further summary evidence, but I thought it was just simplest if I just reiterate the key points that are covered in the evidence. So first of all, we're obviously seeking quite a few change to the urban growth objectives and policies. And principally, as explained by Mr. Thompson, this is to ensure that they give effect to the MPS urban development, in particular policy 13, urban growth policy 13, which is essential to enable Mr. Baird's rezoning framework assessment sort of methodology to be able to be applied, in my opinion. The second topic is the whole issue of density in the general residential zone. I note that the officer's recommendation is to increase that to 15 households per hectare. And in the evidence, I note that the Harrison Grierson report that has been relied on recommends 12 houses per hectare as an interim measure, because there's some structure planning work that needs to be done first to see to what extent 15 is practical. And in my evidence, I've talked about the situation. I mean, the major area where it applies at the moment is the Rolleston future development area. And that is being developed in not an ideal method, a bit piecemeal by way of a number of plan change proposals, just because there is so much demand there, and horses, in my opinion, is already bolted, and the Rolleston structure plan concept for the future development area is not really achievable anymore, which did have some high density areas. And obviously Mr. Kennard can talk further about this. And I still think this is relevant, even though we've got this new enabling housing supply legislation. The point I want to make there is that the housing supply legislation enables high density development. It doesn't require it, whereas what the plan is doing is requiring minimum density. So it's quite different. And so I think it's still totally relevant that we are looking at what is the appropriate density to be applying. In terms of rural residential, the amended policy is to enable this between 1 to 5 households per hectare, whereas at the moment it's 1 to 2 households per hectare, which is in line with the County Regional Policy Statement requirement. I say that
that is something that should be taken seriously looked at in this proposed plan, because we need to be applying in particular policy 1 of the MPS, which is a variety of homes, providing for a variety of homes that meet the needs in terms of type, price and location of different households. And there's a complete gap between the residential general zone. It'll be an even bigger gap if that goes up to 12 households per hectare. All you can have is that, or 1 to 2 houses per hectare, and there's nothing in between. And so people are, if they want something more than a standard residential section, they're forced to a 5,000 square metre section or a 4 hectare section. And certainly my discussions with clients is that the smaller ones are always the ones that sell first, they're more affordable, they require less maintenance. And so that's something that we will be returning to in rezoning submissions, but it does need to change the policy framework to enable those rezoning submissions to be considered on their merits. The third area is application of the urban growth overlay, which has already been discussed. As we know, the way it's defined, you have to be identified in a development plan approved by council. They are hugely out of date. This district plan should be forward-looking. It's looking at the district's housing needs, development needs over the next 10 to 15 years. That simply isn't happening if the only urban growth opportunity you provide for is based on development plans that are of a vintage of between 12 to 7 years old. Also, the urban growth overlay, all it's doing is a high-level preliminary assessment of the merits in principle of an area. They're still required a full RMA rezoning process to assess the detailed site-specific issues, traffic assessment, servicing. All those detailed level reports were not required for the urban growth overlay areas that are in the council's existing development plans, which were all prepared under the Local Government Act. So you can consider the merits of urban growth overlays without having to have all that detailed technical evidence. Okay, so then I've particularly looked at the merits of the Macrae site as an urban growth overlay area. I'm not going to talk about the Galena site because sort of events have overtaken that. It's now the subject of a private plan change. I discussed the merits of the Macrae site on page 26. And I guess the key points are that the urban growth overlay areas for rural residential are based on the council's rural residential strategy, which was produced in 2014. In my table in Appendix B, I go through each of those areas, and the situation is that there are absolutely no reasonably foreseeably available sites available for rural residential in the whole of the Selwyn district. And there are none provided for in Christchurch City, and a very limited supply, I have to say, in Waimak in their proposed plan. The reason why there are none left in Rolleston, there's none left in the whole of the greater Christchurch area of Selwyn. There's none left, obviously, in Prebbleton. It's because they're either rezoned already, subject to plan changes or submissions for full residential zoning. One at South Rolleston became a housing accord priority area for urban development. So essentially, the proposed plan, as notified, in practical sense, it makes no provision whatsoever for rural residential development. Reasonably anticipated available, which is what the MPS requires it to be. Infrastructure ready, reasonably available, and zoned for medium-term capacity. So at paragraph 108, there's a summary there of the reasons why the Macrae site fits the bill perfectly. It's all existing undersized rural lots, unable to support any form of economic farming use. It's on the west side of Shands Road, and Shands Road has been identified in the various documents as the sort of long-term growth boundary for full residential development. It's sandwiched, the area is sandwiched between the southern motorway and Shands Road. This has got an alternative access off Blake's Road, and so there is capacity for this to occur without having to have access onto Shands Road, which is an arterial. And essentially it meets the rural residential criteria that were in the 2004 rural residential strategy. There was one which talked about retaining a sort of an open space character between Prebbleton and Templeton, but that all predated the motorway, which has really changed the lie of the land entirely. And in any case, rural residential development is a lower density form of development, which is an appropriate buffer on the rural township edge. So, great site that, in my opinion, you should be considering on its merits. Finally, the other one that may be considered, and just to say, we will be producing some more detailed evidence as it so happens on the McRae site and the rezoning hearing. And the other one, which we may be asking for an urban growth overlay, is the Kevin and Bonnie Williams site, which is also in the vicinity of Prebbleton. So finally, I just wanted to make a few comments on some of the matters that have been raised in the course of the afternoon. First of all, the whole issue of versatile soils and highly productive land. The point to remember is that on township edge locations, most of the land is simply not highly productive, not capable of being highly productive. As you know, the minimum lot size in the rural zone is 4 hectares. 4 hectare parcels are lifestyle blocks. The other factor that negates against highly productive use of land on the urban boundary is reverse sensitivity issues. And certainly in the case of 4 Stars, which is the subject of a private plan change, there's a lot of detailed evidence on why this land is not incapable of being used for highly productive purposes. So I think that's really, really important to bear in mind when we're considering highly productive land does not equate with class 1 to 3 land. There are a lot of other factors that go into whether it actually is capable of being highly productive, a key one of them being lot size and the pattern of existing fragmentation. The comment about having the amendment to policy, urban growth policy 13, being in accordance with the national policy statement on urban development, whether that's a bit all too encompassing. Essentially, my reading of the proposed plan is that it didn't really take account of those responsive planning provisions that we've talked about weren't in the 2016 version of the NPS. And even without those, I think possibly Selwyn had some difficulty in taking on board the NPS directives that applied at that time, because that would have resulted in some conflict with the operative Canterbury Regional Policy Statement provisions. And as a member of the Greater Partnership, it had some obligations to give effect to the RPS, regardless of what the NPS said. So, yeah, I think that that's some of the background to why it doesn't essentially give effect to the NPS UD, in my opinion. And that provision, including areas that have been identified for rural residential activity and an adopted rural residential strategy, but are better suited to residential activity, is important because essentially all of the rural residential strategy areas that are remaining are now proposed for full urban, and have got lots of good reasons why that's a good thing. And in my view, I don't think it's good to cherry pick just parts of the National Policy Statement on Urban Development in this policy, because other important provisions, and you have to see it as a whole. There may be another way of doing it, but I wouldn't want it, for example, just be limited to the responsive provisions, because other really important provisions like ensuring a competitive housing and land market need to be reflected as well. Finally, the history to map A. I just want to put my tuppence worth in on that one. Map A, the areas on map A, and the future development areas. So the map A areas for urban growth were identified in 2007. That has not changed. What has happened is the LERP simply brought forward the timing of release of some of the land that was on map A. In the original version of the RPS, there were 3 stages in terms of timing, 10-year gaps, and a certain amount was to be delivered within the first 10 year, more within the next 10 year, and the sub areas were all identified. That was largely removed as a result of the earthquakes and the need to bring forward land supply faster. From memory, the only additional area that was added was Preston's in northeast Christchurch. Apart from that, there were no additional areas added since 2007, and no additional areas at Selwyn. So really, those map A locations predate the Canterbury earthquakes, predate so many things that have happened, and in my opinion, are so out of date that they really can't provide a basis for a sole basis for working out what's the appropriate growth strategy for the Selwyn District Plan Review. And in terms of the future development areas that were added in by way of change 1, they were, map A showed the greenfield priority areas, and then it showed a projected infrastructure boundary, which was the infrastructure planning that was done for future urban growth areas in 2007. So those projected infrastructure boundary areas also date back to 2007. So the fact that the only growth in Selwyn is at Rolleston dates back to decisions made on where the projected infrastructure boundary should go in 2007. The other comment I would like to make is that the Our Space plan, it's map 16, which identified the future development areas, was a sort of an interim provision and said that a full review of all this will be done in 2024, but it made the important point that those FDA areas were indicative only. That hasn't been reflected in change 1, where they've been assumed to be the future development areas. So I'm sorry for all that history, but it is quite important to understand how we've got to where we are now. And on that note, I'm happy to answer any questions.
Thank you very much. See if we have any questions for you. Do either of your witnesses wish to say anything at this stage?
If I can just speak to my submission for Kennard. Just a couple of points in support of Mark Brown from David Lovell earlier. By increasing densities to this proposed 15 lots per hectare, from a practical perspective, it doesn't often create good housing outcomes, or any beneficial for outcomes as far as affordable housing. And I mentioned in my submission here, I was involved in Stonebrook, in the marketing of Stonebrook, probably back 10 to 12 years ago, where we were enforced with about 16 high density lots, of which we tried every which way to market, even post-earthquake times with those. And similarly, because of the size of lot that was required, there was no option other than to go to 2-story. So when you look at a metre square rate today at single level of somewhere around 1,800 to 2,000 a square metre to build, if we reflect that back to what it was back in that 8 to 10 year sort of timeline, there was a 35 to 40% difference in cost to build from single level to go to 2 levels. And the benefit in cost of land, it actually made it more expensive than our like 350 to 450 medium density lots, where we could still retain we could retain single level with good outdoor space, depending on construction size, whether it was 120 to 170 square metre builds. So still keeping well under 30%, you know, to 40% of land area. So to put 15 lots per hectare as a per hectare as an arbitrary number doesn't actually give the outcomes that I think is desired in the intent. Also, just recently, we've just in the process of completing quite a mixed use site in Duns Crossing Road, where there's 16 hectares. And there with lot sizes predominantly between sort of 330 and 600 square metres, we've managed to achieve 13.25 lots. And within that, there's around 11 to 12% of those lots are sub 350. So to try to get the other 1.75 out of that would have created major conflict in design and good housing outcomes. And we need to remember in Canterbury and I look at planning from the end user side of it, that's where my experience has really been, and that is that you know, we all hunt for the sun. It's not like being in Auckland where we have an average temperature substantially higher than what we do here in Canterbury for 6 or 7 months of the year. When we get forced into 15 lots per hectare, when we start to try to design around that, it's very actually hard to give good housing outcomes from a sun aspect, just light, warmth, all of those sorts of things, good and healthy living. So that needs to be kept, you know, uppermost in our minds when we're actually looking at these arbitrary numbers, because it doesn't often give good housing outcomes. Thank you.
Do you wish to add anything?
Yeah, good afternoon. Yeah, Robbie McRaith. I guess just in reference to Fiona's comments, I mean, what's happening on the ground in our particular area? I mean, our lifestyle blocks are between 2 hectares and 4 hectares, and I guess for us, there's a mixture of landowners from sort of retired couples to working families, and no one's really using that land efficiently or productively, outside of just grazing animals and the odd cut of hay here and there. Outside of that, it's really just looking at the other options around, you know, what we can do with that land. I mean, with the fact there's a new roundabout on the corner of Blakes and Shands, going through the process of looking at all the technical reports and getting traffic analysis and so forth, but there's good access to get out into Blakes and then into, I guess, Shands Road into town. I guess happy to answer any questions around, you know, what land's been used for at the moment and what we can do with the future use of that land.
Great, thank you very much. Well, I'll see if we have any questions for many of you at this stage. Andrew.
Thanks, Mr. Chair. Sesson, I've got some questions around your evidence.
Yep.
So, I mean, some of it we've already covered with Mr. Thompson, so I'm not going to go over that again, since you've said it's, I guess you've worked jointly on some of these comments. Yeah. But specifically to yours, and I didn't pick it up, Mr. Thompson, if you did cover it. Paragraph 49, and there you've got some wording bolded and underlined in relation to amendments to Policy 1. Space to identify new urban growth areas supported by development plan or other relevant planning document or directive. And I'm interested to know that development plan is defined, but that other component that you suggested is not. What would constitute a relevant document or directive?
Okay, so that my purpose for adding that was to say that there was scope within the Hughes Development Submission to amend the urban growth policy, and so I'm just referring to the relief that the Hughes Development submission requested.
Right.
But in appendix D, I put the version that I think I've suggested. Sorry, so it's appendix D, the second page. So
Yep.
that's where I list all the amendments. So it's
Okay.
spatially identify new urban growth areas supported by development plan, or that have been approved through a plan change review plan review or other planning process or directive. And I guess I've kept in other planning process or directive because in this day and age, there are so many different possibilities. I mean, we've had the housing accords, we've had streamlined planning. So it's to encompass those. And some of those are supported by their own legislation. I mean, the housing accord wasn't under the RMA. So it's to be wide enough to sort of anticipate possible legislative change that we don't know what they are yet.
Okay. Thank you for clarifying that wording in your appendix D is a little bit tighter than what's in your paragraph 49 of your evidence. Just moving on. Paragraph 76, you talk about an amendment to policy 13, and it's to correct a zoning anomaly. How would someone know if there is a zoning anomaly? I mean, I'd imagine a lot of submitters would say my whole block's been left off by mistake somewhere.
Right.
So what are the criteria for what's an anomaly?
Yeah, well, I mean, Mr. Beard essentially has picked up on that word and his rezoning framework proposal. And I refer to that in Mr. Ivan's evidence on page 3, where he quotes from Mr. Beard's report. So one of the criteria are if it is outside the overlay and does not meet policy 8 criteria, whether it serves another need, and another need, he said if it fills some other need, it could be a zoning anomaly and fills a gap or links the provision of infrastructure. So I guess there are some, I guess you could add such as filling a gap in the urban form or linking to the provision of infrastructure to give a bit more direction. So in planning speak, I think we would, an anomaly is when you look at the surrounding urban zoning, this is clearly anomalous. Yeah, and there are some examples. I mean, we've got one in West Melton, which is a 10-hectare block, which is a tooth out of the urban zoning all around it. And another one at South Lincoln, which is juxtaposition between 2 existing urban boundaries on either side, Tufariki and Liffey Springs. So those are the kind of cases that I'm thinking of, and Ivan's dealing with one at Prebbleton.
So quite unusual or isolated examples usually.
Yeah.
Hopefully.
Yeah, I mean, you could add in, for example, filling a gap in urban form or linking to infrastructure.
Right. Okay. Thank you.
Or infill, maybe infill in urban form.
So in paragraph 87, and you comments through a number of paragraphs prior to paragraph 87 around the 15 households per hectare. And you just say, in my opinion, there are good planning reasons to retain 12 hectares, 12 households per hectare. And I'm just querying. So what are those reasons? I mean, you've cut and paste a section of the report in. But from your perspective, what are the reasons, the good planning reasons for retaining 12 households per hectare?
Well,
pending implementation of that report.
Yeah, well, I think the issue is that it's not straightforward going from 12 to 15 households per hectare, and largely the bigger the urban area you're dealing with, the easier it is generally to accommodate some higher density areas, even 20 households per hectare. But when you've got, I think what Harrison Grierson was saying is that it's dependent on some ground truthing to see whether it's possible, and that work simply hasn't been done. And all the reasons that Mr. Kennard has outlined as to that it can be contrary to achieving good planning outcomes, good housing outcomes, and certainly those dealing at the coalface of implementing urban subdivision land development on the ground have highlighted that it can be problematic. And it's generally it is problematic on smaller sites.
Yeah.
And yeah.
Yep, so smaller sites, I get that. And you said in here that I think you've suggested that it should be, you would have thought the council, when developing its overlay, would have, its responsibility would be to identify constraints and negotiate with the developer and agree a target yield. Paragraph 90.
Yeah. So
Yeah.
I don't think that's happened.
Right.
Seems to be, yeah, it's sort of, I mean, we're talking about South Rolleston here,
yeah,
and it's been developed by way of numerous private plan changes just because there's the market, the plan hasn't kept up with the demand.
Yeah. Yeah. So what you're suggesting is there are potentially a series of constraints there which make it just simply unrealistic to achieve 15 households, and the council is not aware of a lot of those because it hasn't done the work.
Yes.
Right.
I mean, it did a structure plan in 2007, which doesn't seem to have been adhered to in the way that development has proceeded. I'm not criticising the council for that. I think the council's done a great job at responding to housing need.
Yeah.
But there are some consequences.
And again, not wishing to cover the same questions I asked Mr. Thompson. So paragraph 111, just out of interest, you've talked about, I guess, how rural residential development is transitioning or being plan changes to go to full urban.
Mm.
So is the whole rural residential approach a bit of a failed approach? Is it not really actually meeting a market at all, given that some half of them are seeking to change?
Oh, it's not that it isn't meeting a market, but it's that for example, at Prebbleton, the situation there, for example, with the Trices Road rezoning Group 1 has changed because we now have a significant district park to the south of the site, which has changed its position sort of in the landscape. It's no longer a peri-urban site. So but I hear what you're saying, is that the level of growth that's occurred in Selwyn is probably more than anybody would have anticipated. So when you are looking at township edge locations, you do need to think about what might be future urban growth paths and take the long-term view. And the rural residential strategy did do that to a certain extent because 2 of the sites were required to be future-proofed, which means that they had to be designed so that they could be intensified to urban densities at a later date.
Right.
That was the case with the West Prebbleton one that Ms. Hart was talking about. We will be providing some urban design evidence in relation to the McRae site as to why it can be considered long-term suitable for rural residential because of its location. But the other point is that I think the rural residential strategy has failed to the extent that the densities, minimum density of an average of 5,000 is not, in my view, entirely appropriate as being the only option. I know why it's there, to create a rural residential character, but there is nothing in between that and full urban. So I think that's something that really needs to be thought about a bit more.
Okay.
And if you're doing sections between 1 to 3,000, they generally are far less likely to be intensified to general residential densities because of where the placement of the houses and the garden areas.
Sure.
Yeah.
Okay. Thank you. No further questions.
Thank you, Lindsay.
Thank you for Commissioner Willis for basically clearing out my question book. But I did have one. I've got one additional. So in relation to your comments on UGP 7 at your para 64 and 60, or it ends up being 64, then 66. Where you say UGP 7.4 is not necessary, and this relates to the strategic transport network because it's duplicated between that and policy 11.2.
Yeah.
Now, UGP 7 relates to the strategic transport network, and so it's discouraging the extension along a strategic transport network of any township boundaries, whereas my reading of PG 11.2, it's about the safe and efficient operation of important infrastructure. So it's one's transport related and the other one's related to transport and all the other sorts of infrastructure. One's for an accessibility reason and the other is for an infrastructure provision and protection reason. Do you have any comment on my take on that they are different?
Yeah, could you, sorry, what's your take on what UGP 7 is again? My apologies.
Okay, UGP 7 is about, or UGP 7.4 is about it shall deliver the following urban form outcomes. And in terms of the extension of any township boundaries along any strategic transport network, that is to be discouraged where there are more appropriate alternative locations. UGP 11 is about avoiding reverse sensitivity effects upon all forms of infrastructure.
Right. So I would say the purpose for discouraging extension of township boundaries along strategic transport networks presumably is to protect the safe, efficient and cost-effective operation of that strategic infrastructure. Or other broader reasons as well.
Oh, there could be other reasons why you want to avoid that in terms of being the shape of it. You're wanting to avoid ribbon development, for example. You're wanting to avoid the number of accesses onto a strategic transport network, which might affect its efficiency and so forth. Whereas the UGP 11 is about reverse sensitivity effects. By establishing there, you won't means that potentially a new residential occupier next door to a highway or next door to a transmission line or next door to any other form of infrastructure as it may be defined.
Yeah. No. Yeah, no, I can see. I mean, in terms of urban form and there are efficiencies in terms of avoiding multiple accesses, but you're saying that under UGP3 you only can consider that in the context of people complaining about the
well, it could be one of a number of things. I just don't see that there is on the face of it. The two policies do two different things. One's about reverse sensitivity and one's about urban form. Why would you delete something about extensions of the township network in relation to the strategic transport network? Because it is an important consideration in terms of urban form.
Yeah, no, I take on board your comment.
Okay, thank you. No further questions, Chair.
Thank you, Malcolm.
Yeah, thank you, Lindsay, for your line of questions. And hello, Zastor, it's good to see you at a hearing again. Thank you for your history of MAP A. It was very succinct and certainly took me back in time to many things we've appeared on at that time. I do have a little bit of an issue. You made a comment earlier about small lots of versatile land are no longer versatile. Surely the versatility of the soil does not change to do with the size of the lot.
No, correct. It's still versatile soil, but it's not capable of highly productive use because it's too small to be effectively for any effective production. It's just, yeah.
I think I might take issue with that if you have a look at some of the market gardening that's happening in the local area on small lots. It is highly productive, but I'm very concerned about our whakanuis in the area and the ability to be able to produce. And a lot of the land holdings that you are seeking to see an overlay over were put in place so that horticultural production could come from them. The people who are living in them have chosen not to. But my point is that it doesn't mean that they still could not be productive if the people using that land decided to use them for production rather than lifestyle reasons.
I think there's also probably a land, so that's getting outside my area of expertise, but probably the value of the land is such that it's not viable to buy them purely for productive market gardening purposes. I mean, I've just been doing some work in Christchurch City, and obviously the land is different there, but the comments made there in their section 32 report for their replacement district plan, which I had of course to go back to, that accepting that all the 4 hectare urban rural fringe land, which is similar flat versatile soil land, is largely being used for rural lifestyle purposes because it's 4 hectare blocks, not for rural production. So I mean, I guess the proof is in the pudding of what's happening on the ground.
I guess one could say that it depends on how we end up and what our economy is doing as to whether we can use that. So I think we can agree to disagree on that one. Fiona, thank you for coming along. You've given me a lot of food for thought, and I look forward to seeing you further on in the process.
Thank you.
Nicola?
No questions, thanks.
Deborah?
No, all mine have been asked around reverse sensitivity and urban form. Thanks.
Yeah, I've just got a question, and it was partially asked earlier around your paragraph 111 about rural residential. You seem to be presenting that there is need for much more new rural residential zoned land, and yet the uptake of the previously zoned land was virtually nil. And in fact, there's 2 significant lots on the west side of Duns Crossing Road were never developed. They were zoned, dairy grazed, and now there's an application to rezone them to a living zone. So I'm just trying to understand the perceived demand for large lot rural residential when history says it didn't happen.
Good question. And I guess in a way that is a reason why you actually need to over provide, in a sense, or provide more than the very minimum, because on the basis that a proportion of landowners may not implement the zoning straight away. And there is some history to that, those Duns Crossing Road blocks. They were former plantation board land, and the plantation board was disposing of its asset there and chose to go through a rural residential rezoning. I guess it added value to the land, but then the purchaser, in fact, was a farming interest, and the land was, as I understand, was fully irrigated, so it actually was able to be productively used. So it has to do with the change of ownership that went on at the time. So that was that one in particular. And in terms of the other ones, I don't think it's reflecting a lack of demand, and certainly the Pemberley would be a good example. Maybe Robbie, if you'd like to tell us a bit about Pemberley.
There's 2 properties sold, or sections, sorry, sold in Pemberley last year in July. One was 870,000, the other was 932,000. I know people went for those sections and missed out on those sections, and they're highly contested at the time.
So I don't think that it's that there's not demand, it's that those landowners have seen an opportunity for, because of the huge amount of growth, for full residential zoning, which has meant that the number that are available is less than originally. And some of them have been used once a housing accord area. So it's not that they're not got any, it's just that there's a higher or better use that's got in the way of achieving rural residential development. But the ones that have been developed have been very successful in terms of marketing. But certainly what I'm hearing from clients is that the demand is highest for the smaller ones, around the 2,500, 3,000, rather than the big ones.
Right, so that possibly is a part of the original problem with the original zonings, was they were larger, and you think that the smaller, sub-hectare lots are much more attractive.
I think what you want is a zoning that allows for a good mix to meet the range. I mean, I was also involved in the 110 hectare rural residential zone at South Lincoln, behind the university, and I understand that has sold really well.
Right. Okay, thank you. I guess we'll come back to this conversation in the future.
Thank you, Raymond.
No, thank you.
Vic?
No, thank you.
Great. Gary?
Thank you, Ms. Aston. You answered Mr. Commissioner Wallace's question about the 12 to 15 households per hectare, and relying on the evidence of your colleagues here, developers. You've said there are good planning reasons why the density shouldn't be increased, or the threshold.
Yeah.
Would you accept that, or would you consider there might be some good planning reasons why densities should be increased? Are there some planning reasons for doing that you accept?
Oh, absolutely. I mean,
Yeah,
it's always
okay.
a balance.
Yeah.
And I know that there's a sort of a feeling that higher density is better able to support public transport, but it just blunt across whole of a new development area probably isn't the best approach. Yeah.
Okay, so you've balanced that, and you've recommended the status quo, or staying with 12, not increasing it anywhere in any situations, or?
Well, it's still the minimum, and it certainly doesn't mean that you can't go be above that. And certainly the recent subdivisions in South Rolleston indicate that developers have been able to go to 13. And I'm aware of some clients that will want to have some high density development, are looking at some medium density housing forms. So it is changing, but I think a blanket requirement of 15 households everywhere is too blunt a measure.
But you haven't suggested an alternative. You've relied on the market dictating what it should be. Yeah.
Yes.
Okay, understand that. And just finally, the evidence you gave verbally about Map A was very interesting, and I'm new to the area. I haven't been here for a long time, but I would appreciate if we could get that written up.
Okay, written up. Yes.
Especially your experience and how that came about, and the dates and so forth. I think through the chair, that would be of use certainly to me in deliberations.
Yeah, happy to do that.
Thank you.
Just two matters. Firstly, your paragraph 21 of your evidence, you're asking, or you say that two submitters that you represent wish to amend the relief that they sought. I'm not sure that there's an ability to do that, to amend relief that's been contained in an original submission. So I'd give you the opportunity to present us with perhaps legal submissions supported by references to case law, perhaps, that enable an original submission to be altered in the way that you now see.
Yeah, well, I guess what I would say is that those submissions ask for full rezoning. So asking for an urban growth overlay, which identifies that as a potential future area for that form of zoning, is a lesser relief, and therefore is within scope. That's the way I've approached it.
Yeah, well, if you could just set that out, or maybe get some legal advice that supports that.
Yes.
And just in terms of Map A and the discussion about its history, is that relevant? I mean, we need to give effect to the RPS as it is. The words are clear on their face. We can't go behind those words or question the intent of the words. We just need to give effect to them.
Well, I think it gives you the context. I mean, there's a big debate going on to extent to which the Map A gives effect to the MPS, and the extent to which change 1 actually now gives effect to the MPS of where the appropriate growth areas should be, since it was originally formulated in 2007. So I think it's a weighting, helps with your weighting if you are of the view that you have to look at to what extent the NPS trumps the RPS. So that's the context in with which I hoped that it would be helpful to you.
All right, thanks very much for that. Well, thanks very much to all of you for coming in and answering our questions. It has been helpful. To the panel members on Zoom, can I please ask you to stay online for maybe just 2 minutes while after the room's cleared and we turn off